let me just, while they're coming out, put out another point. If the reasonableness and amount is not in contention, why is that not something maybe you're offering to stipulate, removing less of the need for any attorney to testify to? Something to consider if you don't have an answer right away.
We will look at that. We've not.
All right, so Jeremy, please. Yeah, Andrew the President.
All right, thank you. Please be seated, everyone. Members of the jury, welcome back. I hope everyone had a restful weekend and they've recovered from their Super Bowl Sunday. We are back ready to go and on track. And so unless there are any issues anyone needs to raise, we would be resuming the defense's cross-examination. So, Mr. Ouellette, I'll just remind you that you remain under oath as part of this case, all right?
Yes, Your Honor.
Okay, with that, over to the defense.
Thank you, Your Honor. Good morning, ladies and gentlemen. Good morning, Mr. Ouellette. I hope you had a
morning.
nice weekend.
I did.
Good.
Boring Super Bowl, but it was great otherwise.
It was boring, wasn't it? Well, we all might be suffering a little bit more today if it was more fun, was it?
Sure.
I'm going to backtrack just a little bit. I know when we had left off on Friday, we were kind of in the time period that I was calling after the October 2018 meeting. I want to go back to August for just a moment and talk a little bit more about some of the things that your documents reflect you were concerned about at the time. I want to take a look at Defense Exhibit 78. And you can see, Mr. Ouellette, this is email correspondence. If you look at kind of the pages between yourself and John Norton, your general contractor at J.M. Williams, correct?
Yes.
Okay. And this is dated August 16th of 2018, right?
It is.
And the email you had sent John, if you look at the second page, was from August 9th of 2018, right?
Yes.
Okay. And so this is the time period, again, the void had been discovered in July of 2018, right?
Correct.
And in August of 2018, we talked about on Friday, there was still correspondence going back and forth between J.M. Williams and the Conservancy about who was going to be doing the work to remove the slab, repair the void, right? That was all still going on at this time in August.
Yes.
Okay. And Your Honor, at this time, I'd like to enter Defense Exhibit 78.
Your Honor, we object to the blue portions of
Okay.
Exhibit 78 as hearsay, which are the responses from Mr. Norton, who's not here to testify. They're going to ask about Mr. Ouellette's questions that are raised in the bold text. You can have any objection, but the blue parts are hearsay.
I'm assuming the blue is slightly.
The lighter,
lighter color.
All right, any response? Ms.
Yeah, my
Mason?
response, Your Honor, is this is 8035 recorded recollection that this witness has adopted because she accepted these answers from Mr. Norton at the time as his recorded recollection as to the status of the project.
All right, overruled. 78 is submitted over objection.
I want to start by, if we could go ahead and pull that up, please. Thank you, Nicole. Glad to see our tech is working today. Okay. And if we could zoom in and scroll down to the second page, I really just want to focus on Mr. Ouellette's statements. So if we can zoom in, I know the blue is really hard to read. We're really going to be focusing on the black text here. Scroll up just a little bit for me, Nicole, please. Thank you. So you can see here, Mr. Ouellette, again, this is an email that you sent on August 9th to John Norton, your general contractor, correct?
It is.
And what you say here is, John, I want to keep things straight with regard to walkers and Soulshine. We just need to make sure we are crystal clear about things. I was surprised Tuesday when you have the date of construction for walkers now pushed into mid-November. I don't understand that delay as the sinkhole is not impacting walkers, but I imagine there are things that are and I'm just not following. Did I read that correctly?
You did.
Okay, so at that point on August 9th of 2018, you stated to your general contractor that your understanding was that the sinkhole was not impacting walkers, right?
Correct.
And if we go down to the next page, and again, the black text that we see here, those are your statements, right, Mr. Olet?
Those are my statements.
Okay, and then the lighter text was Mr. Norton responding to you, right?
Correct.
And if we look at the top of the page, can we zoom in a little bit more, please, Nicole? Make it a little bit bigger for the jury. Thank you. You say, I do know from our end, there appears to be delays that are simply construction delays, things you all are responsible for per the agreement. Because I have responsibilities not only to ourselves, but to a lender, I need to make sure those terms are followed to a T. Did I read that correctly?
Yes.
If we go down to 1, 2 paragraph below, you say there, to me, that means there is a delay unrelated to the double slab issue, unrelated to any delay caused by the sinkhole, and related to your sub. Did I read that correctly?
Yes.
And when I say sub, that's a subcontractor. Is that what you're shortening that for?
Yes, I believe
So
so.
at that point in time, you felt that there were some delays that were being caused in the Walker's construction related to a subcontractor that J.M. Williams had hired.
I was asking John about it. Yeah.
And if we go down to the next paragraph there. Yep. And you say there, I know we have issues with Soulshine. And just to the jury, I'm sure they remember, but that is where the void was found, right?
It was.
So you
Is-
say, I know we have issues with Soulshine, but I don't expect Walker's delays beyond the additional time needed to move the double slab. I was told that was 3 days for sawing above and beyond what it would have been expected. So I need to know why and who is responsible, please.
Correct.
And as we go further down, you kind of have a series of not that far.
Yeah.
Yeah, you have a series of questions here that are in black and John's kind of answering your questions. But what you say is specifically, what are the delays impacting scheduling at Walker's? What are the costs associated with that? Who is responsible? Do you see that?
Absolutely.
And so at that point in time in August, you were concerned about the delays in construction at Walker's, and you were asking your contractor who's responsible for that, right?
Yeah, I was managing the project. Yeah. So I just
Absolutely.
had to know, I'd have answers about what was happening. Sure.
And then let's take a look at the last part I really want to focus on is just right there at the top. What you remind Mr. Norton here is everything that impacts schedule or cost or bottom line at all needs to be documented and accounted for specifically. Even the time you spent recording these delays and accounting for them should be accounted for. That's what you asked of Mr. Norton, right?
Correct.
And I'll give you a moment to look through here, but you do not say anything to Mr. Norton in this email asking about construction at Walker's in August of 2018. You didn't ask him anything that has to do with safety or whether or not it was safe to continue construction at Walker's, correct?
This was regarding the construction schedule. So I talked to John almost every day about the project. So I don't know what.
And at that time in August 2018, you were concerned about delays and costs in Walker's, not about whether or not it was safe to continue. That's what you've expressed in this email, right?
Yeah, as I said before, we were told that we can continue building in Walkers so long as the sinkhole wasn't expanding. And I knew our team, they were excellent, was checking it daily to see if it grew or expanded or whatnot. So that was not part of this.
Right here. Walker's buildings. We can take that down. So still staying in this pre-October 2018 meeting time period, there was a video that we wanted to watch with you on Friday. This is Defense Exhibit 56. We're going to go ahead and tender that into evidence and would like to play it for the jury. I proposed it to you on Friday, Council. You didn't take a look at
Just
it.
the
Defense
exhibit.
Exhibit
He's asking for the
156.
156. All right.
It's a video taken by Mr. Olet that has her statement.
Hey there. Hi. I'm the tenant here. How's it going? I'm the tenant here. How's it going? Is it okay?
Yeah, you want to take a look? Yeah. Go ahead.
Yeah.
Just be careful.
Yeah, well, I'll
It's
be
kinda dangerous.
very careful, yeah. Oh my goodness. Do they know anything yet?
No, they are still checking in the line and see if it's leaking,
Yeah,
but they haven't said nothing so far.
Yeah.
We don't know.
yeah.
We're still waiting on the answer.
Whoa. Golly. Is that water down there or they were
Yeah,
pouring
they-
water in?
Yeah, they testing it with some liquid that they put in the water,
Mm-hmm.
and someone is in the line inside of the sewer line,
Uh-huh.
and they're checking if that water is going inside the line.
Okay, oh
Yeah.
yeah,
Yeah,
to see.
yeah. to see.
God,
Yeah, but it's about 15 or 16 foot deep.
deep,
Yeah.
yeah. So it goes down even further than this.
Yeah, about maybe 2 foot more from
Wowie.
that water right there.
Wow, y'all be careful. Woo,
Oh,
that's scary.
yeah.
We don't want that collapsing on anybody. Well, hopefully they'll figure it out because we can't work until we
Yeah, I understand that.
definitely don't want anyone falling in there.
Yeah.
Is it getting any bigger, do you know?
What do you mean bigger?
Like-
the hole?
Yeah, like
No,
out,
I
yeah.
don't think so.
Okay. Oh. My business partner is not here, so I told him, I said, I'll take a video.
Oh, yeah, no problem.
Yeah, thank you. My name is Catherine.
Catherine?
Yeah.
Oh, okay.
Yeah. So, well, thank
And we talked a little bit about this on Friday, but just to remind the jury, you did go by the site when the Ruby Collins or the construction contractors were there putting in that shoring and testing the hole, right?
Yes, I did.
Okay, and so that video that was taken, that was sometime in the September 25th, 26th time period, right?
Sometime around there.
Okay.
It was.
And even though you were there and you were being told about the testing that was being done, you did not ask Mr. Ballard, your geotech engineer, to come out and check out the hole and engage with those contractors when they were doing testing,
No, I
right?
wouldn't have done that. It was not my building. So, no. And I didn't engage the city. So,
Okay. So even though you were there and saw the hole, you did not ask any of your contractors to come out and kind of look over the shoulder or engage with the city workers at that time, right?
no, I would have had no reason to.
Okay, Your Honor, just for the record, keep myself clear here. We talked a little bit with Mr. Lett on Friday about the Cookerly invoices. Do you remember you engaged a PR firm called Cookerly?
Yes, I did.
Okay, and Your Honor, at this time, the defense would like to tender Defense Exhibit 179, 216, 223, 225, 226, 227, and 228.
All right, other than the other objections previously noted for the record, anything else from the plaintiff?
Not other than the objection raised earlier.
All right, admitted over objection.
And I had asked you some questions about Cookerly PR on Friday, and in the spirit of moving forward, I want to ask you many more, but you would agree with me that the invoices that we've received and that you had from Cookerly, they go from October of 2018 up until, till today, right?
Every time that something happened in this build, whether we get the notice to terminate or anytime that something happened, or in the initial part, we were getting, the media was contacting us because there rumors were out there. I think I told you all about we were underfunded and default and everything like that.
And
But
Mr.
every
Lett,
time a stage happened,
Mr. Lett, Your Honor, my question is very simple. Do you have invoices from October of 2018 all the way up to the present day? That's my question. Do you
I
have
do.
invoices?
And unlike Conservancy, who had Stripe reputation, we actually had to pay for ours. I'm just saying that.
Your Honor, I would move to strike that speculative testimony as to the witness claiming what the Conservancy did or did not pay for.
All right, Mr. Lett, on this particular question, I think that went outside the question and response. So to the extent for now, maybe it comes back up on redirect, but jury will disregard that part of the answer.
But where we left off on Friday, we were already into April of 2019. And Mr. Lett, you've said repeatedly, the jury's heard it, you wanted a geotechnical engineer to survey the site, correct?
Yes.
Handed you, Mr. Let, Defense Exhibit 193. And this is email correspondence that you had on Friday, March 1st of 2019 with folks at Piedmont Geotech, including Mike Ballard, who the jury has heard from, correct?
Correct.
And I want to focus on your statements at the beginning of this email, and I'm not going to enter this into evidence, counsel. I just want to read her statements. Okay. And one of the things you say here, you say, just to clarify, December 17th, email to Jennifer. Jennifer is someone who worked with Mike Ballard at Piedmont Geotech. Is that correct?
It is.
And spoke to her and previously to Mike that we need all invoices to lender for approval back then, as the project was going to be put on hold until we resolved a sinkhole issue on the property. Did I read that correctly?
Correct.
Further iterated that we needed to wait for project restart for additional lender payments. I, however, paid the prior ones myself to ensure they were taken care of in a timely manner. Did I read that correctly?
You did.
So you are telling the folks at Piedmont Geotech that you're waiting for the project to restart in order to get more lender funds. Is that fair?
Yes, the lender funds would restart.
Right.
when-
And that you yourself had personally paid the Piedmont Geotech invoices up to that point.
I did.
A really small one, so
Mhm.
let's see if we can get this up. Once I ask you a few questions. So Mr. Ouellette, I've handed you now, which is Defense Exhibit 1, and this is email correspondence back and forth between you and Mr. Ballard on April 5th of 2019. Do you see that?
I do.
At this time, Your Honor, I'd like to go ahead and enter this in evidence. For all of the statements, and Mr. Ballard's, again, are 8035, recorded recollection, also state of mind, because he's telling Mr. Ouellette what Piedmont Geotech can and cannot do.
All right, objection to defense
Exhibit 1, Your Honor.
1. I know I think we already, that's already been tendered, hasn't it? No, yeah, defense 1's already been tendered,
Okay.
according to my
Mr.
notes.
Ballard?
Mhm.
Yeah.
Oh, okay, then it's already in. Let's go ahead and pull it up. And I really want us to go down to the statements of Mr. Ballard on April 4th. So if we could scroll down. There you go. If we could zoom in just a little bit more, I know it's real small there. But what Mr. Ballard tells you on April 4th is, Catherine, here are my thoughts, correct?
Yes.
And he says, filling the hole with grout, or whatever the product was, will prevent any visual observation of what defect caused the problem. Had the hole not been filled, then it was possible to be specific about the problem, risk, and solution. That time has come and gone. Did I read that correctly?
You did.
Mr. Ballard goes on, we can conduct an investigation using ground penetrating radar, GPR. That device can look down into the ground a few feet, few is not more than 5 or 6, and see if there are any voids of size. If voids are detected, then borings can be drilled at that specific location. Don't know where that might lead. We would want you to hire someone to independently camera the storm sewer. Now or in the past, they are the most likely source of the past sinkhole. Did I read that correctly?
You did.
So at that point in April of 2019, your geotechnical engineer is telling you now or in the past, they, meaning the storm sewers, are the most likely source of the past sinkhole, right?
Yes.
And he goes on to say, if voids are not discovered by the GPR, all that can be said is that no voids were discovered and thus no defects were identified in our work. We will not be able to say anything like the building is safe. That's what Mr. Ballard told you in April of 2019, right?
Yeah, he was describing the first steps of what they could start to do. And then I think when he was in here, he described the remainder, and it would be kind of a step-by-step process to try to determine if the site was safe.
And the jury's heard Mr. Ballard's testimony, Mr. Ouellette. So my question was simply, he's saying, we will not be able to say anything like the building is safe. That's what he told you in April of 2019, correct?
Doing the GPR, yes. That's correct.
You can go ahead and put that to the side. Now, do you recall, it's in evidence, the proposal that Mr. Ballard made, but do you recall the total amount that the GPR was going to cost?
I'm not sure. I think it was around, and I may be totally wrong, but I think it was around 4,500 or 4,800, something like that.
Right on the money. So right around there, a little less than $5,000.
Mhm.
And you did not ask Mr. Ballard to come out and do that work, right?
No,
And you did not send Mr. Ballard's April 2019 proposal to do the ground penetrating radar. You didn't send that to the Conservancy.
no, it was mine. We were working through attorneys, so it was my understanding that that's how that was transmitted.
Okay. And we have a lot of email correspondence in this case, right, Mr. Olet?
We do.
And we have a lot of email correspondence that was attorneys are included, right?
I'm not, yes, I assume that there's a lot, but no, I don't know if it was all encompassing.
It's fair if you don't know all the documents in the case.
Yeah.
There's a lot. I'm not sure any of us know all of them. But at the end of the day, you are not aware of any email or evidence that this jury is going to see that will show that Mike Ballard's April 2019 proposal for ground penetrating radar was ever sent to the Conservancy prior to this litigation, correct?
No, but in my email here, it says that we are submitting the bids to the Conservancy. And so
Okay.
I assume that was done by council.
Would it be fair to say that after the city made the repair of the void, you still thought it was the Conservancy's responsibility to confirm that the space was safe as opposed to you, be our guest, getting your own geotechnical engineers, right?
Can you repeat that? I'm sorry.
Would it be fair to say that after the city made the repair of the void, you still thought it was the Conservancy's sole responsibility to get a geotechnical engineer and not the responsibility of be our guest, right?
Two parts. The city never repaired the sinkhole or investigated it. So that's one. And two, we would have been happy to work with the Conservancy and use our people. But when they got in that misrepresentation that the city made these repairs, they just stuck with it. And even on presentation of other solutions to get us back in, they just ignored us.
But you yourself never asked the Conservancy, hey, I have this geotech who can do this. Can we have him come out? You never did that.
We were working through council at that time.
Okay, so the answer to my question is correct. You never did that.
Well, I assume that, again, that these were sent to them and for a reason.
And I'm going to.
I don't know how to answer.
Your Honor.
I don't know how to answer that without, that's what my understanding was.
All
But
right,
I did not do
I
it
think the witness
myself.
having qualified as an assumption, I don't see a need to strike. Well, you may ask your next question.
So I'm just going to put no geotech. Investigation. IBOG. Talk about a new topic real quickly here, Mr. Olet. You're aware that the city has issued 2 building permits for restaurant spaces in the very same spaces as Walker's and Soulshine, right?
I do.
And in the last 7 years, the city has not taken any action on your safety concerns about the community center building, right?
There's litigation pending, and that's my understanding. Can't speak for the city at this point.
Okay, and I would just move to strike Your Honor, any talk about litigation pending by the city. That's complete speculation.
I don't think that was part of the question that was asked. I'm not seeing the. All right, I'll grant that request. Jury, we'll disregard that answer.
Means this case, right?
Right, I mean, when you say there's litigation, you mean this case?
Yes.
Okay.
Mhm.
There's no litigation by the city or against the city.
Correct.
And Willie's is open today in the same location where the void was.
They are.
Now, you were here when Ms. Miller, your accounting expert, testified to the claim that Be Our Guest is seeking for lost profit damages for 20 years, correct?
Yes.
Okay. And you would agree that the numbers that Ms. Miller based her whole analysis on were projections that were provided by you and Mr. Dooley, correct?
That's not all. She's an expert. She didn't just rely on those if that's the
Okay.
characterization.
But you put together the projections that she included in her analysis.
I did not.
You did not put those projections together?
No, my partner David Dooley did.
Okay, so it was just Mr. Dooley who put those together.
Yes.
Okay. Ultimately, you never opened either restaurant, correct?
Correct.
And you can't show this jury any invoices from Walkers.
You mean operational invoices
Correct.
or? Oh, correct.
You can't show any operational invoices from Soulshine.
Correct.
You never made a single dollar off of any sales of food or drinks at Walkers.
We did not have the opportunity to, no.
And you did not make a single dollar after food or sale of food or drinks at Soulshine, right?
Correct.
And at the end of the day, you agree that the expected profitability of Walkers and Soulshine, that fluctuated significantly in the different versions of the business proposals you and Mr. Dooley put together.
The business proposal changed between 2014 and 2016.
And if you could go to your deposition, man, page 133, line 18, please. And what we have here is question. I'll represent to you that I've only seen one version of these, but I accept what you're saying as well. Did the expected profitability of these spaces fluctuate significantly in the different versions of these? Answer, yes. Did I read that correctly?
Yes.
And now, Mr. Lett, you use social media, correct?
I do.
And it's 2025. You send text messages, correct?
Yes.
And certainly in the 6.5 years, 7 years that you were getting these restaurants up and running and this case has been undergoing, you and Mr. Dooley have exchanged text messages about this, correct?
I'm sure, but we usually talk, but I mean, I'm
And
sure.
you've texted with other folks about this case, including Mr. Norton, Mr. Ballard. You've sent text messages with your contractors over the years,
I'm
right?
sure that I have.
Okay. Did you text with your PR firm, Cookerly?
I really doubt that, but
Okay.
yeah.
But you've sent text messages to other third parties, whether that's friends or family members, about this litigation too, right?
Most likely.
And just to be clear, you didn't produce any of those text messages in this litigation.
I produced what I had. I don't save everything, so I don't have a running stream.
Now, Be Our Guest, the legal entity, does not own the Nook, correct?
No, did you want me to tell you the corporate structure? No.
I would
Okay.
just like an answer to my
Okay,
question. Be
yeah.
Our Guest does not own the Nook, right?
Correct.
Okay. And there are no contractual agreements between the Nook and Be Our Guest.
No.
There's no shared services agreements between Be Our Guest and GM Acquisitions, the parent company that owns the Nook, right?
No, there would have been with our different vendors, but
And you would agree at the end of the day, legally, Be Our Guest and GM Acquisitions are separate legal entities.
yes, they are.
And as you mentioned on direct, you're a lawyer. You understood that you
Mhm.
wanted to have separate legal entities. That way, if something were to happen at Be Our Guest,
Mhm.
that would be a separate liability from GM Acquisitions, right?
Yes. Mhm.
Now, Mr. Lett, you've been in the courtroom when Mr. Bloom, your attorney back in 2023, was being questioned about the press conference that was held in September. Do you recall those questions?
I recall.
Okay, and you were at that press conference?
I was at the press conference.
And that press conference was covered by Atlanta News First, right?
I don't know who was there, but there were a lot of news organizations there.
209. You do recall, though, Mr. Ouellette, that in preparing for that press conference, your PR firm, Cookerly, put together what they called a run of show, right?
I don't know.
I hand you this defense exhibit 209. Really small.
Yeah,
so-
I was gonna say.
I'll circle here. If you look, this is email exchange between yourself and folks at Cookerly on Tuesday, September 12th of 2023. Can you see that?
Got to take your word for this one.
I know, I'm barely being able to get through it too. But if you look down, there's Be Our Guest press conference. Can you see that in the middle there?
Yes. I see.
Okay. And that is an email from someone named Amber, who's at Cookerly, right?
I can't. I see the middle part, but
Well, Your Honor, we would seek to move to admit this exhibit 209. Again, this is correspondence between Ms. Ouellette and her PR firm as to the game plan for the press conference.
Your Honor, We're going to object to it on various reasons. First is the hearsay, to the extent you're going to move to admit statements from Crookerly, who's not here testifying. Also, frankly, can't read the documents. I'm unable to prepare an objection without even being able to see the contents.
All right, these are documents are part of the omnibus discovery package. You need a minute to pull them up.
These seem smaller than anything else. I've
Yeah,
seen.
and
Can you-
I have my readers on it. I can't see it.
You want to take a minute to pull them up and formulate the basis for that, other than hearsay? I understand.
And this was produced by BR Guest, so it's one of their documents, Your Honor.
As he's doing that, any response to the hearsay objection?
Similar to the email with John Norton, Your Honor, I think this goes to a recorded recollection of the Crookerly team as to the plan for that day's press conference, and she adopted that.
Your Honor, it's not a recorded recollection of the person who's on the witness stand. It's a
Right.
statement from an outside party.
I would agree with that, but to the extent it's going, as you mentioned before, it's non-hearsay showing either her subsequent actions or her mental state, then it would be admissible for its non-hearsay purpose.
Correct.
But if you have some other authentication concerns or some other things, I'll give you a minute here to take a look.
I could just take 1 second, Your Honor.
Sure.
Your Honor, when you approach,
Sure.
we did hearsay. True. Bullet points, written by person.
That's absolutely.
I'll shoot there. No, you're right. It's okay.
All right, so defense 209 is admitted over objection, and I'll offer the following guidance to the jury. Members of the jury, any statements within this email that are not those of Mr. Lett are not offered that they are true on their face. They're rather here for you to consider how Mr. Lett took those, what you did with them, and how those reflect on her mental state. So with that, you may proceed.
We could zoom in as much as we can here. I know this is very small. And scroll up. I just wanted to see, go up a little bit more. Up, up. All right, so you can see here, stop there. This is an email from someone named Andrew, who was at Cookerly, correct, Mr. Lett?
I don't know who Andrew is, but
Okay.
I'm assuming he's at Cookerly.
Okay. And he says, hi, everyone. Well, let me just pause here. This is September 11th, 2023, right?
Yes,
And the press conference that you and Mr. Bloom and Mr. Dooley held was on September 12th, right?
I believe so.
And Andrew says, hi, everyone. Attached and below, please find a run of show and suggested talking points for tomorrow's press conference, right?
Yes.
Okay. And if we scroll down, keep going down. And right there. So they first say here, this is directions for Simon. Introduce the backstory of the sinkhole, make a couple of grand overarching statements about why we're holding a press conference, right? That's what's said.
That's what it says. I did not write this.
Yes. This was something that was written by your PR firm to plan for the press conference, right?
That's what I assume.
Okay.
Mhm.
And then we go down, make it a simple story about business partners in good faith planning a $1 million build out of 2 restaurants. It was their dream, right? That's what it says.
Oh, that is true.
Okay, and then if you go down, it says elaborate on all aspects of the lie in quotations, right?
Correct.
Okay. And then in bolded, a few sentences down, it says, this will take a life of its own. Just remember, excessive details aren't your friend. This is a very simple lawsuit. Keep it that way. Do you see that?
I see that.
Okay. And again, this was the game plan that your PR firm came up with for the press conference that you and your attorney, Mr. Bloom, and Mr. Dooley had in September of 2023, right?
Yes.
Okay, let's go ahead and take that down. Now, you recall at the press conference that you and Mr. Dooley both made statements, right?
I talked just for a couple minutes. I don't know if I was on camera. I can't
You're right.
remember.
Yeah, you're right. You didn't say that much, but Mr. Bloom did, your lawyer, right?
Yes.
And Mr. Dooley did, right?
Yes.
Okay.
Mhm.
And I'd like to go ahead and play a clip of one of the statements Mr. Dooley made during this press conference. It's an admission of a party.
Is it exhibit number?
It's not an exhibit, Your Honor. This is just being used for purposes of cross.
Okay.
It's not an exhibit. It's a public statement he made that's online today. And I'm crossing a party with a statement of another person who's a party. Purposes of impeachment doesn't need to be disclosed. Or not purposes of impeachment, purposes of cross.
All right. It's not her statement, but I guess if you're trying to solicit her reaction to it, you can proceed on that.
We reserve the right to any other portions, right?
All right. Well, we'll have to take that as it comes.
Okay, let's play the first clip, please.
Is that the Piedmont Park Conservancy, led by Mark Banta and enabled by the board, has led a campaign of deception about what has happened in this space.
Okay. And so what Mr. Dooley just said there, right, was that there was a campaign of deception by the Conservancy, right?
Agreed.
Go to the next clip. Turn it up as loud as we can.
Under the cloak of night, this hole was filled in.
Okay. And Mr. Dooley.
Under the cloak of night.
All right, so Mr. Dooley is claiming that under the cloak of night, the hole was filled in, right?
He was mentioning the night work. Yes.
The next clip, please.
And it was a conscious, coordinated cover-up.
So Mr. Dooley is referring to this as a cover-up by the Conservancy, right?
Yes.
Do we have one more, Nicole? Let's play that last one.
It might work. Their defense, as Simon mentioned, is that the building hasn't fallen in yet. So therefore, what they did might work. Well, gruesome, but people slept fine at the Surfside condo on June 23rd, 2021. June 24th, massive tragedy, almost 200 people died. These things happen quickly.
Mr. Dooley is comparing the void that was found in Solshine to the collapse of an entire condo building where 200 people died, right? That's what he's saying, the
Yes.
Surfside condo collapse.
Yes. Did you want me to expand it? No.
I'm just asking,
Okay.
that's what he was
Oh,
saying.
yeah, that's what he said.
That was right before Music Midtown, right?
It was.
The same day you filed a motion to enjoin the use of the entire community center building to stop it from being used by anyone, right?
Yeah, a couple days after I saw the cracks. Yep.
Okay. Now, Mr. Lett, you have made many statements on Facebook about this case, have you not?
I'm sure I have.
And in fact, you posted 14 chapters just about a week and a half ago, right before the trial started, right?
I did.
Okay. And I want to ask you about some of those chapters. First, we're going to call Fence Exhibit 505.001-002.
Copies for this.
Oh, yeah. Thank you. And Mr. Roulette, we've redacted many of the statements, but you recognize this as a Facebook post that you made?
Yes, to my friends on Facebook.
Well, this post is public, right?
Two people in my friend group. Yeah. So yes, it's on my Facebook and
Well, I was able to pull it up. I'm not Facebook friends with you, so it's
Oh, I don't-
public, correct?
it's on my friends. Yeah. So I don't know.
And let's go ahead. I would like to seek to admit 505.001-002.
We object to 505. They've basically taken a Facebook page and redacted almost all of it except for the sentences that they haven't shown there. So it's taken completely out of context.
It's just her statements, Your Honor, which
All
are admissible. She's a
The
party.
statement is the full Facebook post, not the
No.
sentence that they isolated.
Okay, do you have a copy of the full post for me?
That was what was supposed to be exhibit.
All right. Let's, if you can show me a copy or you want to conditionally admit that, we can follow up on the remainder.
Well, Your Honor, I have about 5 pages from a series of 72 pages of posts that I would like to ask the witness about. These are her statements. They're not admissible by them because that would be hearsay. So I think we're entitled to question her about these. If we don't admit the documents, that's fine, but I want to be able to show the jury the statements at least.
I understand that you're confronting her with certain of her own statements. Their point is that there may be some necessary context missing, and to that extent, I think they would be allowed under the rules to provide that context. But I don't know whether that's necessary under the rule of completeness without seeing them. So I think you're going to need to show me, on the plaintiff's part, what is the context that's needed to and contemporaneously put things in context.
Yes, Your Honor.
And I don't need these told out front here. If you've got them handy, you can tell me. But for now, I think we just let the defense proceed until you've got, you can show me what those are.
Maintain our objection to their admission.
Okay, so just the admission of the statement, that would be overruled, objections noted for the
I
record.
also think it's prejudicial and confusing to show one sentence without showing this.
Okay, if there's a 403 objection, then that's noted and overruled as well. If you locate some context you have for me, then we can take that up, okay? All right, you may proceed.
All right, Your Honor, so we're proceeding with showing, but not admitting at this time?
No, I've ruled that the part that you do have is admitted, and I'll decide whether there's some more that needs to get admitted
Okay,
when the time comes.
so let's go ahead and put up 505. Okay, actually, Your Honor, just in the interest of time, I have 4 posts that we are going to seek to admit, so I'm going to go ahead and seek to admit all of those right now.
Your Honor, we maintain our objection to these. This has literally a line in the entire text is blocked out.
And again, if you've got a part that has been redacted that you think under the rule of completeness and fairness ought to be considered contemporaneously,
Right.
you bring it to my attention.
Posts from a week ago that
Can
were
we-
not on the
can we-
exhibit list.
Well,
Can we
okay,
I'm
pause?
sure we can
All right.
access the Facebook page and find full
Mhm.
posts.
so that's for you. All right, you let me know. You can proceed to counsel.
Thank you. So at this point, Your Honor, we're seeking to admit 505.001 to 002, 505.012, 505.018, and 505.064 to 066.
All right, those are admitted. We'll follow up on any rule of completeness issues if re-raised by plaintiff's counsel. You may proceed.
Thank you.
Now, Mr. Olet, you are aware these are Facebook posts that you made a week or two before this trial began, correct?
They would have been last week after the jury. Is
We can show the dates of the post, Mr. Olet, but these started being posted at end of January, correct?
I would have to look. I would have to look.
Well, whether it was after the jury was struck or not, these are posts that you made that reflect your opinions and thoughts about this case, right?
Absolutely, yes.
Okay. And so what we have pulled up now is what you've called Chapter 1.
Yes.
If we scroll down, what you say is in 2018, we started construction on 2 new restaurant spaces in the Piedmont Park Community Center, right?
Correct.
And if we go down, you say there, during saw cutting for plumbing, we found a massive sinkhole. That's what you said on Facebook, right?
Yes.
Okay, let's go to 505012. So now we are at what you've called Chapter 3.
Oh, yes.
That's the next one that I've handed you.
Mhm.
All right. Oh, go back up. Right there, Chapter 3. All right, so Chapter 3, you start Chapter 3. When the sinkhole appeared, everyone assumed a breach in the city's sewer system was to blame, correct?
Yes.
Okay. And if we keep going down, you then tell your Facebook followers the city backfilled the void with a flowable fill, right?
Yes.
Let's go look at Chapter 5, which is 505.018. Oh, okay. Just a little bit further down. Oh, yes. Chapter 5. Meanwhile, we filed multiple open records requests. That's what you said, right?
We have. Yes.
Now, before we look at your last post, Mr. Olet, which was part of what was called Chapter 14, and I think in even a comment on Facebook, you said this will make a great book. Do you remember putting that in a comment on Facebook?
I really do think it would. It's been really tremendously tragic. So
Okay. Before we go to that, I just want to make clear, on Friday, you told the jury that BR Guest is seeking a little under $1 million for your costs and expenses in the project, right?
for the direct cost of the project.
Correct.
So
You're also seeking around $4 million for 20 years worth of lost profits, right?
yes.
That's $5 million total, right?
Yes.
And I haven't tallied up all of your attorney's fees, but I think you, with what we've seen from the various lawyers, you want $1.3 million in attorney's fees.
Yes.
Okay, so a total of $6.3 million, right?
I'm not. Yes.
Okay, around that number, that's what you're going to be asking this jury to give be our guest.
That's correct.
Okay, now let's go down to 505.064, which is your final chapter that you posted, Chapter 14.
Oh. Yep.
Okay. Are you there? I want to be very clear. You say, what does this mean for all Atlanta, for Atlantans, right?
Yes.
And then you put these chapters reflect my personal opinion, right?
Yes.
Let's scroll down. And I want to keep it right there. You said just 2 weeks ago, this litigation has come at a high cost to the public and public safety, correct?
Yes.
You said when cameras weren't operational during the tragic murder of our friend Katie Janice in the park, they had money to fight us. That's what you said on Facebook.
That's true.
It's your contention that the Conservancy had money to defend itself in a lawsuit, and that somehow led to a murder in the park. That's what you're suggesting here, right?
That's not what that says.
Okay, it says what it says, right?
It says what it
murder in the
says.
park. Do you even know, Mr. Olet? Were you aware that the city of Atlanta is in charge of installing, maintaining, and handling the cameras that are in the park? Were you even aware of that?
That happened after Katie, my friend, was murdered. Yes.
And we'll
Not
have people with
before.
knowledge of that to testify.
Mhm.
You also say when they needed to raise $200,000 for a safe haven fund, they spent nearly that amount in litigation, right?
At that point.
And in your opinion, based on what you've said here, there will be a high cost to the public and to the public safety if the Conservancy is required to pay BR Guest $6.5 million, won't there be? In your opinion?
Well, I understand now it's a corporation and it's very differently managed. So I don't know how you want me to answer that.
Okay, but if,
This all could have been avoided.
Last question, counsel.
okay, if your contention is that There's been a murder in the park. Safety has been called into question because the money the Conservancy has spent to defend against your lawsuit. You would agree with me, there'll be a high cost to the public and public safety if the jury, if Be Our Guest is awarded $6.5 million from the Conservancy.
I think if the Conservancy continues to operate as it operates, there will be a high cost.
Thank you. No further questions, Your Honor. You can take that down.
Fine. And I don't know if we need to collect the exhibits as well. And Kelsey, let me know when you're ready for redirect here. You ready?
Mr. Gillett, good morning.
Good morning, John.
I want to start with an exhibit that you were shown a moment ago. It was earlier this morning. It was defendant 78. If we could put that back up on the screen, it was an email between you and Mike Ballard. Sorry, John Norton, actually.
I see that.
You familiar with this email?
I am.
And during this email, it sounds like you were asking Mr. Norton why there were delays on the project. Is that fair?
I was.
Okay. And I wanted to draw your attention to the second page of that email. Right after you say, I want to keep things straight with regard to Walkers and Soulshine. Do you see that?
I'm not sure where it is.
Second page, it's Bates number 798,
Okay.
exhibit,
Mhm.
defendants exhibit 78.
Yes. Okay.
And you say, we just need to make sure we're crystal clear about things. I was surprised Tuesday when you had the date of construction for Walkers now pushed into mid-November. I don't understand that delay as the sinkhole is not impacting Walkers, but I imagine things that are, and I'm just not following, right?
Correct.
And then he goes on and says it's complicated and then gives a long, looks like a 2-paragraph explanation, right?
He sure did.
And in the second paragraph there, he writes, specifically in our case, we encountered a double slab that wasn't indicated in the original documents, and it's considered a concealed condition. Is that what he wrote?
Yes.
As a result, dealing with this structural issue was not in our original schedule. You see
Correct.
that?
Yes.
And then in the paragraph below, he says, I say all of the above to say this. Our original schedule showed a duration of 9 days to remove the slab and install the plumbing. To date, we've been working on these 2 items for approximately 6 weeks due to the concealed structural issues.
Yes.
Do you understand what he's saying there when he talks about a concealed structural issue?
Yeah. Just things we didn't know about prior to construction. And we would have known about the double slab and those issues in particular if we had the plans, but this is not unusual in construction.
And the double slab is the same double slab that was over the sinkhole that's the subject of this litigation, right?
Correct.
Okay. And so the double slab, I assume, carried over into the Walker space?
It did. I don't know if it's through the whole building, but it was in Walkers and Soulshine.
Okay. He also mentions in the email that the double slab wasn't indicated in the original documents, and that's why he calls it a concealed condition, right?
Correct.
All right. Let me ask you to take a look at Defendant's Exhibit 39. And while I'm approaching with Exhibit 39,
Okay.
remind the jury again what documents you did receive about the building prior to taking a lease.
We received one little drawing, and then we were told there were no CAD drawings, which are the computer drawings of the building layout and everything like that. And so we were supposed to measure on site, and that's what our architects did.
And so let's take a look at Defendant's Exhibit 39. It's the document I just handed you.
Okay.
John?
Sorry.
I think
what did I say? 349
The long
in
weekend.
my other cup of coffee.
Mhm.
This is an email from Mark Banta to you on July 13th of 2018. Do you see that?
I do.
And so July 13th of 2018 was approximately a day or so after the sinkhole was discovered, right?
Yes.
And Mr. Banta writes to you, if we can put it up on the screen, you along with Mr. Norton.
Has this already been admitted, John?
I don't believe it has.
If there's no objection, if you want to admit it now.
We moved to admit 349.
All right, 349 is admitted.
And Mr. Banta writes to your team, right?
Yes,
And he says, it was good to see many of you earlier today. I presume that was at the site of the sinkhole.
yes,
We have located the 2001 site work civil drawings for the community center. I can make these available to the team on Monday. Is that right?
that's correct.
So after the sinkhole is discovered, Mr. Banta is telling you that he was able to locate the site work and civil drawings for the building and was going to be making them available on Monday.
Correct.
Okay. And so that was when Mr. Norton talked about the documents not disclosing the double slab and it being a concealed condition. Is that what he was referring to?
Yes.
You didn't have the drawings.
No, we did not.
Okay. Let's back up a little bit. We can take that off the screen for a minute. You were asked during your cross-examination on Friday about some of the issues that you were running into in preparing to open this space. Do you remember that?
I do.
And there were things like permitting.
Yes.
There was an issue about tree removal.
Yeah.
I think you said some trees had to be cut down in one place and had to be planted somewhere else. Do you remember that?
I do.
You obviously have experience running restaurants, and in fact, you opened and renovated the Nook before you opened that one, right?
Yes.
In your experience, are delays related to things like permitting and tree removal things that you typically would encounter in preparing to open a restaurant in the city of Atlanta?
Yeah, that's kind of normal in the city of Atlanta. When we were opening the Nook, as an example, the landlord said that there was this little grease trap that was of code, and it was just this little thing under our stove. But when we got into it, the city came out and basically we have like 2 car length grease traps now in our driveway. So that was a huge delay and a huge stall. We were the first place in all of Atlanta that ever had a permitted smokehouse for our smoke wings and pork and beef. I mean, so you never really know what you're going to come across. So it's very normal to have a delay and you build in for it. And then it's also very normal to have some cost overruns and you build in for it.
Did you experience cost overruns and delays in opening and renovating the building prior to opening the Nook?
Oh, yes, absolutely.
Okay. Were any of these issues that you thought you wouldn't be able to work out?
No.
Okay. I want to talk a little bit about that discussion you had with Mr. Banta on behalf of the Conservancy related to the rent abatement.
Yes.
And that was being discussed, I believe, in the spring of 2018, right?
Yes.
Prior to construction commencing.
Yes.
And it sounded like the way you were describing it, that the rent abatement issue was essentially asking for some relief whereby the commencement date would be delayed, right?
Correct.
How would you describe those conversations with Mr. Banta on the topic of a rent abatement and whether the Conservancy would be amenable to it?
Well, we had gotten to the point where we had agreed on rent abatement. So it was pushing back the rent commencement date because of the delays, but also we got rent commencement or rent abatement in like the 7th and 8th, 9th year of the lease agreement. So it was minimal compared to what we were putting in, but we just needed a little bit of help considering the scope of the project.
Let me ask you, approach with the document.
Mhm.
I handed you a copy of Defendant's Exhibit 341. This is an email. It was sent from Mark Banta on May 18th, 2018.
Mhm.
Do you see that?
I do.
I moved to tender 341.
No objection to the part that's from Mark, but I do object from the email from Catherine to Mark. That's hearsay.
Are you looking to admit the entirety?
Yes, Your Honor. I think it reflects her state of mind at the time.
All right, I don't have a copy of it.
Yes, Your Honor. I've got a copy.
All right, and so you're saying that the email from Ms. Drollet to Mr. Banta, the objection is to hearsay, and Mr. Moy, is there an exception or another purpose? All right, I think along those lines, objections noted for the record, and it'll be admitted as an entirety as to 341.
It's Defense Exhibit 341. This is an email exchange with Mr. Banta back in May of 2018, before the construction had started, right?
Correct.
You had a chance to look at it?
Yes.
And you're talking about the rent abatement issue, right?
Yes.
And so if you look at your email on the first page and it sort of carries over, it looks like you're summarizing there, if you can just scroll down, the terms of this rent abatement proposal. Is that fair?
That's fair.
And if you look down on the second page, Ms. Wilkerson, keep going. There's a proposal of a total minimum rent abatement of $64,000 in year one. Do you see that in bold?
Yes.
Okay. And then on the page after that, you mentioned also that there's a benefit to the Conservancy of the rent abatement, which is an additional investment by tenant of nearly $9,100 in building and Conservancy Activity Center improvements.
Yeah. 900,000
$900,000.
in the building.
What did you mean by that?
The building, it is a real old building and it had a lot of additional work. So the plumbing, the electrical, the HVAC, all those things would be items that would be added to the building's value as well.
Okay. And actually, earlier on Friday, you've shown another document with Mr. Banta where you referred to it as a mutually beneficial relationship.
Yeah.
What does that mean?
We were working together for something that would have been beautiful.
Okay. And mutually beneficial because, as we talked about last week, the Conservancy would be sharing in the revenues of the restaurant based upon what was received, right?
Absolutely.
And so obviously Mr. Banta and the Conservancy have an interest not only in getting the space up and running, but also in having the restaurant be a success because they're going to share in the profitability of it.
Yes.
Okay. Let me ask you to look at Mr. Banta's response to your proposal on the rent abatement. And he writes, "Good morning, all. Thanks for the information and proposal for adjustments to the lease terms. The Conservancy values our relationship and appreciates the efforts your team has put forth. All lease term concessions offered below are subject to verified construction expenditures exceeding 1.2 million. Do you see that?
Yes.
And that reflects the number that was ultimately budgeted for this project after you initially started with the $400,000 that we talked about last week, right?
Yes.
And then he's presented the proposal to the Finance Committee and he has two terms, rent checks to begin June of 2019. And then if the sales and triggering percentage rent status in years 6 and 7 and 8 and 15, each shall have 4 months of quarter rent abatement instead of 1/2 rent abatement. Do you see that?
I do.
And it sounds like what he's saying there is that there's going to be a delay in the rent commencement date. Is that right?
Yes.
And then also if you hit some sort of target sales numbers, there's going to be reductions in the amount that's going to be paid in rent on the back end of the lease. Is that fair?
Yes. Let's see.
Okay.
Yes. Yes.
All right.
So it was tied, the whole thing was tied to success for both of us.
Right. And you believe that he was in agreement with this proposal?
Yes.
In fact, he sent you a draft, didn't he?
Yes.
All right, let me ask you to look at Plaintiff's Exhibit 237.
Thank you.
I'd move to tender Plaintiff's Exhibit 237, which is an email from Mr. Banta to you dated June 22nd, 2018.
Your Honor.
Admitted.
Plaintiff's 237. Just very briefly, Mr. Banta is conveying to you and asking your lease expert to review the attached second amendment for the lease, right?
Correct.
Okay, and then let me ask you to look at Plaintiff's Exhibit 15, which I've also brought up.
Yes. Mhm.
You see Plaintiff's 15.
I do.
And is this a copy of the second amendment to the lease agreement?
It is.
I'd move to tender Plaintiff's 15.
No objection.
Admitted.
Okay. And you could scroll through it, Mr. Lett. I don't want to spend too much time on it, but it looks like this captures the terms that were agreed to by Mr. Banta and sent to you. whereby, if you scroll down, Ms. Wilkerson, there's a substantial completion date, right?
Yes,
If you flip the page, the obligation to pay rent in paragraph 3.2 is going to commence on March 1st, 2019, right?
correct.
There's an abatement under subsection D there.
Yes,
Keep going down, Ms. Wilkerson. And then if you just go to the last page, there's an asterisk, two asterisks that references, I'm sorry, the prior page, Ms. Wilkerson there. It references the breaking point for space A or space C, which I guess is the sales target that Mr. Banta was referring to earlier,
yes,
in which case the rent would be reduced on the back end as well.
correct.
Are rent abatements common in your experience?
It's very common.
Okay. I've only got a few minutes left, so I just want to follow up with a couple questions that were asked of you last week. You were asked earlier about this board that was shown to you about how frequently you asked about safety. And I think it was suggested that October 2nd is when you suddenly started raising issues of safety. Is that right?
That's what they seem to allege.
Yes, you look at plaintiff's 92. Do you have plaintiff's 92?
I do.
It's an email exchange between you and Mr. Banta on September 15th.
Yes,
I'd move to tender plaintiff's 92.
Okay, no objection to Mr. Banta's email, but I do object to Mr. Let's email.
All right. Understood. Objections preserved. Same reasons it's overruled.
Mr. Banta is writing to an email that you sent on September 15th, right?
he is.
And I just want to look at the first sentence of that email if I can.
Yes,
If you could go down, Ms. Wilkerson, to her email on the prior page. In the first sentence there, thank you for the Palmer report. Do you see that?
I do.
And then at the end, you say the issue as we see it is whether the building is safe to continue to perform construction operations. Did I read that right?
You did.
Okay. Let me ask you to look at plaintiff's exhibit 98. Plaintiff's 98 is an email from you to your team dated September 18th, 2018. Do you see that?
I do.
Okay, I'd move to tender plaintiff's 98.
Same objection as the previous round.
All right. And this one I will provide limiting instruction again, members of the jury. This is not for necessarily the truth of every assertion made inside this letter, but just to show the declarant, in this case, Mr. Lett's state of mind, and if any. All right. It's admitted over objection.
Thank you, Your Honor. Plaintiff's 98, we could put it up on the screen. You're writing to Chris, who's the architect on the project, right?
I am.
This is September 18th. The last email we looked at was September 15th, right? And I'm looking at the questions you ask of your team. We just need M2 to answer these two questions. Do they agree that work can continue in Walker's? And number two, is it safe from a life safety standpoint? Is that right?
Correct.
Okay. And in fact, you wrote a series of emails for the rest of September where you talked about safety, didn't you?
Yes.
And in fact, we looked at one on Friday.
Objection. There's an objection. Referencing a series of emails. Mr. Moy?
Do you recall sending any other emails where safety was mentioned?
Yes, and pretty much,
All right. That's the exact same objection, Mr. Moy. Unless you've got some specific email that we can go through, just generalized reference to statements is. would be
I'll move on.
All right.
Two questions. Do you recall seeing the email from Mr. Banta where he called it a life safety emergency?
I do.
Okay. Last question. Can you confirm that the monies that you're seeking in this case for damages and fees were paid either out of your pockets or Dave Dooley's pockets as the co-owners of the Nook and Be Our Guest?
Yes, everything was paid by us.
Nothing further at this time.
All right, Mr. Lay, you can step down. Any further witnesses or evidence on behalf of the plaintiff?
Nothing further from us, subject to the
parties conferring with the court, making sure everything's been admitted is supposed to have been admitted. But subject to that, nothing further from plaintiffs.
Plaintiff rests. All right, so members of the jury, now that the plaintiff has rested their case in chief, there's something I have to take up outside your presence. I'm hoping we can be back with you in about 10 minutes or so to resume any evidence the defense may want to present. So if you could please step into the back for this. Again, that form is right. Yeah, it's right, yeah. Yeah, we'll get some. Oh, that's not you. That's not on you. All right, let me start with motions on behalf of the plaintiff. What I would ask the parties is, at this point, I'll just signal that I wouldn't be inclined to grant any at this time. I'm likely to defer any ruling. And so if you could just make the arguments that you need to preserve all your grounds, if you're going into citing case law and explaining things like that, perhaps we can revisit that later. So with that, any motions on behalf of the plaintiff?
Yes, Your Honor. We would ask for a directive verdict in favor of the plaintiff at this point in time, Your Honor, and I will make it brief following the court's lead. In this case, the question is whether there's any material issue with all reasonable deductions pursuant to which a verdict be drawn in favor of the other party using the any evidence test, whether there's even slight evidence. In this case, we laid out at the outset something that remains undisputed at this point, which is that there never has been to this date a geotechnical engineering report indicating that the cause of the sinkhole has been investigated, identified, and thus properly remedied. And in fact, the only evidence in this case is of possible remedy relates to the City of Atlanta's repair. And we had the author of the City of Atlanta report who came in very specifically and said the sinkhole has not been repaired. We put in backfill to protect our asset, the sewer asset, but our backfill was not put in there to protect the building structure. And the report itself does not indicate the site is safe for building, and there is no engineering report. So that is undisputed in this case, Your Honor. There is no question of resulting damages. We have put forth that evidence, which the court has heard both in the form of payment evidence and in the form of invoice evidence, and including construction costs, permitting costs and fees, remaining litigation expense, non-attorney litigation expenses, loan financing, office labor, adding up to approximately $940,000. So on the breach, we think certainly a directive verdict is warranted. And I should add that the parties have, stipulated to the fact that there is a lease to which both parties are privy, and that under that lease, that the obligation is indeed on the landlord to keep the exterior walls of the building, the foundations of the roof in good and tenable repair. With respect to future lost profits, we understand that may be an arguable issue. We also understand that attorney's fees and whether there was bad faith is something that will be debated. But that being said, we think the evidence still is overwhelming on the point of bad faith in that Your Honor has heard evidence in the course of this case that there were withheld reports from our client, specifically Mr. Hagberg's November 15th, 2018 report, which actually agreed with our engineers that you needed a geotechnical engineer to undertake investigation of the sinkhole to identify the cause to properly remediate it. And that was actually withheld from our client. And not only that, the report ultimately given to our client was sanitized and backdated. That evidence has not been refuted, and is unambiguous. You also have heard, Your Honor, how the City of Atlanta, not only its report on its face doesn't show that the sinkhole has been remedied, but that was directly conveyed to Mr. Banta. But nevertheless, that the Conservancy went forward trying to insist that to our client it was repaired, as well as to multiple stakeholders. We think that evidence is overwhelming as well. And for those reasons, Your Honor, we would ask that directed verdict be granted in favor of our client on both the breach issue and the bad faith issue. Last but not least, I think I alluded to future lost profits. You've heard testimony from a
So
expert.
you're saying lost profits is a matter of law as well? Like lost profits are a matter of law as well, should be directed here? I think you just said
Yeah,
before
I'm
it's
sorry,
arguable.
I'm moving quickly, Your Honor. I do think lost profits, as indicated by the motions practice that was held on this upfront, and in fact, I think that is something that I think would clearly admit that it's still in dispute, Your Honor.
Okay.
Thank you.
All right. So in summary, the breach, the compensatory damages that flow from that, and the bad faith claim is your position should be decided as a matter of law, whereas the amount of lost profits and the amount of the attorney's fees are still a jury issue. Does that summarize it?
We would agree that, Your Honor. Yes.
Okay. All right. Thank you, sir.
Thank you.
I'll take that under advisement. Any motions on behalf of the defense?
Yes, Your Honor.
Your Honor, we have several motions. We are preparing briefs that will be filed with the court, likely this evening, if not by tomorrow. Our first motion is on breach. Your Honor, we just heard counsel move for a directed verdict going the other way on breach, but he didn't cite the lease. He said it's undisputed that there has not been a geotechnical investigation and a report that meets his client's subjective standard. That's not our lease requirement, Your Honor. The lease requirement is that the Conservancy maintain the foundation in a good and tenantable repair. We have heard from 3 experts on this issue. We have heard from Mr. Ouellette on the issue, and all we have heard is that it might be safe, it might not be safe. There might be a problem, there might not be a problem with the foundation. Your Honor, the plaintiff's burden here is to present evidence to a jury and to enable a jury to find by a preponderance of the evidence. 51% might be a problem, might not be a problem. They have presented no evidence that would allow a reasonable jury to get beyond 50% to the preponderance standard. So we believe we are entitled to a directed verdict on the issue of breach. Your Honor, with respect to damages, we believe this one is clear as a matter of law, that the Conservancy is entitled to a directed verdict. I'm a little shocked, to be honest, Your Honor. We have heard that Be Our Guest Investments, the plaintiff in this case, is a separate and distinct legal entity from GM Acquisitions, from the Nook, from Mr. Ouellette, and from Mr. Dooley. The only evidence of damages in this case is based upon, you just heard Mr. Ouellette testify. Everything here was paid by either her, Mr. Dooley, or by the Nook. And the case law is very clear, Your Honor. What needed to happen here to preserve any damages claim is there needed to be a capital call. Money needed to be injected into Be Our Guest Investments, LLC, and Be Our Guest needed to make payments. The evidence is undisputed. And in fact, it came out in plaintiff's case that Be Our Guest has simply not incurred damages. So I will acknowledge that the claim for lost profits is properly owned by Be Our Guest. And Be Our Guest can certainly present damages as to lost profits that Be Our Guest would have incurred. But again, Your Honor, this is clear, and the case law is clear. The plaintiff has admitted that the plaintiff has not suffered damages with respect to the $900,000 that was incurred in the construction process and with respect to the attorney's fees. So we're asking for a directed verdict on that point. Moving on, you knew I was going to come here. Lost profits. Your Honor, this has been a long saga. As you're well aware, it predates your involvement in the case. We had a summary judgment hearing on it way back, I believe, in 2022. Ended with Judge Glanville finding maybe some fact issues, but questioning way back 3 years ago whether this claim would properly survive a motion for directed verdict. It's been through the Court of Appeals. Of course, we argued to you there is a bright line rule in the state of Georgia. We have examined the case law. We have still yet to find a single reported case that does find what circumstance in which a brand new business with no record of profitability is able to present a claim for lost profits, much less a claim for lost profits for 20 years. Your Honor, Mrs. Miller.
I'm sorry, I didn't want to jump in here on this one, which is, let's say, set aside lost profits entirely. When a contract has renewal provisions, the initial terms say 10 years, and then there's a 10 on top of that. Why is it presumed, maybe that's a strong legal term, but how is the jury supposed to assess the likelihood that there would have been that renewal? Is that just something that's up to them? They just get to decide, thumbs up, thumbs down, this would have gone for another 10 years? Or is there anything in contract law, generally speaking, that we're just supposed to look to the first term, or we look to the entire term with all possible renewals at play?
Your Honor, I'm not aware of any case law on that point. I think it probably is not reached frequently because what courts have said for the past 100 years in this state until we got.
I'm saying, I'm kind of sidetracking, going down a tangent, setting lost profits to the side.
Sure.
Let's just say that wasn't what we were talking about, and it was just the renewal issue itself. Is there anything to be said for the fact that how renewals are treated when we're calculating appropriate measures of damages?
I'm not aware of anything, Your Honor, and I'm not aware. I didn't hear any testimony or evidence that the plaintiff would have, in fact, exercised its option to renew. I think this is part of why that in and of itself is speculative. Who knows what's going to happen in 10 and 15 years from now? Anything further on that point?
No. Keep going.
Okay.
Keep going.
So I was surprised, after, of course, the Court of Appeals came back and to my surprise, told us, no, there is no bright line rule. There presumably is some case in which some set of facts could be presented that would permit a new business with no track record of profitability and expenses to present a case for lost anticipated profits. Your Honor, at our last hearing on this issue, I speculated, who knows, and you, I think, mentioned the Court of Appeals didn't really give us a lot of help in terms of what that might look like. I speculated maybe some sort of concession contract down at the airport. You've got a captive audience, people are going to need food. A new business at the airport, something like that might make sense to me.
And Mr. McNary, I have to just apologize in advance for doing this because I've this entire discussion and the legal issues surrounding it, I have found very interesting. Let me just ask you this. Would it be safe to say that your position is that the plaintiffs have failed to show them to a reasonable degree of certainty and they should not be awarded as a matter of law in this case?
Yes, Your Honor.
Is there anything else you need right now to preserve it?
Well, I want to point out what Ms. Miller told us. Ms. Miller corrected Ms. Mason on cross-examination. Our assumption had been that Ms. Miller had gone in and had vetted these proposals that had been presented to her by Be Our Guest and had made certain adjustments to them based upon industry data, based upon performance of the Nook. You've heard that this is somehow based on the Nook. What Ms. Miller pointed out on her cross-examination, and again, to correct Ms. Mason's assumption of that, was no. I simply took their proposals, I put them into my model, I extrapolated them out 10, 15, and 20 years, and I put a discount on them to get back to $2,025. Your Honor, if that's how you meet the standard for lost anticipated profits of a new business, the Court of Appeals swung all the way. If that's the standard, any new business can take their pro forma that they gave to their bank and hire an accountant to extrapolate it out and discount it. The evidence that was presented is inadequate as a matter of law to show that these are non-speculative damages.
And I understand that your position here is, hey, that rubber stamp from Miller is an issue and gives it less weight than it should have. But isn't it, it's still going to come down to, is that initial proposal that was given to her, that has to be looked at of whether it's adequate, whether it meets the standard. And basically what I'm saying is that pass-through isn't necessarily going to defeat the analysis entirely.
I agree with that, Your Honor.
Yeah.
But what I want to point out is, despite what the Court of Appeals has said, is there is no bright line rule. There's reams of case law that says simply projections of profitability are inadequate as a matter of law. That's the law. That's the law we're asking you to apply and grant this directed verdict on lost profits.
All right. And it sounds like we've got briefs coming. And so when we can find the time, we can perhaps hear the counter argument and dive in a little bit more at length. What else do we have?
Your Honor, we also have a motion on failure to mitigate. This is part and parcel with the motion on lost profits. Your Honor, of course, our affirmative defense here is Be Our Guest was formed for the purpose of exploring restaurant opportunities. Be Our Guest, for whatever reason, after the Conservancy and the city told it that the void was fixed and repaired and the subsurface stabilized, Be Our Guest had every ability to locate other locations and operate and build out these restaurants. It still had $1 million, actually $1.2 million on its construction loan available. The only evidence that was offered, and I asked the question in opening statements, the only explanation of why they didn't do this is because instead they needed to spend millions of dollars, over $1 million, paying lawyers to pursue this claim for lost profits. Your Honor, there was no effort, much less a reasonable effort, to mitigate. The same is true with respect, again, there's nothing in this lease requiring the Conservancy or anybody else to prepare a certain type of engineering report after the city says in writing it's repaired the void. But the evidence has been undisputed that if that's something Be Our Guest needed to feel comfortable to meet its subjective standard, there's absolutely no reason it couldn't have done those testing. In fact, it was best situated with care, custody, and control of the site, with the slab removed. Mr. Ballard could have gone in there and done any of the things that he was proposing to Be Our Guest to do. Instead, Be Our Guest remained silent, never asked the Conservancy to do it, never asked for permission to do itself, never stuck a bore auger in the ground. Instead, it rested on this possibility. It's possible there are other voids, and comes to court and asks for 20 years of profits. So we believe a directed verdict on the affirmative defense of failure to mitigate is also warranted. Last one, Your Honor, 13-611. The plaintiff simply has not come close to offering sufficient evidence of bad faith in this claim. What we've heard and what was just argued is that we withheld these Palmer reports. You heard from Eric Hagberg. That's been a misconception from the get-go in this case. You heard Eric testify that these reports were not prepared for Be Our Guest. That's the misconception. These reports were prepared for the Conservancy's board of directors after they had seen press coverage alleging a danger at the community center building. The board members asked, hey, what are some things we could do if we wanted to further convince this plaintiff that she should get back to work? Those were presented to the board in an iterative fashion, and the board said, whoa, 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 we're not putting holes in the floor of this operating restaurant. We're not going to tell Willie's it can't operate and interfere with its business. Talk to us about some non-destructive things that can be done. So those things were removed. And as Your Honor has seen, I was involved in that. I still believe that that was a privileged and work product, protection. Your Honor disagreed. I respect that. But Your Honor, again, that's not evidence of bad faith. You saw evidence that Ms. Drolette asked that the first Palmer report be modified to include something. So there's simply not evidence of bad faith here. To the extent there is going to be any argument that there was bad faith in Mr. Banta going to the city and trying to convince the city to say that, maybe it was your asset that caused this. It's clear, Your Honor, Mr. Banta had in his mind, as did Mr. Smith, who you'll hear from, they were there when there was a positive dye test. So going back to the city and saying, hey, Mr. Lewis, maybe you could say that it was maybe your asset. They're not going to try and convince the city to say something false. They're trying to tell the city to tell the truth. So evidence of bad faith, there simply isn't any. In fact, we think the evidence is overwhelming in terms of who engaged in bad faith here. Rather than start that process with a $4,500 GPR study, you hire a PR firm, go on the news, and frankly, prosecute a vendetta against my client for the last 7 years. So, Your Honor, those are our motions. We'll have briefs filed, if not this evening, tomorrow.
All right, thank you, Mr. McLary. And I'll also take those under advisement as well. So moving forward, is the defense prepared? And we can take a minute if anyone needs to step out. Let's not make it too extended, but is the defense prepared to call their first witness?
We are, Your Honor.
All right, and who's that going to be? All right, and as to Mr. Banta, do we have some kind of time projections? Because I know that's another witness where there could be a lot of emails and things to go through. So I'm now tempted maybe we should impose clocks on him as well. So I put that out to the parties.
I'm going to try and move through it as quickly as possible, Your Honor. Frankly, the weekend was helpful towards that end. But I still project we're going to be an hour and a half, 2 hours on direct.
All right, and on the plaintiff side?
Hard to tell. Obviously, it depends on what comes out of his mouth. I would expect less than an hour, but I think we would be in favor of a clock given that one was imposed on Mr. Willett.
Right. And so they've put out hour and a half to 2 hours.
Your Honor, we object to be put on the clock. It is now Monday morning. I am working to get my case wrapped up with closings tomorrow.
Yeah.
And we feel we ought to be able to use our time as we deem necessary.
Well, I only say that because in case, if you're still confident, we think we can get to closings by tomorrow. That's all well and good, and that's fine. I worry. Okay. I'll just say tentatively, you said hour and a half to 2 hours. Once we get past that hour and a half mark, I'm going to be checking in with you.
Sure.
And so at the 2 hour mark is where I may start having to weigh in. Okay. All right. Then with that, again, I don't know if I'd like to avoid the mass exodus. So anyone who needs to step out briefly can, but let's call back the jury no later than maybe 11 o'clock.
Rachel, we got the Banta binders.
Yes, this one's yours.
Okay.
This one's mine. I just grabbed that one out. Then these are the rest.
That's witness connection or witness, those against.
Yeah, why don't we go ahead and get.
One for whoever's.
Oh, thanks so much. What a great way to start the day. Big old binder. Yeah, so this is, I'm assuming everything you guys are gonna use with it. This is what, I may have copies of this already.
I think it's everything we disclosed.
It's everything we
For Banta,
disclosed,
so
whether I
Right.
use it all or not, we'll see.
Yeah.
But
Just saves us from having to pull it out of the folders and hand you a copy.
Right.
And those were, what tab? Or I'll just hand those out. Okay. You'll be happy to know, John, the thickest document in here, I have like one question.
Okay. Yeah.
Are you taking this one on cross?
Yes, Your Honor. Yes, Your Honor. No, Your Honor.
All right, look at that, Mr. Van, go ahead and make it smile. Scan one, bring it to.
See if you can. Right here.
All rise for the jury, please.
All right. Thank you. Everyone can please be seated. Members of the jury, we're now ready to proceed if the defense has any evidence to introduce in support or defense of the claims here. So with that, defense may call their first witness.
The defense calls Mark Banta.
Please raise your right hand. Do you swear or affirm the testimony you shall give to the court today will be the truth? Be nothing but the truth and the whole truth.
Yes, I do.
Please state your full name for the record.
I just unmuted myself.
Mr. Banta, could you, are you?
Good morning. I'm Mark Banta, Mark, M-A-R-K, Banta, B-A-N-T-A.
Mr. Banta, please introduce yourself to the jury.
Good morning, barely. I'm Mark Banta, and I am the former president and CEO of the Piedmont Park Conservancy that you've heard a lot about this week.
How long were you in that role as president, CEO of the Conservancy?
Just a few months under 10 years.
And I understand you've retired recently.
I did. I retired in October of 2023.
Did you go to college?
I did go to college.
What institution did you attend?
I went to Berry College up in Rome, Georgia, graduated in 1982. I'm an ag major with an industrial science minor.
Sure. Could you give, I don't want to go into everything, Mr. Banta, but just could you give the jury a brief overview of your professional career?
Yeah, so it's kind of been a two-phase career. The first 14 years was spent with the University of Georgia. I was an extension specialist that worked in the green industry. So I worked in the metro Atlanta area, teaching people about various things, worked with golf courses, landscapers, greenhouses, that type of thing. And extension agents take the research from the university, the land-grant university, and then put that in a format where others can learn about the things they need to learn about.
So did you teach any classes as a professor?
I did. I reached the associate professor level, and one of my tasks was the master gardener coordinator, and I taught soils and plant nutrition, plant pathology, stuff no one else wanted to teach.
Mr. Banta, you described two phases. I think you said you were with the university for 14 years. Tell the jury about phase two.
So as the 1996 Olympic Games came onto the horizon, I was recruited to build and operate Centennial Olympic Park. So I was the guy in place when we tore out the Olympic Festival after the Olympic Games and then built the park that you see today.
And that's an interesting fact, Mr. Banta. Are you saying that what we know as Centennial Olympic Park actually wasn't there during the games?
No, it was an illusion of television. If anybody got to go to that, it was a giant green parking lot. Asphalt was painted green and it had a few planters, but we had the Swatch Pavilion and the Budweiser Pavilion, the AT&T stage, and a lot of what we call spring steel structures. But we tore all of that out to put in today's park.
Tell us a little bit about that construction project.
So it was an interesting and a long project, fairly sophisticated to take out all of that hard pavement and to make the beautiful park you see today with the water features and all the walking paths, the engraved bricks. But involving, a lot of different expertise, electric, plumbing, hardscape. Certainly there were soils issues that we dealt with there.
When did you leave Centennial Olympic Park?
As I was there, I was at Centennial Olympic Park for 16 years, and I was recruited to go build a very special project in Dallas, Texas. It's called Clyde Warden Park now, and it is what we call a deck park, which is a park over the freeway. It's the equivalent of building a park over the connector. And so it was very technically sophisticated, involved a lot of engineering, a lot of new technology that was done. And we built that project and opened it in 2012 and started operations.
When did you return to Atlanta?
Returned to Atlanta in 2013, came back home. This is my home. It's where I was raised. And of course, it's where all my family is too.
Did you return to Atlanta for any specific position?
I didn't land in Atlanta, but just a minute, and then there was an opportunity. I really thought I was going to retire at that point. I know I look too young to retire, sort of. But the opportunity was to go to Piedmont Park, which is kind of the crown jewel, the big daddy in Atlanta. And I'd certainly enjoyed my time at Centennial Olympic Park, but Piedmont Park was one that I couldn't decline. So I was hired there as their chief operating officer, knowing that they had a transition coming up with their CEO leaving. And so I was hired there.
And so how long was it before you were elevated from COO to CEO?
6 months.
Okay. And as the CEO at the Conservancy, what were your roles and responsibilities?
Basically everything, the old saying, the buck stops there. So we are a small but mighty organization as it relates to the impact that we have on the park. We help with maintenance. We do programming, children's education, and viral ventures. We do facility rentals to help earn the income to take care of the park. So we have a fairly sophisticated, about 28 staff members doing a number of different things, and all those fell up underneath me.
Mr. Banta, as you know, this jury has seen lots of emails, letters. It looks like this issue with the void that was discovered at the Sinkhole, and even preceding that, this tenant, Be Our Guest, you spent a lot of time dealing with these issues.
We did, yeah. And as has been testified to earlier, we also have another half to 3/4 of the building that's being used for a different purpose. The retail operations where the restaurants go is just a small portion of what the community center does and why it's important to us.
Was your job at the Conservancy limited to overseeing the community center?
No, it was not. It was, three-ring circus sometimes at that job. There's a lot of interface with the city of Atlanta and all the different things going on there. And we have neighbors all over the place too, with the park park pavilion there, that's next to us, the Atlanta Botanical Gardens. So we have neighbor relations as well.
During your time as CEO, did you report to a board?
I did. Yes, I do.
Tell the jury a little bit about that board.
So the board is, you've heard a little bit about them, and they are a large board, averaging 26 to 28 people. They're a professional board in that they come from a lot of different places and expertise, lawyers, PR expertise people, people that work for some of the big corporations like Home Depot and Southern Company. But they are a governance board, and I was the executive that reported to that board.
What do you mean a governance?
A governance board, there are two different types of boards, maybe more than that. There's operational boards, and then there's governance boards. The governance boards, like ours, set strategic direction, and they oversee mission, and they make sure that they make sure that we're fiscally responsible and using our resources appropriately.
Mr. Banta, upon your retirement, did you receive any awards or accolades associated with your service as CEO of the Conservancy?
I did. They honored me, and it was a surprise, but a very nice surprise. The last landmark lunch that we did, which is our big fundraiser for the Conservancy, I was the honoree at the landmark lunch, and then the city council, the president and the majority of the city council presented me with a proclamation at the luncheon.
And if you could turn to tab 2 in your binder.
I'm there.
And there are a couple awards. I'm really only interested in asking you about the second page. Is this the proclamation or a picture of the proclamation that you just mentioned?
It is.
Okay. Your Honor, this is Exhibit 521, and I'm seeking to admit only the second page, which is 521.002. We believe this is self-authenticating.
No, we object to it on hearsay grounds, relevance and 403 grounds.
All right, we'll start with relevance.
Do you want me to?
Yeah, let's approach on this. Thank you.
We're all seeking. Mr. Banta, no need to show this or publish this to the jury. I just have a couple questions. If you look at the third to last whereas clause. It says some of his most notable honors include bolstering the Conservancy's annual budget to over 4.5 million. Did I read that correctly?
Yes, that's correct.
Okay. And that 4.5 million annual budget, that's just to sort of run the staff of the Conservancy. That doesn't include all of the work in the park, right?
No, it's everything that we do.
Oh,
It's
okay.
all our work. The 4.5 is inclusive of the money that we raise through philanthropic donations and also then what we earn.
So that's the total budget that the Conservancy has to work with annually to serve its mission in the park.
That's correct.
Okay. And then it goes on, and it says Mark will be missed both professionally as a friend and has displayed the highest examples of character.
Your Honor, objection.
Ethics.
All right, there's an objection. So once there's an objection, we'll stop. And the objection is?
Objection
Just
is
state the grounds.
number 3 in relevance, similar to what we raised earlier. He was about to read the portion out of
All right. I would sustain that for the reasons raised at the bench conference.
Sure. Mr. Banta, who signed this proclamation?
It's signed by the entire city council, the president, and then all the council members.
And we've heard a couple of these names. Is it signed by a gentleman named Alex Wan?
It is.
And was Mr. Wan the council person for District 6 in which Piedmont Park sits?
He is. In fact, he was in place during most of this. Then Jennifer Ide was there for a couple, 3 years, and then Alex Wan's back in that position.
It's signed by someone named Amir Faruqi.
Your Honor, objection.
Grounds being?
Relevance 403.
All right. Unless there's a particular reason why we need to know who signed this document, which is not admissible, I would say that is sustained.
We'll move on. Mr. Banta, in your mind, what was notable to you about this City of Atlanta proclamation?
It was,
That's pretty broad. Let's tie that into something that's permissible. Sustained.
When you received this, you said you were surprised?
I was surprised and grateful.
Okay. Why were you grateful?
It's recognition, the city of Atlanta relationship is critical to the work that we do at Piedmont Park. And so to have city council recognize and use this specific language that opposing council is objecting to was a nice heartwarming acclamation of what I was able to do and accomplish navigating those waters.
Nice way to end your career.
It was.
Okay. Let's talk about the Conservancy. We've heard a lot about them, but I want to go back. What is the Conservancy?
The Conservancy was formed in '89 to help step in where the city wasn't able to do things for Piedmont Park back in those days. And I actually think it was kind of cool. There were free concerts and beer keg parties and, you know, abandoned tents out there. People were changing their oil on Oak Hill. You know, it's got a nice slope. And so a group of concerned neighbors said, we've got problems. We've got stuff going on in the bushes. We've got stuff going on that's tearing up the park. We want to form a Friends of group that then became the Piedmont Park Conservancy. So we've been around since 1989 and have a memorandum of understanding with the city that kind of lays out the joint responsibilities of each party.
And does the Conservancy serve at the pleasure of the city?
We do. I mean, it's codified in the memorandum of understanding, but we do. The city owns the park, permits the events in the park, but the Conservancy works as their private-public partner. So the relationship is mutually important for both of us.
And you just mentioned the city permits events in the park. We've heard a little bit about Music Midtown over the past week. Is that one of the city permitted events?
It is. The Conservancy doesn't permit any of the events, Dogwood, Music Midtown, none of those. All of those are issued a permit and all the funds go to the city, none of them to the Conservancy.
Does the Conservancy earn any money or generate any revenue from major events like Music Midtown?
We do not.
Okay. Do you report to anyone as the Conservancy's CEO, or I should say, did you?
Do I report to anyone besides the board? Is that what you're asking? Ask the question again, I'm sorry.
Did you report to anyone in your role as CEO of the Conservancy?
Absolutely, to the board of directors.
Okay. And was it your responsibility to keep the board of directors informed?
Yes, that's one of my primary roles as the president and CEO, is that liaison back to the board.
During your time as president and CEO, were board members able to approach you with any concerns they had?
Yes, they did, and they do. That was their job.
Want to back up a little bit, talk about your experience with construction projects. Let me just ask the question. I think it's obvious from what you've already testified to about Centennial Olympic Park and the park in Dallas, but have you been involved with a number of construction projects?
I have.
Okay. Did you work with engineers?
I have. All types.
Tell the jury about your experience working with engineers.
Well, the engineers are critical. Architects are important. They lay out the vision and the plans, the beautiful plans that you're going to try to realize the dream. And then the engineers have to translate those beautiful dreams into reality. So I have had a lot of experience working with various engineers. I have a lot of respect for the different disciplines of the engineers.
In your experience working with engineers, have you had occasion to review engineering reports?
Yes.
Okay. Do you know, Mr. Banta, when the community center was built?
The community center in its previous form, and I think it's been mentioned maybe by a couple of different names, the VFW, the Veterans of Foreign Wars, American Legion building, can all be used kind of interchangeably, but it's estimated to be over 100 years old. In our iteration where we purchased it, I think I looked at the purchase price, it was something like $40,000. So basically it was given to us and then we paid the small amount of money to cover whatever. But we got that in around 2000, 1999 or 2000. I don't know the exact date.
So the Conservancy purchased the community center from the American Legion or VFW organization for what sounds like a nominal price.
That's correct.
Okay, that was viewed as a contribution to a
Yes.
And has it undergone any renovations throughout the years?
It did. Very early in that process, then the Conservancy converted the use. It wanted to be able to do some programming, so there was a community room, and then the retail spaces that we've talked about on the front side of the building were part of that plan as well, and that was around 2001.
Let's jump forward a little bit to 2014. That's when you first became the CEO, correct?
That's correct.
Okay. When you started in that role, who occupied the space that is now Shake Shack?
So the space that's now Shake Shack, which we also call Space C, was occupied by Park, P-A-R-Q, Pizza, and that's who was in there.
And that's pronounced Park with a Q?
Yes.
I've been calling it Park Q for 6 years.
Yeah.
I didn't got to know that. Tell the jury a little more about Park.
Well, it was one of the first issues and challenges that I had to address when I got there. There was concern about from the owner. They came to me. His name is Caesar or Cesar. I always pronounced it Cesar, but he came and explained that they were having some challenges. My CFO, Chief Financial Officer, had let me know that they were in arrears on rent. And so I was made aware that we had a bit of a challenge there.
Okay. There was a lease in place between the Conservancy and Park?
There was a lease in place.
Okay. And was the lease at the end or the term in 2014?
I don't recall exactly, but my memory is that it was towards the end. And they had already been kind of telling the Conservancy before I got there that they were having some challenges, some interpersonal challenges with the team that had formed to start Park.
Were you asked to approve an early termination of the park lease?
Yes, they call it a walk away, but they wanted to leave.
And did they in fact leave sometime in 2014?
They did.
Okay. What was the condition of the, I'll just call it Space C when Park vacated in 2014?
It was a pretty big mess.
Did the Conservancy have to clean up that mess?
We did. We had to remove food, and they'd left alcohol behind, which is a little surprising, but the restaurant was just like you were there one day and then walked away and weren't there the next. So still food in the little things where you take it out to put on the pizza, it was still in those containers.
And was there an effort after that cleanup to find another tenant for Space C?
Yes.
Okay. If you could, Mr. Banta, turn to tab 4 in your binder. And this appears to start with an email from Penelope Cheroff to yourself and others at the Conservancy. Who is Penelope Cheroff?
Penelope Cheroff was a volunteer board member, and she's also a broker in the restaurant business. So that's what she does for a living.
Okay. And what was her role in connection with Space C in 2014?
She was attempting to look for a suitable tenant for Space C.
Okay. And was that done through a competitive process such that proposals were solicited?
Yes.
I'd move to tender into evidence Defendant's Exhibit 314.
Any
Respect to
objection?
314, Your Honor, as hearsay, as well as relevance and prejudice. In particular, it's hearsay. It's an email from Mr. Lett.
I'm looking at it. Do we have a non-hearsay purpose here, Mr. McLaren?
Well, first, I would say the email from Mr. Lett is not hearsay. It's the statement of a party opponent. That's certainly what I intend to focus on. I believe that Ms. Cheroff's email is relevant to notice of the receipt of a proposal to the landlord seeking a tenant.
All right, and so you are seeking to admit this in its entirety?
Yes, Your Honor.
Okay.
Your Honor, we would just have a problem with the top portion of the email where Ms. Cheroff makes statements about the restaurant.
Sure. No, I see those.
Her opinions.
And you're saying the purpose of that is just to show the receipt of a proposal?
Notice that a proposal had been received, and notice of the Conservancy's agent's evaluation, or at least preliminary evaluation of that proposal.
All right.
Also, the mental impression of Ms. Cheroff and her immediate reaction is expressed.
I would say the email from Mr. Lett is admissible as the party opponent. The upper part would not be for the truth of the matter asserted.
It's not for, and that's not the intent, Your Honor.
Okay. All right. So objections noted. 314 is admitted. And to the extent you need a limiting instruction or clarifying, if it's highlighted, let me know.
Like that, Your Honor.
All right. I'll see where the questions go.
Sure. If we could publish, please. And Mr. Banta, you're free to follow along in hard copy, analog, or if you want to use the screen, we can do it that way too. And I really don't have any questions for you about Ms. Cheroff's email, so let's go down. And I would like to start with Dear Debbie, Mark, and Penelope. This is an email from Mr. Olette dated April 10, 2014. Do you see that?
Yes.
Okay. And they are attaching a business proposal for 2 locations available in what they call the activity center.
Yes, it's the same thing as the community center, but they're calling it something different.
And do you recall receiving this proposal?
I do.
Okay. Let's go to the second page. Generally, Mr. Olette is describing the team and a little bit about the Nook. I want to go down towards the middle of the page. It says, "We are not a chain. We do not have several outlets throughout Atlanta." Do you see that?
I do.
Was that important to the Conservancy?
Yes, it was important.
Tell us why was that important?
There was a strong feeling by the board members and Ms. Cheroff specifically, who does a lot of restaurant work, that we wanted something that was park-centric. And we had a lot of interest in the space. When park, it's when you're as prominent as that area of Piedmont Park along Piedmont Avenue, there's people notice that there's a restaurant not open there. So there was a lot of interest. And we were getting requests from some of the chain restaurants, like, I don't know if it's okay to say names, but we just had chain restaurants like Marco's Pizza saying, hey, we would be great there. A, we didn't want another pizza restaurant, but B, we didn't want a Marco's.
And do you recall receiving this proposal from Mr. Ouellette back in 2014?
I do.
Okay. Can you describe generally the concepts that were being proposed for the spaces?
Yes, I think they were the two things that I think wound up being modified in the second proposal in a later iteration, but they were basically the idea of trying to do something park-centric. So they had already heard kind of the messaging, and they were attempting to put something forward that would be a fit for the space, not a chain restaurant.
Yeah. Did you understand the concepts being proposed back in 2014? Were they proposing concepts that were similar to the Nook?
No, that would have been a problem.
Why do you say that?
When we're selecting a restaurant, we don't want a chain. We don't want a repeat of something, particularly something that was right up the street. That creates a whole nother set of concerns and issues.
Was Be Our Guest successful with this proposal in 2014?
No, they weren't.
Who was chosen?
Well, to be clear, this is before the actual solicitation. Mr. Ouellette was being proactive, and she kept a close watch on that space. She was proactively sending this information as before we had put out a solicitation. Ultimately, there was a solicitation soon after this put out, and the gentlemen, Sean and Gilbert, that operated Hobnob were selected. They had a proposal, and we selected them.
And Be Our Guest was also considered as part of the proposal, notwithstanding the fact they put their proposal in before anyone asked for it. They were considered, right?
Yes, they were.
Okay. What was the proposal received from, you said Gilbert and who?
Gilbert and Sean Yeneman. It's easier to say the Hobnob guys. It wasn't going to be another Hobnob, though. It was going to be a different park-centric concept.
Was a lease formally entered into with the Hobnob guys?
It was entered into, and the negotiations were done through the letter of intent process, and then also we created a lease that we gave to their parties.
Why did we not see construction of the Hobnob guys concept at the community center?
As sometimes happens with these types of situations, it came down to one clause, which was the right for approval if someone wanted to transfer. So sometimes restaurateurs get a lease and they're not able to make their restaurant work. It just doesn't fly. And so they will oftentimes ask for a clause that allows them the right to transfer the rights to the space, to the lease, without going back through a bidding process. The Conservancy, who had a very good lease attorney, said it has to be the final approval by the Conservancy, and they did not want that. They wouldn't accept that term.
Why is that final approval right of, as I understand what you're saying, something doesn't work out for whatever reason, tenant might seek to have their obligations to pay rent, et cetera, transferred to someone else who tries something different. Why did the Conservancy need an approval right? Or said another way, why was it not okay to give the Hobnob guys that exclusive authority?
So it's just it's a lease kind of tenant that the Conservancy wanted to control its own destiny there. If you do allow the transfer of the space, then you don't know if you're going to get a concept that's going to be much more alcohol driven to do a bar there instead of a restaurant with food and alcohol. And so it's very important to us to have final approval rights. Didn't mean we wouldn't discuss it with whomever, it just we had to have final approval.
So that deal fell apart.
It did.
After that, were there further improvements made by the Conservancy to the community center building?
There were. In that interim time, when we were going to have to go back out and look again, we obtained a grant from one of the big local philanthropic organizations. And that particular entity had interest in us making improvements in the park and in some of our buildings that would increase our ability to have earned income. And we decided to use some of that grant to improve the spaces. So besides that first phase where we just kind of cleaned out the mess left behind Park Pizza, we did some fairly significant improvements, enlarging the demising walls so that space C was larger. That was one of the things that we'd heard from Park and from other people, was the square footage was a little small. So we enlarged that. We purchased air handling units, air conditioning for the roof. We redid the roof. We did some internal air handling and air conditioning equipment that we were going to pass along to the tenant.
After that process was completed, was this Conservancy again seeking tenants for spaces A and C?
Yeah, we were ready to get back out and see what the market would have.
Was there another solicitation for proposals?
No, we still had a lot of people expressing interest. And so even though I don't remember what the thing's called, but it's, you all have seen real estate listings like for like your home property. Commercial people have the same thing for restaurants. And so Ms. Cheroff would put that out at different times as a solicitation, and then people would respond to that. In this particular instance, there was, I believe that Ms. Cheroff reached out directly to BOG and said, hey, are you still interested in the space? And so we didn't go through the whole process of vetting. I couldn't eat another piece of pizza or eat another bad hamburger, which I'd done a lot of in the initial vetting process.
Why were you eating lots of pizza and hamburgers in the vetting process?
So in the vetting process, in the big, what I call the big solicitation, we wanted to give everybody their chance. And so we would literally go out to their location wherever they suggested, and then they would provide food to sample to say, these are kind of the things that we would propose for the restaurant.
Mr. Banta, turn to tab 6 in your binder, please.
I'm there.
And I'm not going to seek to admit this, but I do just have a couple questions. I see that this begins with an email to yourself and Ms. Cheroff from a Katie Braden at CBRE. Do you see that?
I do.
Okay. Do you have an understanding of who that email was sent on behalf of?
Let me be sure let me be sure I'm on the right spot. Say it again, because I said I was looking at what you were, but I'm not sure that I am.
Yeah, it's the second page, an email from Katie Braden saying, Mark, Penelope, it was great to meet you on Tuesday afternoon.
Yes, now I have it. Thank you.
And Ms. Braden, this is in, let's see, date. This is in April of 2017, correct?
Yes, that's correct.
And who is Ms. Braden representing, if you know?
So Ms. Braden was working with CBRE, which is one of the commercial brokers that's pretty prominent in Atlanta. And in this particular instance, she was looking for Shake Shack locations.
And then I see a response to this email from someone named Matt Bronfman to yourself and Ms. Sheeroff. Who is Matt Bronfman?
Matt Brofman is the guy that did Ponce City Market, and he was also on our board and one of my advisors.
Okay. His email signature here indicates he's the CEO of Jamestown LP.
That's correct. Jamestown LP does Ponce City Markets as well as other properties like that throughout the country.
Okay. And Mr. Bronfman is relaying to you, he says, I am happy to be the bad guy and advocate aggressively that we do Shake Shack. You see that?
I do.
So were there folks, board members, advisors, who were not fully on board with the failure to solicit proposals and the decision to just go with Be Our Guest based upon their 2014 proposal?
Yes, that's correct.
What was your personal view with respect to Be Our Guest versus Shake Shack or others who were potentially interested?
There's an old saying, you dance with the one you took to the dance. And so we were honoring, I wanted to honor the work that we done with Catherine and Dave, BOG. And so I advocated strongly in this particular exchange and in other exchanges with my board and with advisors to stick with BOG and to continue with them.
And were any concerns presented to you by board members, advisors, folks like Mr. Bronfman about your position that you should go with Be Our Guest as opposed to a larger national operator like Shake Shack?
Objection, Your Honor, to the extent he's asking for general concerns from undisclosed board members.
To the extent he can show his knowledge, it's overruled.
Yes, there were concerns voiced. They're somewhat illustrated in this email, but it's capitalization and sophistication. How much money does a person trying to start a restaurant have? Do they have the resources and do they have the sophistication? As you all probably know, restaurants fail at an extraordinarily high rate. And so the board and the advisors were interested in getting someone well capitalized and more sophisticated in operation.
Ultimately, your position to go with the smaller local Be Our Guest operation, ultimately, that was approved by the board, correct?
That is correct.
Okay. And did you eventually get a lease signed with Be Our Guest?
We did.
Okay. I don't want to go back through the lease with you, Mr. Banta. I think the jury's seen the lease, understands what's important in the lease. But I just want to ask you a couple questions. You've been in the courtroom. You've heard this lease described as an as-is lease. What does that mean?
As is, where is means that the operator, the landlord, is not got tenant improvement dollars. We're a nonprofit, and we're basically saying we're going to provide the building where it is as is, and all improvements and all needed work is, the responsibility of the person building out.
And that's because the Conservancy doesn't have either the resources or the personnel to manage the community center like a property manager or provide tenant improvement allowances, things like that.
Objection, Your Honor, leading.
Overruled.
That's correct. And this was not foreign to me when I built the park in Dallas, Clyde Warren Park. It was the exact same scenario. That's also a nonprofit. And the expectation was that the restaurateur provide all the improvements. There were no landlord improvement dollars.
Okay. And the lease to Be Our Guest, when it was originally signed, was limited to the parcels space A and space C, right?
That's correct.
And I think the jury's heard, but Space C is the larger space that was to be Walker's 1834,
That's correct.
and Space A was Solshine.
That's correct.
Okay. Was there any parcel or leasehold property that would entitle Be Our Guest to construct or locate a walk-in cooler outside of Space A or Space C?
No.
There's been some discussion, Mr. Banta, about the provision of plans to Be Our Guest. Section 2.1 of the lease, again, we don't need to look at it, but I'll quote it. It says landlord represents that it has delivered to tenant whatever drawings, plans, and specifications that landlord has in its possession for the building. My question to you, sir, is did the Conservancy comply with that obligation?
Objection to the extent it calls for a legal conclusion.
All right.
Did the Conservancy provide whatever drawings, plans, and specifications it had in its possession upon execution of the lease?
We did.
Okay, how do you know that?
I did it myself. I hand delivered the rolled plans. I think part of the confusion has come up, and I've heard it in earlier testimony about CAD drawings. CAD drawings are computer-aided design, and CAD drawings did not exist in 2000 when the original, or at least not for our project, when the original renovation happened. So when people say we want the CAD drawings, myself and or Ms. Cheroff would be saying there are no CAD drawings, but there were line drawings that showed the demise of the property. So what the different dimensions were and how big the space was going to be. Also a drawing that would show about the patio. But I personally delivered to AI3 what I call the rolled plans, which are as-builts. And I remember very clearly and distinctly that I delivered those to them.
The jury was shown an email message earlier today that indicated that you had found the civil plans after discovery of the sinkhole. How does that square with what you're telling us that you had previously provided the as-bills?
Right, without causing myself any PTSD, in all the projects that I built, one of the biggest things that people do is they keep every plan they've ever received. They keep every version. So as a construction project is designed, there are different iterations of the plans. And the final plan is what's called released for construction. And then after released for construction and they build it, then there's a set of plans called as-builts where they take what the architects intended and then they mark down what was actually done, because shockingly, it's not always the same. The set of plans that we found, which are the civil documents, would have been included in the rolled plans that I delivered to AI3. I verified that with Gay Construction, who did the work, and they said, we can tell you that yes, the double slab and the location of the rock sewer are both on those civil drawings, which we provided a second time. I had a great director of operation, Mark Nelson, who just was trying to be responsive. When the void was uncovered, he ran down to the shop and he found a copy of the civil drawing.
You just mentioned Gay Construction, and we're going to get to their role in this, but since you mentioned them, can you tell the jury how Gay Construction fits into this whole story?
Yes, they were the original contractor on the renovation done in 2001. And they also did the work to remediate the space, trying to correct the damage that was done when the tenant abandoned the project.
And that tenant you're referring to, that's Be Our Guest.
That's correct.
So Gay Construction was involved in the renovation back 2000, 2001, and then they did some work after Be Our Guest left the spaces.
That's correct.
Again, we'll come back to that. Would like to show you now what's behind tab 8 in your binder, Mr. Banda.
I'm there.
And What is this document, sir?
This is an email between Mr. Olet, copy David Dooley, and myself.
Brian, we move for the admission of defendants exhibit 6.
Objection to D6.
No objection, Your Honor.
Submitted.
Thank you. So if we could put this up. Want to start with Mr. Olet's email and orient us. This is an email dated January of 2018. How long after approximately, Mr. Banta, is this email after the lease was signed?
Oh, goodness. I don't recall months.
Okay. The jury will have the lease to look at, but if I tell you it was signed in June of 2017, does that sound about
It
right?
sounds about right.
Okay.
So what,
this is-
6 months?
Call this 6 months after the lease. And the message to you from Mr. Olet, she says, we have a few glitches in the matrix. And before that, she says, we are working on a timeline. Had you requested a timeline or what was going on here?
Yes, we'd requested a timeline. Again, back to the board asking questions and wanting updates. I meet with them on a monthly basis, either in the form of the full board or the executive committee. And the restaurant spaces were always a topic of conversation.
Okay. And Mr. Olet is telling you the bids came in very high, about twice what we expected. Do you recall being advised of that?
Yes,
Okay. Mr. Olet characterized the bids as obscenely high.
correct.
Okay. And she says AI3 doesn't understand it, and we're trying to wrap our brains around it. You mentioned AI3. Just remind the jury who that is.
AI3 is their architect and an architect I had used previously. They designed Googie Burger for me in Centennial Olympic Park. And they just do beautiful designs.
Were you surprised that the bids came in higher than the $400,000 that Be Our Guest was projecting or committing to in the lease?
No, the AI3 did a beautiful presentation to us. It's part of the design acceptance process. So we went for a presentation to the AI3 offices, and they did a beautiful PowerPoint. And as we left that office, I remember we just gotten outside the door, and I looked over at Ms. Cheroff and I said, that's a $1.2 million building.
So your response to this email, at this point in time, this is just an update to you. Mr. Olet does not appear to be asking for any concessions at this point, correct?
That's correct.
Okay. And you thank her for the details.
Correct.
Tell her you appreciate all she's doing.
Yes,
And you'll listen out for updates, right?
that's correct.
Let's look at tab 10, document behind tab 10.
I'm there.
And I don't believe this has been admitted. I could be wrong, but just correct in case I am. I move to admit, Your Honor, defendant's exhibit 18. I'm waffling a little because it may have been a plaintiff's exhibit.
All right, any objection to defendants 18?
No objection.
Submitted.
Right. Let's go ahead and publish that. While we're getting it up, Mr. Banta, this is an email from Mr. Olet to yourself with a blind copy that somehow we can see here to Mr. Dooley. You see that?
I do.
And it's dated April 19, 2018.
Correct.
And if we can just scroll down to the bottom, I just want to show that this is a lengthy email, fair to say?
Yes, it is.
Okay. And if we could go back to the top, I have just a couple questions about it.
Okay.
It starts with Mr. Olet saying, Mark, I was going to call you upon reading your email, but I was so upset I just couldn't do it. You see that?
I do.
And this seems to be about this walk-in cooler situation.
That's correct.
Was there a point in time during this project where Ms. Drolette was frustrated with you, or you understood her to be frustrated with you over this walk-in cooler issue?
Yes.
Tell the jury about that.
The cooler was something that we expected to go into the space, the retail space. And that's not what they wanted or understood. I remember Mr. Dooley saying that the reason we should have known that there was a cooler was because they had put it in a business proposal. But both Ms. Cheroff and myself had always said, your coolers have to go in your retail space. They came back to us and said, we have got to have an additional cooler. We can't move the product. They gave me the examples of what goes on at the Nook with a number of tater tots that they sell. They said, we'll just fill the cooler full of tater tots. And so we were trying to work with them to get the cooler located. And the reason that Mr. Ouellette is very upset with me is that I was working with the city of Atlanta, specifically a guy named Dan Calvert, to try to get the cooler placed. We don't own that lot. Bless you. We don't own that lot, and we were trying to get the city to agree to allow us to put the cooler in one of the parking places. And I was hitting a lot of brick walls. I meet with Ms. Fong, Commissioner Fong, on a monthly basis, and I had that on my agenda with her and was talking about her with that, but she instructed me to work with Dan Calvert. And this letter is in response that they got agreement with the city. They, being BOG, got agreement with the city to just move the cooler back onto the Conservancy property in the back door where we drop off the camp kids. And I had, at this point, I'd told Mr. Ouellette, that's not acceptable. We cannot do that.
Why was that not acceptable?
Two things. A, they had not reviewed that with us, and the second was safety of the children. You've got people trying to load and unload in trucks right there, trying to unload into a cooler right where the camp kids are.
And as I'm understanding, this is in a parking lot at the rear of the community center?
That's correct.
And you said there would be people loading and unloading. You mean people delivering food, commercial delivery trucks?
Right.
And you talked about safety. The kids are inside. Are you talking about carpool?
It's the carpool drop off at the back door. That's where they wanted to put the cooler.
And so what happened next with respect to this cooler issue?
Well, there was back and forth, and Mr. Ouellette was upset with me, and we worked through it. Eventually, I had suggested, or someone suggested, I think it was me, it could have been Mr. Ouellette, Catherine, but we decided that we had some old junky trees that were right behind the compactor, and maybe we could put that cooler there. There was already a power drop there. They could run some additional power. And if we could get that through the arborist and the neighbors, that we could put the cooler back there. And that's where the trucks were going anyhow, to pick up the trash and then just make a delivery into the cooler. And we worked with them for that.
And did the Conservancy under its lease have any obligation to do anything to support Be Our Guest efforts associated with this cooler?
We didn't, but that didn't matter if we had an obligation. That's the way we operated.
Did the Conservancy have any ability to control the city in terms of what approvals and the length of time it took the city to approve this process for the cooler?
We did not.
And this was this holding up? This was before any physical work had been started, right?
It was. I don't know. I don't know if or why the placement of the cooler would have stopped other parts of their puzzle or not. I'd heard that or read that in some of the emails, but that's foreign to me.
Okay. Let's look at the document behind tab 11.
I'm there.
And I don't think the jury's seen a document like this before. Can you tell me what this document is?
These are meeting minutes from the executive committee meeting of Thursday, April 19th, 2018.
So that's the same date as this email we just looked at, talking about the walk-in cooler. Is that right?
I'll trust you. Yes, it is.
Okay. And so the executive committee, tell us about, the jury's heard about the board of directors. What's an executive committee?
So like a lot of big boards, these are volunteers and they're oftentimes people with important jobs. So the executive committee meets in what we call the off months. So in January, the regular full board would meet. In February, the executive committee would meet. And then alternating months, you would either meet with one or the other. The executive committee in our bylaws is empowered to have the same force, the same power as the full board and act on their behalf.
And so the meetings it sounds like both the full board and the executive committee, they are taken down in the form of written minutes.
That is correct.
Okay, and that's part of the ordinary governance process of the board and the executive committee.
That's correct.
Okay. Your Honor, we're going to tender into evidence defendants exhibit 444.
Any objection to 444?
We'd object to Your Honor on hearsay grounds. We don't meet the exception of the business record because he hasn't authenticated that he's the one who kept these meeting minutes in the ordinary course. He hasn't said who took the meeting minutes down.
All right. Any response or other exception you want to raise?
I would just note that we had a similar set of meeting minutes earlier in our case that were not admitted for that same objection.
Understood. All right.
May I approach you?
Sure.
You know what, let me just ask the next question. Avoid this. Mr. Banta, who takes the minutes of these both executive committee and full board meetings?
It's done by the executive assistant, Marty Kellifus.
And that's your executive assistant?
Yes,
And
she's the primary liaison with the board.
And she takes down these as part of her ordinary job, as part of the ordinary governance process at your direction?
That's correct.
Okay. Your Honor, we remove for the introduction of exhibit 444.
All right. Same objection?
Yes, Your Honor.
Is there anything else you want to proffer, argue, or that you wanted to approach on?
Well,
All right.
Your Honor, again, based on the.
I'm saying this.
All right. Submitted over objection.
Mr. Banta, if we could publish this, please. I just want to go, looks like there are a number of things being covered in this executive committee meeting from April 19, 2018. Fair to say?
Yes.
Okay. Want to go to the second page. There's a heading President's Update.
Yes, I'm there.
Who is this your update?
That is correct.
Okay. And there's some discussion about staffing and MOU with the city. Again, indicating that a lot is going on other than dealing with this Be Our Guest restaurant situation, but that is addressed in the last full paragraph. Do you see that?
That is correct.
Okay. And what you say here, you say the tenants who have signed the lease for the vacant properties have not started the construction process for the 2 restaurants they plan to operate. They are working through permitting for the on-site cooler and evaluate construction costs, which are 1.5 times more than budgeted. According to the lease they signed, they will be in default in October, but additional negotiations are underway to resolve these issues. Did I read that correctly?
You did.
Okay. And so the default in October, what was being negotiated to avoid that concern?
This would have reflected that the second amendment to the lease was being discussed and also a potential amendment to allow the cooler to occur.
Okay. And the Conservancy at this point in time had been approached by Mr. Olet, and there was a request for more time to be paying rent and operating under the lease, right?
That's correct.
And the Conservancy was entertaining that request and was trying to help. Is that fair?
That's what we were doing.
Do you
And
renew it or, sorry?
He's leading the witness. I'd ask him to ask questions.
All right, for to leading, that'd be overruled.
And so, I guess what I'm trying to understand, Mr. Banta, at this point in time in April, construction had not started. You're saying that the tenant will be in default in October. Did you believe it was possible for the tenant to complete its project as required by the lease by that October deadline when you presented this update?
I did not.
Okay. And so the Conservancy could have just waited for that date to come and could have exercised its rights to default, be our guest under the lease.
That's correct.
Well, why didn't it just do that?
We brought them to the dance.
Okay. In order, Mr. Banta, to get approval for the further rent abatement and to move the rent commencement and operations date, did you have the unilateral authority to do that?
No, absolutely not. And as we've talked about, I was strongly advocating for BOG and fighting for what they were trying to do. But I have to have approval of the board.
So you had to go and convince the board that the right thing to do was not to just hold them in default and move on with someone like Shake Shack. You had to go convince the board that you should negotiate an extension and ultimately renovate.
Same objection.
All right, to leading, that's overruled.
That's correct.
Okay. Let's look at the document if we could, Mr. Banta, behind tab 13 of your binder.
I'm there.
This has already been admitted. If we could go ahead and put this up. Just want to make clear, starting with Mr. Olet's May 7, 2018 email to you. This is an email that the jury saw early this morning. If we could go down, BRW is proposing a specific rent abate, correct?
That's correct.
Okay. If we go down a little bit more, it says through July, and it looks like the proposal here, if we can go down a minute, that is blocking. Total additional minimum rent abatement for both Walkers and Soulshine, it's approximately $64,000 in year one.
That's correct.
Okay. And there was some testimony earlier about this rent abatement being in the future, but I just want to make clear, year one is the first year of the lease.
That's correct.
Okay. And so in later years, Be Our Guest was requesting rent abatement, can we go down? Keep going till the next bold section. There we go. So they're proposing additional rent abatement in years 8 through 15 of about $122,000.
That's correct.
And at this point in time in May, was the Conservancy willing to entertain requests for additional funding through rent abatement to assist Be Our Guest?
We were.
And again, at this point in time, had construction begun on site?
No, we're still a couple months before.
Okay. What was your reaction to this request before construction began for additional financial concessions from Be Our Guest?
The dance was getting more expensive than I thought it was going to be, but I still wanted to stick with the tenant.
And there's been some discussion about that this made sense because Be Our Guest was over budget, the bids came in obscenely high, and so it was gonna be spending more money in the Conservancy's building. Does that make, did you?
Yeah, I mean, that's the argument. In my experience, those building improvements are site-specific and restaurant-specific, so there's very little value that's transmitted to the Conservancy. If the business fails, you know, the type of furniture or the curtains on the wall or the floor, you know, every restaurateur I've ever worked with wants their own stamp. They want their own fingerprints on it. So the chances of these improvements, with the exception of perhaps a few mechanical upgrades to the power, would not be transferable to the next person.
So was this notion that Be Our Guest was spending $900,000 more approximately than what it committed to in the lease? Did you view that as valid to the business?
I just remained silent on that, in that I knew that it wasn't, but it's not worth diminishing. I mean, that's their position, and I can appreciate what their position was. But it didn't dissuade us or persuade us. We were moving forward with doing the Second Amendment to the lease to accommodate this.
We could look at the document behind tab 14, Binder. What is this document, Mr. Banta?
I'm there. It's another executive committee meeting. Again, they're meeting off months, so this one's for June of 2018.
And it's dated June 21st. Had construction, well, before I do that, Your Honor, move to tender into evidence defendants 388.
Objection to 388.
Based upon Your Honor's earlier ruling, no objection.
Well, I mean, if you have an objection you want to preserve for the record.
I think we preserved the same objection we raised to your earlier set of meeting minutes, Your Honor.
All right, so an objection on hearsay is overruled. It is admitted.
Your Honor, I'm sorry, Mr. Banta, if we could get this up. This is dated Thursday, June 21st, 2018. Had Be Our Guest started physical construction as of the date of this executive committee meeting?
They had not.
And if you look down, again, lots going on here. I want to come to the president's update again.
Yes.
Okay. It says, Mark Banta reported that the new restaurant tenants at the community center have completed all the requisite permitting and they will start building out the restaurant space next week. We agreed to make some financial concessions in order to make it easier for them to afford this construction. Did I read that correctly?
That's correct.
Was the full board enthusiastic about your position that the Conservancy should provide financial concessions to help Be Our Guest out?
Objection to the extent the full board was enthusiastic. And
did you get any pushback for your request for providing financial concessions?
Yes. I mean, I had, like any big board, I have some cheerleaders that love everything I'm doing, and others are saying, Banta, what are you doing over there? But I was continuing to fight for.
You continued to advocate to provide financial concessions to help Be Our Guest out.
100%.
In terms of the prediction here that construction was going to begin the following week, did that generally turn out to be accurate?
I believe it did. You know, when the construction starts, it's kind of they have a thing called mobilization. So they got to bring equipment on site. They do safety checks. They start erecting fence. So there was no hammers and drills out there yet, but they were getting ready to start their work.
Your Honor, we're about to switch topics. I see we're at the lunch hour. Happy to go on, happy to break, whatever.
All right. Thank you, counsel. All right, members of the jury, let's go ahead and break for lunch at this point. And I propose we be back in about 45 minutes at 1 o'clock so we can resume the defendant's case. So please don't do any research about this case or discuss it with anyone, including amongst yourselves. Thank you. See you at 1 o'clock.
And
All right, Mr. Banta, you can step down.
Thank you, sir.
Because I want to talk about, yeah.
I appreciate the job.
Thanks, sir. Is there an issue, Deputy?
Water. They're asking for water.
Okay, well, and which juror, just one juror was asking you? All right, well,
Several extras.
Yeah, I think we have
Yeah.
a pallet if they want some water.
the issue is we're running low on provisions and the number of jury trials we've had the last year, but I think we'll make it happen. Okay, so we've gone about an hour and 15 on that. Mr. McLary, do you think you're still on track with your prediction?
I think I got another hour.
All right. And I think the other thing we want to address before we break is the issue of attorney's fees on the defense side. Let me just kick this off from the bat. Would not this have been something that should be on the witness list on behalf of the defense?
Your Honor, no.
Okay, why not?
Well, because the Georgia Supreme Court has told us that is not required. Your Honor, I'll cite to you Halpern versus the Lacey Investment Corporation, 259 Georgia 264. It's a short case. You can go all the way to the very last, well, almost very last paragraph. It's enumerated 2. And it's, I'll read from it. It says here, the attorney testified, and of course, on appeal is that it was an error to allow the attorney to testify. It says here, the attorney testified only as to attorney's fees following a tradition in the courts of Georgia, which we decline to disturb. So long as the testimony is limited to attorney's fees, we hold it is not necessary that the attorney be listed as a witness in the pretrial order, for it is to be anticipated, as Your Honor suggested, he will offer such testimony in any case where a claim for attorney's fees is made. So we think this is a non-issue, Your Honor.
We can just leave it at that.
Yeah.
Was there, counsel might have been busy with other things in the meantime, but has there been I'd put it to the plaintiff whether this is something they're open to stipulation on amount and reasonableness.
We've tried to reach stipulation on a number of things before we got here today, including that issue. We were not able to reach stipulation, and I don't think we're going to do a one-sided.
Well, generally, I think I would say by definition, probably not. But it sounds like I may be hearing there may still be interest on it, but let me also see what defense's position is on that.
Well, we obviously accept such stipulation. As I think you're going to hear, Your Honor, our attorney's fees, despite being represented as the big, bad, well-heeled organization, our attorney's fees are substantially less than the plaintiff's attorney's fees. We believe that they were all, of course, reasonably incurred. We will reduce certain of the fees that were billed associated with the withdrawn claims, for example. And if there is an offer to stipulate, that would certainly save me having to stand up in my place and explain how we build this client. So.
All right, well, let's just stop there then. So what I would ask defense, just to make sure everyone's talking from the same point, is just clarify for the plaintiff, what is that amount?
Sure.
What documents are we talking about? And then plaintiff, you can let me know whether that is then accepted in the stipulation as the amount, and we go from there. Is there anything else then you think we need to address on that from the plaintiff's perspective?
I think the expectation would be that there's a stipulation from them as to our fees as well, right? If we're going to stipulate.
No, this would just be one by one. It would just be, if you're saying you're worried about what other things he might testify, here's an opportunity where he doesn't take the stand at all, because you're saying the amount we have no issues with, and we don't have an issue with the reasonableness. So, and I'm not saying that was just something I've put out there. If you think there is something you need to get into with that, then it sounds like he's taking the stand.
Take a look at it.
Yeah. All right. Otherwise, I don't see anything else to take up at this time on that.
We have one other item,
All right.
Your Honor. There was some testimony that the jury heard, and Your Honor's been doing a great job admonishing the jury in terms of don't go out and do any research. Because there has been specific evidence of Facebook posts this morning, we would request that those be made private. They are currently public. It sounds like maybe the intent is they're private. But again, we can go on and see these posts, and we prefer the jury not to be able to the extent they disregard Your Honor's instructions. And again, it sounded to me like this may be unintentional. So
Your Honor, just
Yeah.
if I may, I mean, I think the easier solution would just be to instruct the jury not to look at Facebook, including Mr. Lett's Facebook page. I mean, there's been some confusion. My client did intend to keep them to her friends. Apparently, they're not limited that way.
They are.
But rather than trying to parse out, is it public or private? And God forbid something come up with that.
Yeah, I would say if we've reached the point where a juror is following up on exhibits and trying to find, them originally on the internet, we've got bigger issues. And, I think I would be letting them know, certainly in the charge as written. I think the charge specifically says Facebook. And I think we could also let them know that if at any point you think a fellow juror has violated one of these provisions, to bring it to our attention. And so I would just say that, if we're gonna go out and try to claw back something that's out there in the record, then I don't see how I can distinguish between that and say, other press releases or news articles or just all the other things out there that I don't think we can shield them. And so I'm willing to again emphasize, to give them other directions, to do what we can to be proactive about it. But I don't see the need at this point to single out one specific thing out there and direct a party to go back through and audit all their posts at this point.
we respect that, Your Honor. And if you would, we'd appreciate just being clear with the jury on that, and the suggestion that if anyone, I don't like to make.
I mean, I don't know if that even
tattletales,
puts something in their mind. Oh, wait, I could go look at these. So, that's something to think about. But the timing of when and how you want me to do that, I'm open to it. But so you tell me.
Okay.
I could do it when they come back from lunch. I mean, or I could do it during the charge. I don't know.
I think let's wait. Your Honor, we are going to, and I think the charge conference is the appropriate time, but we believe the foundation that there were text messages existing was very clearly established this morning. And so we are going to renew our request now based upon evidence in the record for an adverse inference with respect to text communications between Mr. Olette, David Dooley, and others.
All right. So if you have a pattern charge or some other non-pattern charge on that point you want to submit, you can include that. And I believe there's some more coming in from the plaintiff's side. So please get that over to us at your earliest convenience, and we'll take a look at it, and then we can take it up at the charge conference about how appropriate it is.
Okay, thank you. That's all we have.
All right. Anything else on the plaintiff's side?
No, Your
Okay.
Honor.
We'll see you back at 1 o'clock.
Thank you, Your Honor.
Yeah.
You got them all?
Yes.
All of them better?
Uh-huh.
Okay. All right.
Smith and Mitchell. But it's looking like.
Yeah.
side being Norton. What we're doing here is talking about the importance. Everybody's agreed thus far, Piedmont Geotechnical and M2 have agreed that the likely cost. Nobody's done anything wrong. What we've done so far is great, but it's very important for us to get the city in on the lead on this because we're going to be dealing with their sewer asset.
And looking at the first paragraph, it says, it is fine to go ahead and do engineering for the shoring under this change order. PPC will pay for this either to Catherine as a reimbursement or directly to JF.
That's correct.
Why was the Conservancy willing to pay for this?
Well, we had said in conversations early amongst ourselves that we wanted to repair the void. That's an unforeseen condition. We didn't cause it, wasn't our fault, but we did agree that we would pay for the cost of repairing the void and investigating the void.
Go down to the second to last paragraph. This has received some attention this week. It says, and I'm going to pick up mid-sentence, it says, this issue, and you're saying as a quote, life safety emergency. You see that?
I do.
Why did you put life safety emergency in quotes?
In quotes. So the same board member who owns a company that does construction management all over, if I named the list of projects of what they do, you would immediately recognize them. But besides saying that it was important to get the city on board, he coached me to say that the important thing to say to the city in order to get them to triage it, in order to get them to prioritize it, is this represents a life safety emergency. And that's what we put in the outreach to the city of Atlanta.
And did that work?
It absolutely worked. They came out immediately.
Did anyone from the city ever comment on your use of that phrase?
Well, they,
Let's rephrase the question.
Sure. You know what, we'll move on from that. Okay, not important. Let's move Mr. Banta to tab 21.
I'm there.
This has also already been admitted. It may have been admitted under a plaintiff's designation, but this is defendant's exhibit 86. We could go ahead and publish that. Mr. Banta, this is a letter on VR Guest Investments LLC letterhead dated September 10, 2018, and it was a letter addressed to you. Is that correct?
That's correct.
And there's been some testimony that you asked Mr. Ouellette to send you this letter. That's true, right?
It is true.
Tell me why.
I wanted Mr. Ouellette to put in writing what their position was of their decision to stop work in order to try to get the city to move forward. And I thought this could be one additional piece of information the city could consider that the tenant was getting ready to stop work in the site.
And as of this date, September 10, 2018, VR Guest and its contractor had in fact stopped, correct?
They had notified me they were going to stop. This is a formalization of what they'd already told me they were going to do.
And Mr. Ouellette tells you in the second paragraph here, the damages caused to our two businesses resulting from the sinkhole and the subsequent delays, in addition to damages from the other landlord issues, are substantial. Is that what you expected to receive when you asked Mr. Ouellette to send you this letter?
I did not expect that paragraph, no.
Did you respond to this letter?
I did respond to the letter. I had to.
Okay, and that response letter has been characterized as a change of tone. Do you recall seeing that testimony?
I do recall.
Okay. And so, don't want to belabor the point, Mr. Banta, but is the word safety or safety concerns expressed anywhere in this letter?
It is not.
Let's look at your response. This is behind tab 22. This is Defendant's Exhibit 88. It's been admitted already as Plaintiff's 84. Just want to have you identify this for the record, Mr. Banta. Is this your response?
Yes, this is my response to the stop work letter.
And you said you felt like you had to respond. Explain to the jury why you felt that.
So the language used in Mr. Allette's letter, putting us on notice as to her reasons for stopping work, have to be responded to. And so I have to state that we have expectations to follow the terms of the lease, and also that we disagreed with this laundry list of alleged damages of deficiencies of the building. And so that's what I'm doing here is saying that we have in good faith attempted to work with Norton to work this parallel path to have them ready to go if the city won't come out, and that we had expected J.M. Williams and Norton to bring this contract back to us for execution, and they did not.
How did you learn that Mr. Norton or J.M. Williams were not going to be doing the removal of the slab and the excavation?
I received a phone call on September 6th, and the reason I remember that so clearly, we have two fundraisers. You've heard me talk about the Landmark Lunch, which is our biggest. Our second biggest is called Party for the Park. And I got the phone call as I was literally putting on my jacket to walk to the event from John Norton, explaining that they were.
Is this the main exception? Is for the truth of the matter asserted or for some other things?
It's notice.
Notice to
Mr. Banta that Mr. Norton's company would not be proceeding with the contract.
with that distinction. So
Please proceed.
John Norton called me and said that they would not be proceeding to execute the contract.
Mr. Banta, do you know what was the planned duration of the build out of the walkers and social space?
I've seen two construction schedules. They call them Gantt charts. It was between 14 and 16 weeks from my reading of the Gantt chart.
And construction began on walkers around the first week of July.
Correct. Right at the end of June, the start of July. There's a little startup mobilization period, but yeah.
And so when the void was discovered, obviously work stopped in that area while the parties figured out what to do, right?
That's correct.
So that allowed all of J.M. Williams resources to be deployed to work on the walker space, which they did until September of 2018.
That's correct.
Did you have any understanding when you looked at the state as of the stop work order, how much work had been accomplished or put in place?
I asked for an assessment on that, and so Ed Smith, that we'll hear from later, estimated that there was roughly 10% of the work done in that period of time.
Let's look at document on tab 23. This was admitted during Mr. Wilco's testimony as defendant's 89. Put that up. This is an email, Mr. Banta, from you to Mr. Ouellette, CC Mr. Dooley, or at least that's the beginning. You see that?
I do.
Okay. And it starts, if we go to the next page, a email from Mr. Ouellette to you. She says, as requested, attached is a letter from us specific to the sinkhole that you can forward to the city. So this is just confirming what the jury's heard the parties both say. You did request this letter so you could use it to try and get the cities.
Off the top dead center, that's correct.
Yeah. Okay. And so if you go forward, again, you transmit a response letter, and you say on a parallel path, we have asked for a face-to-face meeting with Commissioner Powell with Watershed Management. Why were you informing Mr. Lett?
I wanted Mr. Led and Mr. Dooley to be aware that we were doing everything in our power to keep this project moving forward. We believed, as did M2 and Piedmont Geotechnical and our folks at that point, that the sewer was the likely cause. And so I was letting Mr. Lett know that we were going to the very top, the department head, Commissioner Powell, for a face-to-face meeting to get her to the table.
Mr. Lett then responds a little later, 8:09 p.m., and she wants you to forward the stamped engineering report you referenced, stating that the location does not pose a life safety issue. See that?
I do.
And then there's a reference in your response. You say, "You are welcome. You misunderstood what I said. What I told your attorney was that we have an initial assessment," and it goes on. It sounds like there was a meeting on the site where you ran into Mr. Lett and be our guest attorney.
That's correct. It was an accidental meeting.
Which attorney?
Neil Wilcove.
Okay. Just tell the jury kind of what happened during that day.
We had Music Midtown already in the space, and they were opening their will call ticket office, and I was kind of in the center of the building, and I could hear yelling, literal yelling. And of course that was concerning to me. So I left the area where I was talking to the Live Nation will call office and went to investigate what was going on, where the yelling was coming from. And what I encountered was Neil Wilcove standing next to the hole with a flashlight, waving a flashlight around and yelling, "This is dangerous. Are you kidding me? This is dangerous." And I said, "Excuse me, who are you and what are you doing?" And then he introduced himself and I introduced myself. And I said to him, "What do you mean it's dangerous?" And he said, "Well, I've worked on these before and this is dangerous." And I said, "Are you an attorney or are you an engineer?" And he said, "I'm an attorney with a lot of experience."
What was Mr. Wilcove wearing?
He was wearing a tie, a suit and tie, a real very nice suit, actually.
And tell me how there's been some testimony that as Mr. Wilcove, Mr. Lett are leaving, I've never seen you run, but the testimony was you ran up and said, "Wait a minute, I've got an engineering report." Explain to the jury what was going on.
What I realized, and I think Mr. Ouellette said that the conversation between Mr. Wilcove and myself was a little bit heated. I didn't appreciate someone being in the building with a client in the building yelling, "It's dangerous, it's dangerous." So I felt a little badly about that. So I went up to them. I don't know that I ran or am capable of running, but I did catch up to them. And I said, "Hold on, I want you all to know that we've had the engineer of record, the historical engineer on site that same day, Mr. Eric Hagberg, who you all have met and heard from, and he has done his initial assessment. He had already been in conversations with Ed Smith, who was also familiar with the building. And what I was trying to say to Catherine and David was that, and to Neil, was that we were going to get a report. What they had said is, if you can get a structural report that says we can continue construction, we'll continue construction, because they'd already told us they were going to stop. And so that was one of the purposes of Palmer, was to assess structural soundness and to provide that report so they continue work.
And I'm not going to bore the jury with it again. They've seen the two September Palmer reports. Were those the reports that were generated after that meeting?
Yes, the first report was literally generated in a 48-hour period after Mr. Hagberg had come on site.
And Mr. Ouellette asked that some changes be made to that.
That's correct.
So another version was issued.
That's correct.
Okay. And that other version referenced that Mr. Hagberg had considered the M2 report.
Correct.
Just to generalize, in this report, Mr. Hagberg reports he was aware of a positive dye test.
Correct.
And ultimately, he concludes that the building is structurally sound, and there's no reason construction in the Walker space couldn't continue.
That's correct.
And he put his stamp on it.
That's right.
And did you send that or transmit that report to Mr. Ouellette?
Of course, right away.
And did Be Our Guest go back to work in the Walker space?
They did not.
What did they do instead?
They responded to me and also to everybody else that they didn't understand how he could assess that the building was structurally sound, and began to question, what he'd done and what his expertise was, et cetera.
Okay. Did there come a point in time, Mr. Banta, where you began to believe you weren't going to be able to satisfy Be Our Guest?
That's correct. That's a correct assessment.
When tell us about that.
It started pretty quickly after we realized that they were saying that they don't accept a stamped engineer report, that's not going to be sufficient. And then that concern continued to grow as we moved through time, and there were other exchanges of emails about what was needed. And we still had not satisfied the demand that said we have a laundry list of building deficiencies and we need the Conservancy to agree to a plan for how to compensate us for that or do the $2 million in escrow.
Mr. Banta, did there come a point in time where you were no longer able to persuade your board to continue offering concessions or trying to prove to Be Our Guest that there were no other voids?
That's correct.
Let's look at the document behind tab 26 of your binder.
I'm there.
This appears to be a email from you to Commissioner Powell. Who is Commissioner Powell?
Commissioner Powell is the Commissioner of Department of Watershed Management for the city.
And I'm not going to admit this, but just a couple of questions. It references a call between Commissioner Powell and Mitchell King. Who's Mitchell King?
Mitchell King is the board chair for the Piedmont Park Conservancy.
And did you ask Mr. King to contact Commissioner Powell?
I did.
Why did you?
Commissioner Powell and Mitchell King knew each other. I had worked through the chain of command, and we were again working under the advice of the advisor, the previous advice to keep the city engaged if there was any way we could get them on site to investigate the cause of the void and repair of the void, because it was their asset that we would be working on.
And you let Commissioner Powell know in this email, similar to your email to Mr. Abed, initial dye pack tests seem to verify connection of the void to the system, but the subsequent smoke test several days later was negative. Some thought this was due to the mud washed into the bottom of the void during dye pack testing sealing the fault. Were you on site during smoke testing?
I was.
Describe what you saw.
They did this actually more than one time, but what they would do is bring a smoke generator, which puts out this billowy white smoke, and they put it in an open manhole with the idea that it pushes down and then runs through the system. And then it's supposed to come out in the other areas. And if there is some default in the sewer, then it's going to come out of that default in the sewer. That's the theory.
And you say those tests were negative. Did that surprise you?
It did not surprise me.
Why not?
I don't have an engineer stamp behind my name, but I know that water and smoke both flow to the path of least resistance. And as soon as they put the smoke machine on, the smoke was billowing out of the open storm drains around the building. There were these little pipes that came up that are downspouts were in, and the smoke was just pouring out of those. And there was, there wasn't much expectation that it was going to come up through 16 feet of soil.
Mr. Banta, after this reach out from Mr. King to the commissioner, did the city ultimately come out and re-engage?
They did.
Tell me what you recall of that first re-engagement.
So this was, and though I've heard criticism of how quickly the city did or didn't respond, with Commissioner Powell receiving this information, she did mobilize her A-team, which included a number of people that are at the top of their departments. And they came out on site, and mind you, Music Midtown is still in place and still operating, but they came and asked to see the void. And that's where I got a very funny look. One of the people who I knew pretty well, this is the first time that they had seen the void, and they looked at me and said, "This is your life safety emergency?"
He said he's going to say what somebody said.
Say it.
Well, he's made an objection, so is there a response?
Oh, I was going to say no, I agree with the objection.
Okay, all right.
Sorry.
Jury will disregard any, answer they did here, and we'll move on to the next question.
Mr. Banta, was there a meeting, and without telling the jury anything that was said by others, was there a meeting that occurred between Conservancy representatives and City of Atlanta Department of Watershed Management?
As well as the contractor, yes, all those parties were there.
How did that meeting proceed?
That meeting proceeded by them coming in and looking at the void. They asked if they could have a room to meet, to confer, being the city themselves and not us. And we said yes. So they went to the laboratory in the back of the building and met, I would guess somewhere in the 20 to 30 minute range. And then they came back out and told us that they would do the investigation and the repair.
And there's one thing I don't think that we've closed the loop on, Mr. Banta. The jury knows that Ruby Collins, the city's contractor, came out and did its excavation, investigation, repair. Did the city ever send a bill to the Conservancy for that?
They have never sent us a bill for that work.
So who paid for that work?
The city paid for the work.
Has the city ever paid for any other work on the Conservancy's private property?
Not on the Conservancy's private property, no.
Let's go to tab 28, your binder.
I'm there.
And what is this email, Mr. Banta?
This is actually moving a little bit backwards from what something we've already talked about. So after Palmer issued his structural soundness report, Mr. Roulette asked if we could include the fact that he had reviewed the M2 engineering report, and he did so. And this was just me asking. And then also the top part of the email, I don't know if it's published, but top of the part of the email says, by the way, I'm notifying Mr. Roulette and Mr. Dooley that the city, DMW and their contractors will begin moving the slab and doing their exploration of the void under slab and the vestibule space starting tomorrow, which was immediately after Music Midtown. Basically, Music Midtown ended and the city came right in behind them to do this work.
Your Honor, move to admit that it's
Objection. Admitted.
we can bring that up. You've really said what I think the substance of it is, but want to focus on the beginning here and have you confirm on September 17, 2018, you're letting Mr. Lett and me, our guests, know that the city is going to come out, remove the slab, explore, and proceed to do work associated with this void.
Correct.
Okay. There was no intent to hide what the city was going to do, was there?
No.
You've heard this being described as the fix was under the cloak of night. Is that accurate?
It's not.
How long was the city on site doing its investigation and repair work?
I don't know for sure. I believe it was about a week's time, roughly.
Is there any reason that you're aware of that Be Our Guest could not have had its engineers, its contractors, its people overseeing that entire process?
No, there's no reason.
Did the city ask you or anyone you're aware of at the Conservancy for permission before they injected the flowable fill?
No.
There's been some question in this case, Mr. Banta, about as the owner of this building, you should have told the city to stop before they injected the flowable fill. You've heard that?
I think I've heard that inference, if not that direct statement.
If Be Our Guest wanted the city to not inject that grout, is there any reason they couldn't have been there and said, hold on, we want our people to look down here before you cover it up?
No, and I think that we watched a video a minute ago of Mr. Roulette on site talking to the contractor.
Let's go to tab 30 of your binder, Mr. Banta.
I'm there.
Want to start with Mr. Roulette's October 2nd email to you. She is saying, thank you for the update on the sinkhole. Please send over the promised reports as soon as you have them from the city. Do you recall receiving this?
I do.
Do you know what reports Mr. Roulette was asking you for?
Yes.
At this point in time, had you notified Mr. Roulette and Be Our Guest that the void had been repaired? I think we saw an email with the ray line good news.
That's correct.
And so I don't know if this has been admitted as a plaintiff's version, but to the extent it hasn't moved to admit defendants 385. We'd object on the basis of mistake. We would seek to admit only the portion that is Mr. Roulette's.
All right, with that limitation, 385 is publication.
So when you publish this, I don't know if we're able to redact it quickly, or if we can just go straight to the October 2nd, 2018 portion before putting it on the screen. I don't need the jury to see it. Okay, Mr. Banta, again, focusing on Mr. Roulette's email, she's requesting reports, and she goes on to say, we are looking to ensure that they reviewed all of the lines below the building and that they did the proper inspection and repair work to the sinkhole, and that they have done what is necessary to ensure that another sinkhole does not arise and or does not currently exist anywhere beneath the building. Do you recall there becoming a point in time where Be Our Guest was insisting that the Conservancy demonstrate to it that there would never be another sinkhole on this property?
Yes.
Is that something that was possible to do in your view?
No, it's not possible.
Is that something based on your experience working with engineers? Any engineer would ever do?
That's correct. You cannot predict the future. You do what's reasonable to limit.
So there's been some discussion about the meeting, I believe, October 5th. Is it your understanding this is the email that is precipitating or setting up that October 5th meeting?
Yes, there was actually another small meeting just between Catherine, Dave, and myself. And then this email is also pointing towards the need to meet with the attorneys and get everybody together on one page.
And Mr. Roulette says here Even with the sinkhole issue potentially remedied, we will need to meet and review the list of outstanding items we have regarding this project before we put shovel to dirt again. Do you recall receiving this email where Mr. Lett is essentially saying, we're not going back to work until the Conservancy addresses all of these things?
That's correct.
Okay, and she enumerates 5 issues.
Right.
And I think we've seen another email where there are 13 issues. And so if you take off the sinkhole, it's either 4 or 12 issues. You recall a number of issues that were not related to the sinkhole being addressed to Conservancy during October of 2008.
Yes, I do.
Let's, well, before we move away from this document, there's also some discussion here about the lockbox. You see that?
Yes.
What's going on with the lockbox? Can you explain to the jury?
Yeah, it's a really minor issue. So just like when you're selling your house, the real estate agent will put this little lockbox thing on and it's got a code and you put in the code and it gives you the key. For some reason, Mr. Lett thought that the code had been changed or the keys were gone. And all it was you have to put a little pressure on the shackle, put in the code, and then it comes, the key opens up. And I just explained to Catherine, to Mr. Lett, that there, nothing had changed. Nobody removed anything. It's all the same. Just put a little pressure on the top and it'll let you in.
Okay. Mr. Banta, we've seen that ultimately the Conservancy sent a notice of termination for default BRS on May 31st, 2019. My question to you is, before that date, did the Conservancy do anything to prevent the tenant from accessing its leasehold space and doing anything it wanted to in terms of investigation, probing, exploratory?
No.
Let's talk about the meeting of October 5th. What happened at that meeting?
It was a meeting and I think the jury's already heard the majority of the story, which is the lease attorneys were there. Neil Wilcox was there. You were there. Catherine, Dave, myself, and there could have been 1 or 2 other people, but I think that was the majority of them. And as has been described, there was some back and forth about the long laundry list of building deficiencies, some conversation back and forth about the Willie's corn coming backflow into the building, into their space. And then the description is how I remember it was that Mr. Lett got very upset. Mark Rushi, the lease attorney, finally interrupted, and I don't remember who was talking at the time, but Mark Rushi finally interrupted and said, Luke, has your client read the lease? This is a whereas as is lease, and the Conservancy is not responsible for any of these things that you're listing besides its cooperation on the void. And at that time, Catherine slammed her notebook on the table and she pointed and she said, Mark, I will fix it. And then she grabbed her stuff up and went out the door.
Do you recall any specific financial demand that was made in that October 15th meeting? October 5th meeting?
Yeah, it was, I don't think the exact number besides the 2 million in escrow, but there wasn't, it was them asking the Conservancy to agree to whatever those damages were.
Objection to the extent he's going to say what somebody said other than Mr. Hunt.
Mr. McLean?
Not asking, not seeking to elicit any testimony.
All right, if you re-ask the question.
Sure. The jury's already heard about this $2 million escrow concept. Do you recall when that was proposed, did anybody laugh?
No, but I don't think anyone laughed.
Did you think that was a joke?
I didn't take it as a joke.
Okay. $2 million is almost half of the Conservancy's annual operating budget.
Yeah, and beyond that, it's not, we were going to agree to damages we didn't do.
Mr. Banta, putting aside the other issues we've talked about, what is your understanding of BOG's condition to return to work? What is your understanding of what BOG needed to get back to work?
What was articulated to me was a number of hurdles that I didn't believe we could get over. The first communication was that we agreed to a plan to compensate them for 6 figures of building deficiencies, which we were saying the whole time that we did not agree with, that those weren't our responsibility, that we would help with the void, but that we didn't owe the other. The second hurdle was that the city come in and certify the building as safe. And I explained that the city doesn't do that. The city issues building permits, but they don't come in and certify the building to be safe. And the third, which has been really presented a lot, was we need a third-party soils engineer to issue a structural safety letter to say the building's structurally sound. And from my experience and the things that I built, that doesn't exist. That doesn't happen.
Did you tell your guest or Mr. Lett that what they were conditioning their return to work on was not real?
Yes.
Let's jump forward in time. I think we've established the lease termination occurred May 31, 2019. Did you become aware later on in July of 2019 that Mr. Lett or be our guest had delivered informational packages to the homes of your board members?
I did become aware.
Tell me about that.
I think that was a bit of a shocker. I had board members immediately, real time, emailing me saying that they were believing they were being served, that they were receiving these information packets from Mr. Lett, and I don't remember if it was FedEx, I think it was, were delivering them, and they were just giving me a real-time notice to tell me what it was. And what I tend to do in those situations is as soon as I have that information and verify it, then I begin to let other board members know what's going on.
And did you issue some sort of statement or fact sheet for the board members after they received that information?
Yes. The Conservancy is a connected board, and they live in the community too, and they receive questions from friends and neighbors. So some of the things that we were hearing from the plaintiff were not only pretty outrageous in terms of what they were saying related to safety, but also inaccurate. And so we created, with our attorneys and with our communications people and with our engineer, a fact sheet for the board members to know basic information and to be able to answer questions. We asked them not to speak to the media.
What was the condition of space A and space C after Be Our Guest was terminated?
It was a mess. The end of the building was removed. The floor was removed. The slabs that everybody has talked about, 75% of the floor was exposed in C, and probably 50 to 60% of the floor was exposed in space A.
And you testified a little bit already about Gay Construction. That's the company that Conservancy hired to bring the space back into leasable form.
Right, and also to weatherproof it. I mean, at that point in time, we had an open, imagine going through the winter with an open building with some plastic sheeting hanging down. And we've got sprinklers and fire protection and plumbing and everything else exposed.
handing you, Mr. Banta, what's been pre-marked as defendants 402. Are you able to identify this document?
Yes, I can identify it.
What is it?
This is a invoice from Gay Construction that you referenced earlier that did the work to do the restoration and cleanup of the damage from the tenant's work.
And under the lease, Mr. Banta, are you familiar, there's a provision that requires the tenant to return the space to the landlord in a broom swept condition?
That's correct.
What does that mean?
It means that when you're done with your lease space, then you don't have to pressure wash everything, but you have to clean up your equipment and you have to clean up whatever's left behind from your operation.
Your Honor, move to admit defendants 402.
No objection.
Would you publish, please? What is exhibit 402?
This is the invoice that we just discussed from Gay Construction to bring back the community center spaces CNA into leasable space.
Okay. Do we have defendants 402 on this? It's 11. Okay. This is one I would like the jury to see. Maybe they can just pass around my copy. Mr. Banta, what was the total amount that the Conservancy paid Gay Construction for the cleanup work, if you will?
It looks like it was just around 90 grand, just under 90 grand.
Okay. 86,000 and change?
86, it looks like 86,421 to be precise.
Okay. And there is a stamp on this that says paid. You see that?
That's correct.
Who paid Gay Construction?
Piedmont Park Conservancy.
Handing you, Mr. Banta, what's been pre-marked as defendants 522. Mr. Banta, there's been some discussion about difficulties with insurance because of the sinkhole. You recall hearing that testimony?
I do.
In its contract with Gay Construction, did the Conservancy require that Gay Construction maintain minimal levels of liability insurance?
Yes, we do.
Okay. And does the Conservancy, as part of its normal practice, require its contractors to provide a certificate of insurance before work?
Yes, we do.
Okay. Your Honor, move to admit defendants 522.
Objection. All right, admitted without objection.
What is this document, Mr. Banta?
These are certificates of insurance, liability insurance for Gay Construction.
Okay, so Gay Construction didn't have any difficulty getting liability insurance to perform work on the community center site in March of 2020, correct?
That'd be correct.
If you could turn now to tab 42 in your binder, Mr. Banta.
I'm there.
And what I'd like to do, if possible, just to move things along, I'd like to admit in bold what is behind tab 42 all the way through 47, which is defendants 514, defendants 515, defendants 516, defendants 517, defendants 518, and defendants 519.
Any objection to those?
No objection. Okay, let's roll through these quickly, Mr. Banta. What is defendants 514?
514 is Shake Shack's certificate of property insurance.
Okay, and so Shake Shack, we're jumping forward a bit, but Shake Shack now occupies space C, correct?
That's correct.
And Shake Shack entered into a lease with the Conservancy for space C.
That's correct.
does that lease contain any special concessions or protections for Shake Shack associated with any subsurface issues?
No, it does not.
And Shake Shack was able to obtain liability insurance for its operations in Space C.
Correct.
Let's talk about Space A. I'm a little confused. Willie's has been operating the community center for 20 plus years and was operating the entire duration of this saga with the sinkhole. Is that right?
That's correct.
Okay. And so tell me what happened after Be Our Guest was out of Space A. How did it come to be that Willie's operates it now in Space C?
So Willie's had a new concept, which if you haven't tried it, shameless plug, Willie's Howling Chicken, Nashville Hot Chicken, had it recently for lunch. It's excellent. And they approached us and said, sorry that this has happened with BOG. We would be interested in the space to do our expansion to have Willie's Hot Chicken.
And ultimately, Willie's entered into an amendment to its existing lease to occupy that space, Space C, correct?
That's correct.
Okay. And in that lease amendment, did the Conservancy provide any special concessions or protections associated with the sinkhole that the Conservancy repaired right beneath that space?
No, the contractors and the risk insurance people and the structural engineers for all of those other operators accepted the same documents that we provided to Be Our Guest.
Was there any additional information provided to Shake Shack or Willie's associated with their due diligence associated with the space?
No.
Turn to tab 43. This is defendants 515. I'll go through these quickly.
I'm there.
What is this?
This is the same thing, certificate of liability insurance for Willie's. And this would have been related to Willie's Howling Chicken.
Okay. Next tab, defendants 516. What is this?
516 is the building permit, and this is issued for Willie's Mexican Grill for their Howling Chicken expansion.
And you were in the courtroom when Ms. Hyde testified about the city's issuance of building permits, right?
That's correct.
Let's turn to next tab, defendants 517.
Yes.
What is this?
This is Shake Shack's building permit for Space C.
Okay. And in your experience in the construction industry, Mr. Banta, the permitting authority here, the city of Atlanta, has the ability to issue a stop work order, right?
That's correct.
And the city of Atlanta certainly knew about what was going on at this space, right?
Yes.
Did the city ever issue a stop work order?
They did not.
Instead, they issued building permits?
Correct.
Let's look at 518 and 519. You could just tell the jury what these are.
I'm there. So these are after the construction is done, these are the certificates of occupancy where the city says these businesses can operate in the spaces they're in.
Mr. Banta, could you go to tab 41 in your binder?
I'm there.
Before we introduce that, Mr. Banta, what law firm has represented the Conservancy from 2018 to the present day associated with the Be Our Guest situation?
Troutman Sanders has been our only attorney.
Okay, and just so the jury isn't confused, Troutman Sanders became Troutman Pepper in 2020.
I can't keep track of y'all's name changes, but yes.
And in fact, well, 2025, I don't know if they'll see a bill. We're now Troutman Pepper Law. Did you know?
Okay. And we're going to reject all the subsequent invoices.
What is defendants 496?
So these are invoices to the Piedmont Park Conservancy. They would have been sent to my attention, and I would then check them and forward them to my chief financial officer for payment.
And I noticed, actually, before we get to it, move to admit 496. May we approach on this? Sure. been on our exhibit list, they were produced 24 hours in advance. I'm not.
All right, is there any objection to Exhibits 496?
No, you're right.
It's submitted over without objection.
Okay. We could just put up the first page. This is a fairly voluminous exhibit. What is the date of the first invoice?
The date of the first invoice is dated 6/16/20,
It's for
2020.
it's for time incurred in the month of May 2020, bill in arrears, is that right?
That is correct.
And there's been testimony that my law firm has been involved in this issue way back to 2018. Why is it that the first bill you're seeing is not until mid-2020?
Troutman Sanders, whatever your name was providing some pro bono assistance to the Conservancy as a nonprofit.
What does that mean?
Pro bono means that the services are done in support of the nonprofit, and there's no charge for them.
Obviously there came a point in time where Troutman was no longer willing to provide free representation.
Yes, and you and your associates had forewarned that if it got to a point where there was litigation filed and we had to take depositions and do formal work, that we would have to start billing for that, even if it was at a discounted rate.
Okay. And that in fact happened. Was there a discount applied to the Troutman?
Yes, significant discount.
And Mr. Banta, these exhibits go through November, time through November 2024, correct?
Yes,
Look at the last page. Have these invoices been paid?
yes, all of them paid.
Who paid them?
Piedmont Park Conservancy.
Mr. Banta, at any point in time, did the Conservancy put profit or money over the safety of park patrons?
Of course not.
Thank you, Mr. Banta.
You're welcome.
All right, we proceed with cross-examination when ready. Clear?
Good afternoon, Mr. Banta.
Good afternoon, sir.
We've not officially met in a while. My name is John White.
Good to see you again,
Good to
John.
see you. Let me ask you a question just to start us off here. When did the Piedmont Park Conservancy decline to provide further monetary concessions to PRDS? When did that happen?
I think it was an iterative process. We were willing to provide relief from the void, but we had to get them back to the table and back to work.
Okay, and I guess I'm just trying to get a sense of the timing.
Yeah.
Because obviously the chronology is very important here.
Right.
When would you say that, when does that line in the sand get drawn? Is it October 2nd, like we saw earlier in that meeting that you described today?
No, I think at that point, we are still willing to do our part to get the tenant back to work.
Okay, so after October 2nd, can you just give me a ballpark?
I can't give you a precise date because this was a moving target, and we also had the tenant doing what they were doing with the media.
Okay. So my question is, it sounds like at least as of October 2nd, you would say the Conservancy was still willing to grant some sort of monetary concessions to BRDS?
I think that's accurate.
As of October 2nd. Okay, great. Thank you. You also said earlier that you were asked, that Mr. Ouellette was and your counsel asked you this question, was telling you that she wanted assurances that there can never be another sinkhole. Do you remember that?
I do.
We haven't seen any email or writing in the course of your testimony today where that terminology is used, have we? There can never be another sinkhole?
I think the exact quote is, I have to be 100% sure that that can never happen again.
But my question was, there's not a written writing where Mr. Alette says, I want assurances that there can never be another sinkhole.
I have not seen anything in writing. These are media interviews that are being put out to the
And
public.
I assume if there was a writing where she said that to you, we would have seen it today. Is that fair?
I would think so.
The Piedmont Park Conservancy owns the community center building, right?
That is correct.
Okay, but they don't own any of the land in Piedmont Park, right?
There's a small amount of land around the community center that we own as part of the community center.
Okay, but for example, if we were gonna, and for those who've been to Piedmont Park, if we're talking about the hill and the Great Meadow and some of the places you talked about earlier today, where they used to have concerts and tailgates back in the day, that part of the park over on, let's say, 10th Street in Monroe, is not owned by the Conservancy, right?
That is correct. The
So
city of Atlanta.
So it's fair to say it's limited to the community center building and some area around that.
That is correct.
I want to back up and try to go a little bit chronologically to the extent I'm able. You had said earlier, you talked about some of the issues that were being dealt with prior to construction commencing in June of 2018. Remember that?
You'll have to tell more specifically what you're referencing.
Sure. Well, there was some discussion about, for example, the cooler.
Okay. Yes.
And the fact that there was some negotiation or discussion with Mr. Alette about trying to locate the cooler in a place they'd be able to have access to. Right?
That's correct.
And it was your understanding that Mr. Alette was essentially looking for a solution to that problem, right?
I think that's accurate.
Okay. And ultimately, a nice solution was reached, wasn't it?
I believe so.
In fact, there were arrangements made to put it, I think you said in an area kind of out around back so that nobody would be able to see it. Is that right?
Well, people would still be able to see it, but it wouldn't be in the traffic pattern of the children in the unloading zone.
Which was your initial concern?
That was the concern when they had a solution to put it there next to the loading zone.
And so the cooler issue was resolved, fair?
I think we came to a solution that we all agreed to.
Okay, good. And you, prior to this sinkhole dispute and what's brought us here today, you had a friendly working relationship with Mr. Alette, didn't you?
I would classify it as that, yes.
It was collaborative?
It was.
Okay. And for example, when we talk about the rent abatement issue, you were actually working with Mr. Alette on that issue, and it was a negotiation, right?
That's correct.
And rent abatements are not uncommon when it comes to commercial property, right?
I would agree with that.
In fact, Willie's, who currently occupies the space, right?
Yes, Willie's in
Willie's
space
has the
A.
space, right?
In space A and B, yes.
And one of the spaces that was left vacant by my tenant was taken over by a Willie's affiliate called Howling Chicken. You know that?
That's accurate.
And actually Howling Chicken got a rent abatement as part of their lease, didn't they?
It's not uncommon.
My answer is, did they get a rent abatement?
Yes.
Okay, they did.
That's my memory, yes.
Let me ask you to take a look at plaintiff's exhibit 238. This is an email from you dated May 23rd, 2018 to Dawn Severt.
Sievert, yes.
And who is Dawn?
Dawn Sievert is our board, what's the title? She's the finance chair for the board.
Okay.
That's a volunteer position.
And it's copying Chris McDade. You see that?
That is correct.
And who is Mr. McDade?
Mr. McDade would have been the board chair at that time.
And Ms. Cheeroff, I think we've heard some testimony earlier. She's the broker on the property.
That's correct.
Looking at this email, it looks like you're conveying some sort of attachment, and it's talking about the rent abatement issue through the term of the lease. Do you see that?
That's correct.
Okay, and it says that you told them you wanted rent to start earlier than they had proposed, which was August. Then there was another issue about the late rent abatement in years 8 to 15. You see that?
Yes.
All right, I moved to tender plaintiffs 238.
Submitted.
If we could just put it up on the screen. And I'm looking looking at the sentence there where it says, I told them that. Based on our earlier initial conversations, I told them that we wanted rent to start earlier than proposed, August 2019. And our other biggie was that the late rent abatement years 8 to 15 drop to 1 quarter if they are, quote, making hay, hinting percentage rent. Did I read that right?
That's correct.
Okay, and what you're talking about there is I think what Mr. Lett testified to, which was that there was going to be some relief on the front end in terms of when the rent commencement would start, right?
That's correct.
And then in additional, there'd be some back end adjustments if, to use your term, the business is making hay or hitting their percentage.
That's correct.
And so the reason for that, in other words, we've talked about that the Conservancy was going to be sharing some was going to be paid based upon the revenues that were being derived from the property, right?
That's correct.
And so the sales targets that were in there, you were proposing that they be slightly adjusted if they were either met or exceeded. Is that fair?
That's correct.
Okay. And so there's upside to both sides that this lease is a success, right?
Always.
Okay. So when we looked at your memorandum from the meeting minutes, where you talked about the tenant is about to be in default as of October, we're going to give them concessions, right?
Mhm.
It's in the Conservancy's interest to not have a tenant in default and rather to get them into the property so that they can start generating revenue, right?
That's right.
Not only because it's good to have a tenant in the property, but it's also an income stream for the Conservancy, right?
That's all correct.
And that income stream is derived in part from the sales that they make as a business.
That's correct.
Okay. Take that. And as far as the delays on the development, you mentioned there were some permitting delays as well.
I didn't mention those. Mr. Roulette's mentioned them.
Are you aware that there were some permitting delays?
Based on her testimony and also the discovery, yes.
And those are not uncommon either in this business, are they?
I think that they can occur for sure, dealing with city.
And in fact, Shake Shack, when they were first, their start date was actually delayed as well due to some delays in permitting, I think as of 2021 or so, is that right?
I actually don't know that to be a fact. They had more issues with steel delivery,
Okay.
but that's the only delay I was aware of.
If I told you they had a delay with permitting as well, would you have any reason?
I would have no reason to doubt it.
So PPC built out the community center in or around 2000, 2001, is that right?
That's correct.
And I think you testified earlier that you had located some drawings for the site build, and we saw the email earlier where you took them down after the sinkhole was developed, right?
That's not completely accurate.
Okay. Let me ask you to look at Exhibit 349.
Okay.
Which part?
This one.
And I believe, is this going to be in this with you? I believe it wasn't. Let's put it up if we can. And this is an email from you on July 13th, 2018, right?
Right.
Approximately 2 days after the sinkhole was identified.
Yes.
Okay. And in this email, you've written and you say, we've located the 2001 site work civil drawings for the community center. Do you see that?
Yes.
I can make these available to the team on Monday.
Right.
So it sounds like in 2001, that would have been the time that this property was built out, as you testified earlier?
They were starting construction.
Okay. And so these drawings would be from the construction commencement?
They would have been, as I testified to earlier, they were part of the full set of plans. So this is a separate section that we found again, and we delivered actually the same day as the discovery of the void. I'm letting the team know that we located those drawings, made them available, and hey, everybody, these are available.
Okay, and so those drawings had been delivered, you said, as of the day the void was discovered?
Correct.
Were they delivered before that, these
No.
drawings?
They are part of a bigger set of drawings, what I've called the roll plans, which are the as-builts, including ready for construction, all documents.
And when were those delivered, according to your testimony?
Before they started construction. Those are the ones I personally delivered to AI3.
Okay. Do you know what an acknowledgement transfer form is?
I absolutely do.
Okay, and you didn't get an acknowledgement transfer form confirming receipt of the drawings that you testified about?
That is
today?
correct.
You did not, right?
I did not.
When you got on site at the sinkhole on on the 13th. Approximately how big was the sinkhole?
I would estimate it at 8 feet by 8 feet, 10 feet.
Okay.
Yeah.
Nobody from the Conservancy ever actually measured it, did they?
Very difficult to measure. I pulled out the 8-foot long 2x4 that was put in, so I guess I estimated it at 5 feet deep.
Okay.
But we could not determine what the width was. We could see 3 sides, but not the west side.
So you would say, based upon your visual inspection, 6 to 8 feet approximately?
Are you talking about depth or?
Let's do all three.
Okay.
Depth, length, and width.
Width and length, 8 by 10, approximately. Depth, I think it was less than 6 feet. And that's informed, if I'm frank, that's informed by subsequent photographs where you can see if the worker who's standing in the bottom stands up, his head's above the side.
Let me ask you to take a look at Plaintiff's Exhibit 29.
Thank you. Got it.
This is an email you sent to John Norton on the 16th of July, right?
Correct.
I moved to tender Plaintiff's Exhibit 29.
Any objection?
You put it up on the screen.
Well, I'm gonna object to the extent, I don't have any problem with showing the top part. I think Mr. Clinton's mail is.
I just want to show the top part here.
All right, with that clarification, it is in the top portion.
So on the 16th, you write to Mr. Norton, who's the general contractor. Thank you for your note and a copy of the soils engineer report, right?
That's correct.
You say, Catherine and I need to discuss the division of construction management and financial responsibilities for next steps, including removal of the collapsed slab, repair of the underlying cause, and filling of the hole. Do you see that?
That's correct.
And that was the goal at the time, right? It was to remove the collapsed slab, repair of the underlying cause, and filling of the hole.
That's all correct.
Okay. And after that, I think you testified that you proceeded to negotiate with Mr. Norton and his company, J.M. Williams, to have them perform the geotechnical work that was recommended. Is that right?
I don't.
Jury will call the yes. Answer the question to the best you understand it.
Yeah, I don't think that's correct. I think what we're saying is Catherine and I are going to talk about who should pay for what's next. This is very early in the process. And we're going to determine, based on that, develop a scope. Remember, we also have the city and the identification of the city asset as the likely cause as part of this thought process.
Right. And you were convinced, I think, that the city sewer was the cause, right?
I think convinced is too strong a word, but I believe, as I've said earlier, I've built a lot of stuff, so I am, like Mr. Norton said, I pay attention to what the engineers say.
You believed it was the likely culprit.
I believe it was the likely culprit.
Okay.
And remain today to believe that.
At this time, you're negotiating to do work into contract, as you said, with Mr. Norton's company, right?
That's correct.
And that included some shoring work that was recommended by a firm called M2, right?
Yes, the shoring design, and this has not really been clear, and I don't know if it matters to the jury, but the shoring design is actually different than M2. So there are engineers that specifically develop shoring, and yes, M2 was working to have that done.
And M2 made a proposal for the shoring work, right?
That's correct.
Let me ask you to take a look at Exhibit 41. Sorry. While we're getting it up on the screen for the jury, did you agree generally with the recommendations of M2 and Mr. Erickson?
Yes,
You did.
I do.
And you received a copy of this recommendation when it was issued on the 25th?
I did.
Okay. And obviously in this report, the third paragraph starts with the recommendation. You see that?
Yes.
Third paragraph. It is our recommendation that the 2 existing steel columns within Suite A, as shown on the attached sketches, shall be temporarily shored until the void has been fully investigated and repaired. Right?
Yes.
And you agree with that?
Yes.
Okay. And then he says at the end on the bottom paragraph there, given the potential presence of an old sewer line under the building, it is possible that voids exist under other portions of the building slab with the potential to impact other portions of the building's structural, architectural, mechanical, electrical, plumbing, and fire protection systems. Do you see that?
I do.
Okay. And so at this point in time, he's referencing the sewer line, right?
Correct.
And acknowledging that other voids could potentially exist under the building.
That's correct.
Okay. So you were aware of that as of July 25th, right?
I am.
And you testified earlier about an email that I want to ask you about. If we could put up Plaintiff's Exhibit 50, I believe you already have a copy. You'll remember it. It has been. You recognize this email?
Yes. Yes.
And you say in your email, I'm looking at the third paragraph, he, and I think you're recommending, you're referring to someone on your board, recommends that we get the City of Atlanta Watershed Management in the lead position on this issue. Do you see that?
That's correct.
And he recommends that we create a separate contract for PPC and J.M. Williams for this scope. That's what you wrote, right?
That's correct.
Okay, and then you say this change in direction doesn't reflect any concerns about our relationship, but is in consideration of the potential risk of unforeseen conditions, potential risk to the base building, and the situation PPC may find itself in with the City of Atlanta Watershed Management, right?
Correct.
So you're identifying the risks there, right? Including the risk of unforeseen conditions and or risk to the base building, right?
Correct.
Okay, and then in the paragraph just after the one below, when you starts with John, you refer to this issue as a life safety emergency, right?
That's correct.
And I think
In quotes.
In quotes, and I think you testified earlier that you were coached or told that that's what you should say. Is that right?
That's what they call prescriptive language in order to get the city to triage and put that as a top priority.
Okay, so when you said life safety emergency, was that just a matter of semantics?
It's not semantics, it's prescriptive language that specifically is going to trigger a response from the City of Atlanta.
But when you put that in the email, you didn't actually believe it was a life safety emergency?
Of course not.
You didn't?
No.
So you put it in the email and you sent it forward to the contractor on the project, or to Mr. Ouellette rather, but you didn't believe it was actually a life safety emergency?
That's correct.
That's your testimony?
That's absolutely correct.
Okay, and did you tell Mr. Ouellette, by the way, I'm putting this in quotes and we all know it's not actually a life safety emergency. You didn't say that, did you?
We may have had that conversation, but I don't recall specifics.
Do you remember telling her that it was a prescriptive term that you didn't think really applied here?
Yes.
You did tell her that?
In fact, I've told her attorney that as well when I was challenged on that language.
Okay, but I'm not talking about her attorney. I'm talking about in real time, at this moment. The only place we see it is in an email to her, right?
It's used in more than one time.
At this point in time, you're using it and you're not qualifying it and saying it's a prescriptive term, are you?
Not in this email, no.
Okay, and so you used the term, but you didn't actually believe that that's what it was?
That is correct.
Okay, got it. And you believe, we can take that down, you believe that the sewer was the cause, I think we've established that, or the likely culprit, right?
Yes,
And in September approximately, you engaged Mr. Hagberg.
that's correct.
We talked about him earlier, right?
Correct.
And Mr. Hagberg, you described him during your testimony as the engineer of record. Mr. Hagberg wasn't the engineer of record for this building. He wasn't, was he?
Palmer Engineering, I probably use that term incorrectly. The more correct term is the historical engineer.
Correct, because Mr. Hagberg was not personally involved in the construction of this building, right?
No, he's with Palmer, and Palmer was the historical engineer.
So the answer to my question is no, he was not personally involved.
He was not personally involved.
So calling him the engineer of record is not completely accurate.
No, he's part of the firm that's historical. That's correct.
And Mr. Hagberg was engaged in around mid-September, September 14th or so?
September 12th.
September 12th. And Mr. Hagberg also shared your view that the sewer was the likely cause of this sinkhole, right?
He shared the view of all the engineers that had looked at it.
So that was Mr. Hagberg's position. Let's take a look at his report if we can. It's Plaintiff's Exhibit 97. It's already been admitted. Now, you testified earlier that you believe the Hagberg report deemed the building structurally sound. Is that right?
It absolutely does.
Okay. In your view, the report was sufficient to, I think you said, to continue work.
That was the express purpose.
Okay.
To talk about all the concerns, address those concerns, and then give the green light or the red light to proceed.
Okay. And let's take a look at some of the conditions as he describes them. Well, first of all, in the limitations, Mr. Hagberg acknowledged that he hasn't done any analysis of specific structural elements, except were noted in the report, right?
Correct.
He also says no geotechnical investigation was performed, right?
That's correct.
And he acknowledges that the observations were limited to what could be seen with the naked eye standing on the floor, right?
That's correct.
Okay. And then if you look at the next page, under existing conditions, I want to look at the sentence that starts, the paragraph starts, upon further investigation. Do you see that?
I do.
And there it references the sewer asset, right?
Yes.
And at the last sentence there, he says it was speculated the sewer has a hole and erosion of the soil had occurred over a period of time, right?
That's correct.
Okay. And then at the next paragraph where it says an additional concern, let's scroll down, was the issue of the sides of the hole slowing off, making a wider hole, right?
Sloughing off. That
Sloughing
means to
off.
fall off. Yes.
And that appears to be occurring mostly on the west side of the hole and moving toward the steel column and footing holding up the mansard roof. And he says this concern is twofold. First, the hole may be actively getting bigger, right?
Yes.
Secondly, that the hole is going to undermine the column and cause the building collapse, right?
Yes. And to be clear, he's not saying that's, sorry.
Is that what he wrote?
Let's clarify, what's the question?
Mischaracterized, this does not say building collapse.
All right, so then, Mr. Boyd, you can re-ask the question, unless you understand it.
Did he write that the concern included that the hole is going to undermine the column and cause a building collapse? Is that what he wrote?
Yes, he is trying to address the concern being brought forward.
Okay. And then,
Not his concern, the concern that's being brought forward.
and then on the next page are his recommendations, right, for repair.
Correct.
And he lists a series of recommendations there, if we can just scroll down. Including locate the sewer in the area, confirm the location, engage a geotechnical engineer to confirm the sidewalls of the void are reasonably stable, cut away the slab, et cetera, right?
Yes.
You take that down. And you believe that this report you just said was sufficient to deem the structure sound, is that right?
That's correct.
And sufficient to get back to work.
That's correct.
Now, to get the timing right, at the time he generated this report on September 14th, the city had not yet filled the hole with grout, had it?
That's the beauty. That's exactly correct.
Okay, and so for example, we looked at a video earlier during Mr. Let's cross-examination, and the jury got to see the hole and how far down it went with the water on the bottom, right?
That's the
Have you ever seen that video?
that's the excavated hole after they've sucked all the soil out.
But none of the grout had been put in at that point in time.
That's
right?
correct. It's shored properly and it had the grout isn't in yet.
And so you believe that Mr. Hagberger's report was sufficient to get back to work and sufficient to deem the building structurally sound, notwithstanding the fact that no grout had been put in the hole at that time.
That
Is that
is-
your testimony?
That's my testimony and that's correct.
Okay, understand.
And that was Mr. Hagberg's testimony as well.
Now, the city did come on site around September 18th, right?
Yes,
We saw your email where you're notifying Mr. Lett of that fact.
that's
right?
correct.
I want to ask you about something that happened right before that. Let me ask you to look at plaintiff's 92.
Got it.
an email you wrote on September 15th, which is actually the day after the Hagberg report we just looked at, right?
Yes,
You recognize this email?
I do.
It's an email from you to Catherine Drillette, right?
Correct.
With a few copies as well. I would move to tender plaintiff's 92. Okay. We can put it up on the screen. If we can blow it up just a little bit, Ms. Wilkerson, please. And I want to focus on the first paragraph. And there you're summarizing the Hagberg report, right, which it issued the day before, correct?
Yes, I received questions about how could they say that the building's structurally sound? What did they look at, et cetera?
And in this report, you're saying he indicates that and believes the site is safe to continue work. That's what you wrote, right?
Structurally sound, yes.
Okay, and that's what you believe based upon the report. Again, notwithstanding the fact that the hole had not yet been filled in.
That is accurate.
Okay. Now, the city came out on the 18th, and they ultimately did the work that they did. We've obviously looked repeatedly at the city memos. I'm hopeful we don't have to look at it again. But
I think you're going to get to see something even better than that.
okay, great.
Good.
I don't know what that means.
You'll find out.
Okay. The city memo didn't find the cause to be the sewer, did they?
The city report says it was not. Yes, the city says that it's not their fault.
City says that the sewer asset was not the cause of the void, correct?
That's correct.
Okay. And in fact, there's no report anywhere saying that the sewer asset caused the void.
I would agree with that.
Okay. And after the city reached that conclusion, Piedmont Park Conservancy did not do any further work to identify the cause of the void, correct?
No,
After the city issued its memo, the Conservancy did not do any further work to identify the cause, right?
that's correct.
Okay. And to date, nobody has definitively said what caused the void, have they?
I don't think anybody can.
But you believe the sewer was the cause, right?
Yes,
Even though the city memo concluded otherwise, right?
that's correct.
And in fact, after the city issued its report saying that its sewer was not the cause of the void, you made a phone call to the city about that issue, didn't you?
Don't recall a phone call. It could have been a phone call or an email.
You don't remember making a phone call to Chris Lewis at the city of Atlanta?
Chris Lewis called me, but I don't remember a call to Chris Lewis.
Okay, do you remember a phone call with the city of Atlanta to talk about that issue?
Not in that timing, no.
All right, let me ask you to take a look at let me ask you to look at your deposition. You remember
Okay.
being deposed before?
I did, more than once. Okay.
This is a deposition you gave in this case, and it was around November 2021,
Okay.
years ago. Yep. Let me ask you to look at page 129 of your deposition, if we could.
129.
Yes, sir.
All right.
Starting in line 5.
Give me 1 sec. I'm there.
Okay, and the question was, did you ever communicate to the city of Atlanta that the Piedmont Park Conservancy disagrees with their assessment that their asset or assets did not cause the sinkhole void? Did I read that right?
You did.
Objection, Your Honor. This is improper impeachment. There's nothing inconsistent about what's being said.
Maybe I can read his answer.
No, I don't think you can. I'm not looking at this. I have no idea how to assess it. Your Honor, it's tab 1 in line.
Can you direct me to the page again?
129.
Mr. Moore, if you want to approach.
I had a phone call after I got the wood. Doesn't remember any phone calls. He said, yeah, phone call at that time. The question was, did you ever communicate to the city of Atlanta that the Piedmont Park Conservancy disagrees with your assessment the asset or assets did not cause the sinkhole void? Did I read that right?
You did read that correctly.
And your answer to that question was, I had a phone call after I got the initial report. I had the phone call to ask them if they would. I knew that they didn't want to admit it was their problem or they caused it, but would they be willing to modify the language that could have been the cause, or that was the cause, but everything's okay now? And that did not go over. Did I read that right?
That's correct.
Okay, so you did in fact have a phone call with the city where you asked them to modify the report to identify that the asset was the cause of the void, right?
Yes, that's correct.
Okay. The city did not make that change to its report, right?
The city did not make that change to the report.
You said it didn't go over.
It did not go over.
And when the city did the work that it did, it also did not replace or repair the sewer asset, did it?
It did not replace or repair. It did do a repair, yes.
My question was, did it replace or repair the sewer asset? It did not.
I would disagree.
Okay. All right. Let me ask you to look at page 134 of your deposition.
Okay.
Jack.
Good grounds up.
Is there questions pending? Is it your testimony that the city repaired an asset in the course of doing its work in October of 2018? Repaired the sewer asset?
I believe the grout, yes, I believe the grout sealed whatever small hole there was. That's correct.
Okay. Let me ask you to look at page 134.
Okay, I'm here.
And the question was, do you know if the city of Atlanta replaced any of the assets underneath or in the vicinity of the community center? Your answer was, I do not believe they replaced or repaired any asset. Did I read that right?
You did read that correctly.
Okay, thank you.
I think replaced was the key word that was being focused on. The original question was, do you know if the city of Atlanta replaced any of the assets?
Right, and your answer said, I don't think they replaced or repaired any asset. That's what you said, right?
Right. That's correct.
And the reality is, when you're working underground, you don't really know what's going on down there until you get down there, right?
That's why the excavation, that's correct.
And so without knowing what the cause is, there's still a question as to what the cause could be, isn't there? We have no cause.
I don't believe that's true.
You believe the sewer was the cause, notwithstanding the city report, is that right?
That is correct.
Okay. And that was your basis for the return, the belief that my client could return to work, right?
My basis is the engineering reports, Piedmont Geotechnical telling us what to do, we did it. M2 telling us what to do, we did it. Palmer Engineering telling us what to do, did not do it. Return to work.
You recall there was another sinkhole that opened up in the park, maybe 2015 or so? Does that ring a bell?
You know, I've been asked this before, Counselor, and I have vague memory. I think a student reporter from Grady High School wanted to do a story and they were trying to cut their teeth as a reporter. So that's my vague recollection.
Do you recall giving quotes to that reporter as part of that?
I may have, trying to be a good guy, yeah.
Okay, let's take a look at that if we can.
All right.
Plaintiff's Exhibit 6.
Got it.
You recognize Plaintiff's Exhibit 6?
I've seen, yeah, I mean, I think I saw this in Discovery, but I don't recall the article or the little reporter.
Okay, well, it appears to be an article from the Southerner Online dated May 4th of 2016. You said at the top.
Yeah, this is the student newspaper for grading.
Okay, and it's the misdiagnosis affects.
Objection. Your Honor, I don't have any problem with reading of any statements made by the witness. This is an article, a high school newspaper. It's the definition of your statement. Yeah, his statements are, that's fine.
Are there any other statements other than Mr. Banta's receiving?
That's all I want to ask about.
Okay, that's how we'll proceed.
Well, I object to it. His statement.
Move to tender plaintiff 6.
Objection.
With the
Solely to read the statement.
of Mr. Banta.
Yes, Your Honor.
All right, so it's noted with those annotations without objection.
Ready when you are. Am I good to go?
Just give us 1 second.
All right.
Wait a minute, I object to this being published again. Instead, you want to.
This is be published in just the portions you said are admitted.
Just the portions that are admitted.
Okay. So before we would show that, it's just going to be this statement.
That's fine. The article that we're looking at here was talking about a sinkhole from 2015. Is that fair?
That's what the article says. I'll have to trust with that it was accurate on the timeline.
And in describing that issue, you said it turned out it wasn't a 90-inch pipe that was the problem. When they finally dug down and got it dried out, before they hooked up all that black pipe, they learned it was actually a terracotta pipe that had broken. It was a much, much smaller pipe that was part of an old storm sewer. Is that what you said?
That's what I read, yeah.
And then on the next page, if you flip over, 3rd paragraph from the bottom, do you see that?
Okay.
That's the challenge with underground utilities, Banta said. It's easy to armchair quarterback it now, but the reality is when you're working underground, you don't really know what's going on until you get down there, right?
Sounds like a good quote. We spent about $1 million on that project.
And I'd move to strike. It's non-responsive, not responsive to any question.
All right, Mr. Banta, I'll ask you just to focus on the question that's asked and answer that.
Yes, Your Honor.
Let me ask you to look at Defendant's Exhibit 372.
Got it.
This is an email you sent on November 11th to Maher Abed, who you testified during your direct, right?
Yeah. That's correct.
And in this email, you're asking for an update on conversations between Maher and Commissioner Powell, that's Keisha Powell of the City Department of Watershed Management, right?
That's accurate.
Okay. And then I want to ask about the middle paragraph, if we can put up Defendant's 372.
Yes.
Put it in.
I don't have any objection.
We moved to the 372.
372 is admitted.
In that middle paragraph, you say, we've hit a major delay on our end. This past Thursday, the on-site contractor, after careful consideration, withdrew from the exploratory work due to their legal counsel and insurance agent's advice. The concern is the level of risk and their certainty that the sinkhole has been caused by the sewer line. Did I read that right?
You read it right.
So you're reporting that part of the reason the contractor had pulled out from doing further work was the level of risk. Is that fair?
That is what Norton has told us, is that they've been told to pull back.
You talked earlier about the dye test that the city of Atlanta ran when it was on site, right?
Yes, we've talked about that.
And it's clear, I think we've established it, but there's no written report reflecting a positive dye test Is there?
There are no field reports in that early testing confirming that. That's correct.
In fact, the only written report we have is the one from the city, says the dye test was negative, and that's one of the reasons they concluded the sewer was not the cause, right?
Yes, those subsequent reports do not include the field reports. Correct.
So regardless of any testimony you've given today about a visual dye test that you might have received on site, there's no written report to that effect.
That is correct. We've never received the field reports.
Do you recall issuing a press release in or around January of 2019 entitled "The Community Center is Structurally Sound"?
We've never released a press release.
Okay. Exhibit 141. This has been admitted already as exhibit 141. 141. Do you recognize the document we're looking at here?
I do.
Okay. And this is issued from the Piedmont Park Conservancy, and the contact is the Director of Marketing, Communications, and Public Relations. Is that right?
It is not issued. This is a copy of the verbiage that is placed on our website, 3 clicks deep for camp parents. Never issued to the press.
It's publicly available on the Conservancy website, right?
3 clicks in. It's not anymore, I don't think, but it was at the time. Yes.
At the time, it was accessible on the website.
Yes,
right?
sir. That is
Okay.
correct.
And then I want to ask you about the paragraph. It starts with, the void under slab has been repaired since September 28th, 2018. You see that?
That's correct.
And that's a reference to the City of Atlanta's work. Is that right?
That's correct.
The methods used to inspect the void, access the sewer asset, and repair the void have been deemed reasonable and thorough by the City of Atlanta Department of Watershed Management engineers, as well as the building's engineer of record. That's a reference to Mr. Hagberg?
That is correct.
Okay. All right. And you recall after this press release was issued, you received an email from Keisha Powell of the City of Atlanta?
It was either an email or a call, yes.
Right. And she asked you to change that press release. Didn't she?
You're saying as to what Ms. Powell was asking.
Let me just admit the document.
Well, that's.
Somewhat duplicative of the same argument, so let's just skip to it. To accept their statements from Ms. Powell inside this email. Is there any exception or non-hearsay use?
Impeachment.
Those of someone else's statements.
Well, it's also, I mean, I think it speaks to his state of mind.
Does he respond to it in some way?
He acts in response to it.
Shows any further argument. Larry, I'll hear it.
Something true. To show that after getting this document. Give some instructions. I don't. She's giving you instructions.
What's the exhibit number on this?
It's exhibit plaintiffs 154.
All right, to the hearsay objection that is overruled objection, over objection. Here's the jury, as instructed you previously, the contents of this email, which include statements by somebody else, are not included. The statements they made are true, but they're just admitted to show you, if it does at all, how Mr. Banta proceeded in his actions and his state of mind.
You may proceed.
We can put up exhibit 154, please. I'm going to scroll down to the bottom half of the page. This is an email from Keisha Powell to you, right?
Yes, correct.
It's addressed, good evening, Mark and Amy. Who's Amy?
Amy is Amy Dietrich. She is Director of Communications with Conservancy.
Ms. Powell writes, it was raised to my attention that the notice seemed to indicate that you deemed the community center sound based on documentation of our inspection of the utilities in the vicinity of the center in your engineer's report of records report. Did I read that right?
That's correct.
Okay. The bottom there, she says, I'm writing to ask that you revise your notice to clearly distinguish between your work to address the void on the Conservancy's property and our investigation of the utilities by our linear infrastructure operations team. Do you see that?
I do.
And then in the sentence after that, she says, our engineers did not provide a review of the void under the slab. As was communicated previously, this is private property and not under our purview to investigate the building slab further or repair the void. Did I read that right?
You did.
Okay. And after you got that email from Ms. Powell, the press release was changed, wasn't it?
We did modify and separate the actions that the city did and what we did.
And remove the reference to the fact that it was deemed reasonable by the city of Atlanta that work had been done.
That's correct. We only talked about what they did and then what we did and what was deemed by our engineer. That's correct.
You mentioned earlier there was a fact sheet that was generated. I think you said that you prepared it for the members of your board.
That's correct. Mm-hmm.
And it was a fact sheet to talk about the sinkhole issue and to establish some facts that you wanted to clarify for your board. Is that fair?
That's accurate.
All right. Let me ask you to look at Defendant's Exhibit 5. It's tab 40. Take a look at tab 40 in your binder.
I'm there.
Okay. You recognize this document?
I do.
What is this document?
This is the Conservancy fact sheet that we put together for the board members in case they got questions.
This was done approximately spring of 2019, is that right?
I honestly can't tell you based on what's on here.
I moved to tender Defendant's Exhibit 5. Okay.
D5 is the
And I want to ask you about the fact sheet and specifically the third statement, if we can. Get a moment to get it up on the screen. Scroll down. Actually, go back up to one right above that, please. It says fact, this remains a commercial dispute between landlord and tenant. Do you see that?
I do.
Okay. And I want to ask you about the last sentence, if I can. First of all, you prepared this fact sheet?
This would have been prepared with a combination of board input, council's input, my input, and then communications, PR type people.
Okay, and you reviewed it for accuracy?
I did.
And you approved it before it went out to the board?
I did.
Okay. And in that sentence there, it says the tenant's alleged safety concerns were raised only after the landlord declined to provide further monetary concessions for which the landlord has no obligation. Do you see that?
I do.
Okay. And that was not accurate, was it?
I think it's 100% accurate.
Okay, and I asked you at the start, when did the landlord decline to provide further monetary concessions for which the landlord had no obligation? When did that happen?
Back in 2018.
When in 2018?
I think there was back and forth in September and October about the demand.
And you had said, I think, when you started your testimony, that it had to be after October 2nd, because on October 2nd, you were still willing to provide for the monetary concessions, right?
And I said, we're still willing to work with them as it related to the void and the expenses related to that, not the laundry list of the building deficiencies. We never cleared that hurdle.
When did you decline to provide further monetary concessions to the landlord?
When we terminated the lease.
Okay, and so this statement that the safety concerns were raised only after that point, that's inaccurate, isn't it?
It is not inaccurate.
All right, let me ask you to take a look at defendant's 92. Plaintiff's 92, which was already admitted earlier. Put up on the screen, please. Let me ask you to look at the second page. First of all, this is an email dated September 15th, 2018, right?
I can't see the date on my part.
Okay, we can scroll back up if you need to.
I'll take your word for it.
Okay. And it's an email to you from Mr. Lett, right?
It appears to be.
And she's acknowledging receipt of the Palmer report in that first paragraph, right?
Yes.
And then she writes, the issue as we see it is whether the building is safe to continue to perform construction operations. Did I read that right?
I see that.
All right, that's on September 15th, right?
Correct.
Let me ask you to take a look at plaintiff's 102. And I only want to ask about the part where you respond.
Thank you. It's another nice thing.
This 102 is an email September 25th that you're writing to Mr. Lett, right?
Yes, that's correct.
Apologies, Drew. Look at this guy. That's all right. While we're doing that, maybe put that aside for 1 second, if you would.
Okay.
Can we put up on the screen defendant's 88, which was admitted earlier? '88. Take this back. We scroll up, just so we can see the timing of this. This is a letter you wrote on September 12th, right?
That's correct.
And if you scroll down to your first paragraph there, it says PPC disagrees, second paragraph says PPC disagrees with any assertions or assumptions that the entire community center is in danger due to sewer system issues, right?
That's what it says.
That's what you wrote.
That's correct.
And so you're disagreeing with any assertions or assumptions that the community center is in danger, right?
That is correct.
As of September 12th.
That's correct.
So that issue had been raised, it sounds like, as you're disagreeing with it, right?
It's raised in Mr. Alette.
Right. As of September 12th, it was raised by Mr. Alette, right?
That's correct.
We move to tender plaintiffs 102.
Just the top. Any objection? Submitted.
No objection to Joshua Schmidt represented.
If we could blow that up. This is an email you sent to Mr. Alette on September 25th, right?
That's correct.
Approximately 2 weeks after the one we just looked at, right?
That's right.
All right. And then I want to ask you where it says, to date, you have not done so. Do you see that?
To date, you've not done so?
Do you see, I've asked numerous times,
Yes,
and then it says, to date, you have not done so, right?
that's correct.
To bring forward any expert that would bring new facts or light, right?
That's correct.
To date, you have not done so.
Correct.
And then after that sentence, you write, you continue to cite safety concerns. Is that right?
Correct.
So I read that right.
That's correct.
Okay. And that's as of September.
You were walking away when you spoke. I'm
Yeah.
sorry. What was the last thing you said?
It was as of September 26th. You said that Mr. Alette was continuing to cite safety concerns. That's what you wrote, right?
I think it was the 25th, but I won't argue with the date.
Okay. And so when you said in the fact sheet that we looked at earlier, that Mr. Alette did not raise safety concerns until PPC declined to provide further monetary concessions. That was not right, was it?
Because this doesn't have a date, I can't speak to that, but it is my opinion then and now that safety concerns were only raised after we said we're not going to come to the table with the 2 million escrow or the laundry list damages.
And that was at the October 2nd meeting, right?
That was a later meeting than that, October, whatever, 4th, 5th, whatever date it was.
Right.
But we were having email exchanges before that.
We looked at a few where she raised the safety concerns in September 2018, true?
You'll have to show me those.
Have we not just seen 3 emails, 2 emails from her and 1 from you where safety concerns were mentioned?
In September,
Yes.
you'll have to show them to me again.
Okay, I feel like we just looked at plaintiffs 102.
What's the date of that?
September 25th, you continue to cite safety concerns.
Yeah, those are verbal, right? I've not seen anything. What I'm asking for, Counselor, is anything in writing from M2, Piedmont Geotechnical, or any other engineer that cites what her claims are, which are not specific at that point. They're just saying that there's safety.
Right, and your statement to the board was, she did not raise any safety concerns until PPC declined to provide further monetary concessions, right?
I did say that to the board.
Not in the form of a written report from an expert, just generally, safety concerns were not raised until monetary concessions were declined. That's what the fact sheet says.
That's accurate.
Okay,
And I don't know
Thank
when
you.
I don't know when this fact sheet was produced.
thank you.
You're welcome.
We talked a little bit about Shake Shack earlier. That's the tenant who took over after, right?
That's correct.
And actually, before we get to Shake Shack, I think there was some testimony about the condition of the building. You had to do some repairs on it when you took it over after termination of the lease, right?
Yes, when we took it back.
Approximately $86,000. Correct. Okay. And part of the reason the property was in the condition that it was because BR Guests never returned back to work after things were terminated. That is correct. When Shake Shack moved into the premises, they signed a lease as well, didn't they? That's correct. And I believe you testified earlier that Shake Shack didn't have any concerns about the sinkhole or that they were addressed. Is that right? I think they did have questions. I think there was enough mud on the wall at that point that they did have questions. And do you recall whether Shake Shack was not able to sign the initial lease that was provided to them because there were questions about that sinkhole? No, I do not know that. You don't? Okay, let me refresh your memory. Okay. Thank you. Mark is claims 239. I'll represent to you, this is an early iteration of a lease that was being negotiated by Shake Shack. Okay, I'll accept that. Okay, and I only want to ask you about one provision. Okay. It appears on page 4326 of the lease agreement. You see the bottom left right-hand corner? See that? Haven't gotten there yet, but I'm working. While we're doing that, we move to tender this.
You're saying this is an early draft, right? This is not.
Correct, this is an early draft.
Okay.
We can put 304 up on the screen. It's page 4326 in this document. 4326. Oh, sorry, it's exhibit 239. Plaintiff's 239. You see what we're looking at here, Mr. Banta? I do. I'm on 04326. Perfect. And the paragraph that we're looking at is section 304, where it starts with tenant. See that? I do. It says tenant shall accept the premises in its as-is condition, subject to any latent defects discovered by tenant during the first lease year, which landlord has been notified in writing, which shall be corrected by landlord at landlord's cost. Do you see that? I do. Okay. Let me ask you to look at the final version of the Shake Shack lease. This has been pre-marked as plaintiff's 188. And I'm looking at page 5452, which is the provision we were just looking at, Mr. Banta. Okay, I'm there. We moved to tender plaintiff's 188.
Well, there's an objection to the extent this is being represented as being the final version is signed. So there is an objection.
I would take that as a foundation objection. Mr. Boyd?
I'm looking at page 5490 for signatures. One on behalf of Piedmont Park Conservancy, Howard Wertheimer. Appears to be a signed lease to me. 549.
Well, I see that, but I'm also looking at several unsigned pages. 5521. I don't know that this fits a foundation for whether this is the final lease or not. I don't know where it is.
All right, so let's satisfy the objection. This is saying that the foundation.
Mr. Banta, do you recognize this document that we're looking at here? Plaintiff's 12188.
In general, I do.
Do you recognize the provision that we're looking at in section 304?
I do reading it, yes.
Does this appear to be a version of the lease agreement between Piedmont Park Conservancy and Shake Shack, Georgia?
It does.
Do you see that there's signature lines on page 45 of the document, one by Howard Wertheimer on behalf of the Conservancy and another on behalf of Shake Shack, Georgia, LLC? You see that?
I do not. The version I have has no signatures.
I'm looking at page 45 of the document.
Maybe I'm on the wrong page. Stand by. Stand by, Houston. Okay, I got you.
Does this appear to you, sir, to be a signed copy of a lease agreement between Piedmont Park Conservancy and Shake Shack, Georgia, LLC?
It does.
Okay, I move to tender plaintiff's 188.
The objection.
Objection to the extent this is being represented as the final lease agreement. This has no knowledge of.
All right.
Who signed this? If it's a version, that's fine, but representing the final binding agreement, there's no foundation.
I think his testimony speaks for itself, which is if he recognizes the provision, he said it's a version, and he's acknowledged it's been signed by both parties. I don't have to use the word final.
Okay, you did ask the question with your response to saying it is a version. So to the extent that is what it purports to be, is there any other
Objection to it being a version.
All right, but that is admitted.
There's 188. If we can go to page PPC 5452, please.
I'm there. Yep.
Okay. While we're bringing this up on the screen, this is the same provision that in the prior version we looked at, just had the as-is language. You recall that, Mr. Benson?
I believe so, yeah.
Okay. And here it says tenant has had the opportunity to fully inspect the premises prior to the effective date and will continue to have the right to inspect the premises during the inspection period provided for in section 3.6 below. You see that?
I do.
It says landlord has made tenant aware of claims of a prior tenant of the building concerning the presence of an underslab void in the building, right?
Yes.
It says landlord hereby represents and warrants that landlord has provided tenant all of its engineer's reports with respect to that issue. The void was not located within the premises, because obviously we're talking about the Shake Shack space, right?
Correct.
Nor within the Willie space, but was instead located in the approximately 718 square foot space adjacent to the Willie space, right?
Correct.
And to landlord's actual knowledge, landlord has fully repaired such underslab void. Is that what it says?
That's what it says.
Okay. You can take that down this way.
Mr. Moore, got an hour and 10. How much more time?
I mean, maybe 5 to 10, but might be a good time for a short break.
Let's send you, see if you can land the plane.
Okay. Tell you what, I'll break early, Your Honor. No further questions for the witness at this time.
How much time do we expect on redirect? Shall we press onward? All right, let's go for it. Mr. McLaren.
Mr. Banta, you were asked some questions on cross-examination about the Palmer September 2018 report and the fact that that
was issued before the city of Atlanta came out, did its investigation and repair and injected the global film. Remember that?
I do.
And the suggestion was that the Conservancy was telling BR's guests to go back to work in space A. Is that accurate?
That's not accurate. What Mr. Lett said she needed and we provided was a structural soundness report to continue to work in Walker before space A was repaired.
Right. So space A, there's no dispute at all. It needed to be addressed. We weren't telling her to go back to work with the hole in the floor.
That's correct.
The phone call, you recall that discussion, a phone call between you and Chris Lewis, who the jury has heard from. Do you recall talking about that on cross-examination?
I do.
Okay.
That's why I was a little confused about which phone call they were referencing.
And the questions where you had asked if Mr. Lewis would be willing to revise his memo to say that the city's asset might have caused this.
It could have possibly been. There was no way for the city to say definitively that that we didn't cause the issue. You can't.
And in fact, you were in the courtroom when Mr. Lewis agreed that the city's asset could have caused this. The city left it in a safe space, and that the flowable fill grout had choked off the throat and left the subsurface stage.
Objection, Mr. Chair. We'll let the jury recall the evidence as best they can, and that's to the extent we need him just to summarize testimony. Let's take one of the next question.
And that phone call, regardless of who initiated it, were you trying to have the city say something that was false?
No.
Okay.
Absolutely not.
Was that discussion after you had been on site and observed a positive dye test?
Yes.
Go to tab 40, if you would, please. Banta, this is Defendant 5, the fact sheet.
Yeah, I'm there.
Okay. And Mr. Moy asked you a series of questions about this last statement. The tenant's alleged safety concerns were raised only after the landlord declined to provide further monetary concessions for which landlord has no obligation. And Mr. Moy showed you a number of statements where Mr. Aled in an email to you was addressing, her concern about safety, correct?
Yes.
Okay. This was issued after Mr. Aled had gone on the news and talked about the safety of park patrons and the safety of camp kids, right?
That's correct.
Okay, so that's what you're talking about here.
Yeah, it's real hard with these things not dated to recall, and the council doing his job tried to trap me on what the timing was. But everything that we did, whether it was this fact sheet to the board or a sheet on the camp parents website, on our website for the camp parents, is all in response to these media efforts.
Thank you, Mr. Van.
You're welcome.
Any recross?
Maybe 1-2 questions. Thank you, Mr. Van.
You're welcome.
And to be clear, I'm not trying to trap you.
I know you're not. It's your job.
I can make this easier for you. Your counsel put up a demonstrative during Mr. Aled's testimony. It stated October 2nd is an operative date. You recall that?
Sort of, yeah.
Okay, and on the demonstrative, she said, here are all the issues Mr. Aled was talking about. And it wasn't until after October 2nd that she started talking about safety. Do you remember that? I do. Based on what we've seen today with these various emails that have been shown from September, you would agree that that was inaccurate, wasn't it?
Objection. As best you can answer it, you can.
Okay, no, I think that the timelines are tricky for everybody, but I still believe that was, all these things were being talked about and worked through, and then there was a very sudden shift in direction, and safety became the word of the day.
So your testimony is prior to that, safety was not the word of the day.
That is absolutely right.
Nothing further from you.
All right, Mr. Banta, you can step down.
Thank you, sir.
Members of the jury, feel free to, this little stretch break in place, unless anybody wants to go to the restroom, we'll go ahead and take time. All right, let us know when you're all ready to resume. And Mr. Blair, if you have the witness stand.
Sure. There are a few others, Judge.
I think these are left over from a Roulette. You want me to leave them here or?
No, you can on me.
Are we taking up business
Yeah, let's do a few things here. First of all, I think it is safe to say Mr. Adamowski can stay in north, and we'll wait for him tomorrow morning. We got our next witness here. Why don't we go ahead and have him?
I'm gonna bring him in. I personally would like to run the restroom.
Okay, all right. As soon as that light's on, I'm bringing in the jury, and then we can have the witness here ready to go. All right. So.
You're a little soft-spoken compared to all us loud lawyers, so I need you to kind of talk into the microphone.
Okay.
Don't sit too far back. And this is being live streamed online, so
Smile.
I don't know if you have any fans. Maybe let your wife know she can watch.
Oh, wow. Such fun.
Oh, yeah. Okay, court come to order, please.
Check on him, Deputy.
Yes, yeah.
Thank
Yes. It's kind of hard with them building two styles. They say it's 4 more ways to go in.
Okay.
Mhm.
But only one raised it.
All right, jurors. Stand up.
Jurors, the president of the county court, may you please seat everyone. As we call the next witness.
The Conservancy calls Edwin Smith. Raise your right hand. You swear affirm that the testimony you will give will be the truth, the whole truth, nothing but the self of God.
I do.
Go ahead and have a seat.
Thank you.
Will you state and spell your name for the record?
Edwin Smith, Edwin Houston Smith Jr. Fully.
Mr. Smith, good afternoon. Where do you work?
I have a consulting company right now. I've been working in construction business for 55 years.
Did you go to college?
I went to Georgia Tech and graduated in 1971 in a bachelor's of industrial engineering. And went to commercial construction for the next 50 years.
Don't want to hear about all of that. That's a long period of time.
I'm sure.
Could you give the jury just an overview of the types of companies and types of work you did in that 50-year career?
It was all commercial work. I mean, I worked for, my first job was for nuclear engineer, and I worked for them for 3 nuclear plants over 10 years. Did high-rise steel, 40-story office towers, have done hotel, have done condos, have done rocket launch facilities on the eastern shore. So done the whole gamut almost. Never did medical though. Thank you.
Mr. Smith, what was your, before EHS Consulting, your consulting firm, who was your last employee?
That was Silverman Construction Program Management.
Okay, and the jury's heard of Arnie Silverman. Who was that?
He was the owner of Construction Program Manager who basically helps a lot of nonprofits manage construction issues.
Was Mr. Silverman involved with the Conservancy?
He was in the board of directors at one time, yes.
Have you done any work at Piedmont Park?
Yes, I have.
Have you done any work at the community center?
I have, yes.
Tell the jury the first work you did at the community center.
The first work we had $1 million contract with a donor, which was a lot of money for the Conservancy, and we went around and replaced a lot of HVAC, electrical, HVAC, heating and cooling, electrical work on several buildings throughout the Conservancy.
And was that around 2015, 2016?
Yes.
Have you been engaged to do anything for the Conservancy subsequent to that?
I have done several projects. I went through and measured every one of the buildings there for insurance purposes. I rebuilt or built the north entry, north entry right at Monroe Drive, and I made a complete list of all their equipment with serial numbers of and dates of everything that they had in their possession.
Were you re-engaged at some point to oversee work being done at the community center in 2018?
On this particular issue?
Yes.
Yes, I was called the day after the issue happened and have worked on that for like 3 months, I guess, at the time.
What did your work entail?
It was to help resolve the issue of this void underneath the slab in the community center and resolve that.
When you first got involved, were the parties working together collaboratively?
I would say yes.
Okay. If you could, I put a binder in front of you. So you can go to tab 3 of that binder.
Yes.
Do you recognize this?
I do. That's my contract with the Conservancy for this particular issue. Yes.
Okay. And it's signed by you.
Yes, it is.
And it's signed by Mr. Banta.
It is.
And it contains what I would call, it says the services shall include.
Yes.
I would call that a scope of work.
Correct.
Okay. Your Honor, we move to admit defendants 397.
No objection.
397 is admitted. Okay. If we can put that up. We'll put it on the screen, Mr. Smith, or you could just follow along in the hard copy, whatever you're more comfortable.
You can see it there.
Could you, reviewing this, just tell the jury a little bit, this is dated July 21, 2018. Don't need to go through everything, but what services, what was your scope of work that the Conservancy engaged you for in July of 18?
Well, to review the contracts that were in place at the time of this incident, to look at existing drawings, old drawings of what was proposed and what had been built in the past, to meet with the contractor, insurance agent, and to evaluate the repair of this particular issue, and provide reports daily or as needed.
And if you could go to tab 5 of your binder. Are you able to identify this document's been pre-marked as defendants 478?
Yes, this is a daily log or weekly log of projects that, and this happens to be the log of this particular project that I was monitoring.
And do you maintain these types of logs as part of your consulting business as a routine part?
I do, and before I was in consulting, I would always have a binder that was not loose leaf paper that doesn't fall apart, and go back and refer to what happened day by day.
And is it your practice to record information timely after you receive that information in your log?
Yes, I mean, I would do my reports depending on the duration, weekly or bi-weekly or monthly, and I would refer to those notes as to what to report to the manager I'm working for.
Okay. Your Honor, move to enter defendant 478 into evidence. Any objection?
No objection, Your Honor.
478 submitted.
Okay. Let's pull this up. I'd like to go through just a couple of the entries. Is this your handwriting?
It is, yes.
Okay. And if you go, you see there are some pages down at the bottom. We could go with the ones in the center. Let's go to page 3.
Okay.
And the beginning of this is contract review. And then it looks like you are providing notes on your review of a contract. Is that accurate?
This is correct. This was the contract with J.M. Williams for the work at Walker's.
Okay.
And the notes on the left is just a paragraph of, this is a standard American industrial engineering architects actually contract, standard boilerplate contract, and the numbers on the left are the paragraphs which you can go back and relate to what I was talking about.
In your experience, Mr. Smith, in the construction industry, when you're doing a renovation in an old building, is it typical to have a contingency for the contractor when stuff comes up?
Very much so, yes.
Okay. As part of your review of the contract between J.M. Williams and VR Guest, did you note anything about the inclusion or lack thereof of a contingency?
I found no contingency in there. Talking to the person who gave it to me, he said that they had no construction contingency in their contract, which was a surprise.
Okay. Did that set off any red flags?
Yes, it did. And generally you have contingency from my side, from the owner would have a contingency for anything that could come up, but the contractor would also have a contingency for, they estimate all the work and they price everything, but there's always things that come up that are not shown quickly, or your order gets late and it costs you more money, or you hit rock when you didn't expect to hit rock. There's all kinds of opportunities in construction to not be exactly like shown.
And you said contractor contingency and owner contingency. I want to clarify that. In this instance, under this contract, the owner is actually the tenant, VR Guest.
This is correct, yes.
Let's go to page 8 of your notes, your log. Looking at an entry dated August 15, 2018. You see that?
I do.
Okay. Page 8.
Tab 8.
And so the first bullet point under this date, it says response of mayor with COA. Needs reports, need to respond. PPC will proceed with the shoring and fallen slab removal, but needs COA personnel to investigate full. Did I read that correctly?
Wait a minute. I'm on tab 8 in your book.
Well, we're still in tab 5. Mr.
All right.
Smith. You're log and you're on page 8.
Sorry, right.
So
Okay.
I'll read it again.
All right.
Response of mayor with COA City of Atlanta, right?
That is correct.
Okay, says needs reports, need to respond. PPC will proceed with the shoring and fallen slab removal, but needs COA personnel to investigate void. Stop there. Did I read that correctly?
You sure did, yes.
Okay, and so were you involved with a process where the Conservancy was going to contract with J.M. Williams to remove the slab, excavate, and then call out the city?
Yes.
Okay. Was that agreement, was there, did the parties come to terms on the agreement between the Conservancy and, J.M. Williams?
Well, that was my recommendation to the Conservancy. And so we discussed it with J.M. Williams, and they provided a contract, an AIA 104 contract, and which is the standard contract for doing cost plus work. And I provided a scope of work for them, specifically of what the Conservancy was going to pay for in that scope of work. And they were going to give me a price, an estimate of the 6 or 7 items I had on my list that would be the scope of work. But we never were able to receive that.
You know why not?
I do not.
Okay. Let's go continuing on that same sentence. I'm going to back up. It says, need COA personnel to investigate void as dye introduced in whole by COA exited the building on the east side. Did I read that correctly?
Yes, you did.
Okay. Is that an accurate recollection of what you understood as of August 15, 2018?
That's what I understood. I did not personally see that, but I was told that.
Let's go to page 12 of your log. I'm looking at an entry dated August 22nd, 2018. Looks like it's recalling or memorializing a phone conversation you had with John Morton.
That's correct.
Okay. And item 1, it says mold and studs, not big deal, but want direction due to liability. Do you remember an issue about mold or studs?
The one owner architect meeting I went to, the only one, they had stated that they had some issues. And so these were some of the issues that they stated that they had. And we went after that. Well, we didn't complete the meeting. We talked about early parts of the meeting, and then we were asked to leave, and we went over and looked at the job site to follow up on our own observations of what they found.
Let's go to the next page, page 13. I'm looking at an entry from September 6, 2018. It says various messages to Beverly Norton. Who's Beverly?
She was the vice president of J.M. Wilkinson's. She was the name on the contract, or this wasn't signed. It was just a name. That's who was going to sign the contract between the Conservancy and J.M. Williams.
And is Beverly, do you understand, is that John's wife?
That is John's wife.
So it says various messages to Beverly Norton. Meeting with Catherine. We'll get back on status of contract by 11 a.m. See that?
I do.
Okay. And so the next entry that day, it says Mark received call from John N. and Beverly N. that they could no longer.
I know the records themselves are omitted, but even within the records, there may be hearsay, and so I'm like, these pieces, and I think in this instance, this entry includes hearsay.
All right, it's already been admitted. Goes to notice, would be my response saying it's already been admitted. All right. So Beverly N. said that they could no longer help us with the void issue, suggested we work with the, what does that say?
Structural engineer and shoring company.
Okay.
Who J. and Wilkins has already employed to look at the situation. And so she suggested that we work directly with them at that time.
Who is Eric Hackberg?
He is engineer for Palmer Engineering.
And it was you who identified Palmer Engineering and brought Eric Hackberg into this one.
I did.
Why did you do that?
They were the engineer of record on drawings issued in the year 2000, where they modified the building. And this slab that fell was close to one of the columns that they had erected. So.
And why was that? Why did you think that was advantageous to hire the same company who had been the structural engineer in 2000, 2001?
But the structural engineer that J. and Wilkins had was only the structural engineer for the new construction and didn't have any knowledge of the old building. So we went and found the engineer who designed the column that was in close proximity to the hole, and found out that it was supporting some mechanical equipment on the roof, but not the building.
And you said you found the engineer. I want to be real precise. Mr. Hagberg wasn't personally involved in 2001, but his company.
Yeah, Palmer Engineering was the stamped structural engineer on the drawing.
And although Mr. Hagberg was not involved back in 2001, he would have access to all of the data, all the calculations, all of the loading that his company would have done as the structural engineer.
That is correct.
I'd like to go to tab 9 of your binder, please. When you're there, Mr. Smith, if you could tell me, do you know what this document is?
This is my first field observation report, dated February the 28th, from a visit of February the 12th.
Okay. And is this type of field observation report something that you prepare in the ordinary course of your work?
Yes, it is.
Okay. And you prepared this person?
I did.
Your Honor, move to introduce defendants 432.
No objection, Your Honor.
That was 44, 42?
432.
432.
If we could put that up. And Mr. Smith, you said this was your first field observation report, but it's dated February 2019. You issued other field observation reports as in the course of your work in 2018, correct?
So this is for project 1901.
Okay.
And
was your work in 2018 under a different project number?
Yes.
Mr. Smith, at some point in time, were you retained in order to perform monitoring services after the void had been repaired at the community center?
I think that is correct.
Okay. Well, let me see if I can
All right.
refresh you on that. If we could go to the next page.
Okay.
See some
Oh, yes.
photographs.
This
Yeah,
is,
what
that
are
was
we
a,
looking at here?
okay. So the pictures, what you're looking at, I was looking for, inspecting the building for any cracks or any settlement, just, just to document the fact. And this was on the other side of the wall where the failed slab, the slab that was cut out that fell was. And I noticed that there was a gap on the bottom of the board, and I measured that several times, and it hadn't changed whatsoever. There was no indication of anything settling there. The metal stud it's got a metal track. It was securely secured to the slab. So this gap was just between the drywall or the base and the floor had a dip in it from construction. And I monitored that several times just to verify that nothing was settling that was observable that I saw.
And Mr. Smith, if we could, let's go back up to the first page of this report.
Okay.
So this is dated February 12, 2019. And your observations, if we could go down.
Okay.
I'm not going to read all of them, but item 4 says, probing at the low slab area showed at the bottom plate of the wall structure tight against the slab and no signs of settlement. Did I read that?
Yes, you did.
Okay. And your follow-up steps are follow up with field observations at 3 to 6 month intervals.
Correct.
Okay. Let's go to the next path. Now, Ken.
This is a return visit to the same location.
I'm going to move to enter this into evidence as defendants 436.
Oh, 436 is in.
So you had just recommended follow-up in 3 to 6 months.
Yes.
We're in July, so we split the difference. We're about 5 months later. What were you doing at the community center in July of 2019?
Just went back and re-verified my measurements. And
Why
so
did you want to do that?
just to see if they're exactly the same or if any change at all.
Okay.
So I used some feeler gauges that were quite accurate.
Well, let's look at those. We go down to page 2. This is the same location, correct?
Yes.
Okay, and then let's go down. And you said this is right on the other side of where the void had been repaired, correct?
Correct. Yes.
Okay. And what are we looking at here?
So there was no difference in the gap between the bottom of the trim on the drywall, the base and the floor, and the track underneath it was still tight to the floor.
Did you see anything in any of your visits at the community center after the city of Atlanta did its work in September of 2018 that indicated to you the building was in any sort of form of structural distress?
I have not found any, no.
Mr. Smith, were you asked at some point to conduct a review of the status of DOG or its contractor's progress as of the time they stopped work in September of 2018?
Yes.
Okay. How did you go about that?
So in their contract, there was a schedule of values which we used in billing purposes. So it divides the different categories of the work from the drywall to the concrete to the steel to the site work to as detailed as you can get for billing purposes. And that's what I used. And I went through and observed the status of construction in place at that time.
And were you able to quantify the amount of work in place in the Walker space at the time DOG stopped work?
Yes.
About how much had been completed based on your review of the schedule of values?
You have that sheet here?
Sure. Go to tab 12 would be fine.
Okay. So that's got the percentage complete of like 25 different line items. It does, this particular sheet does not have the grand total. It has the grand total, but it doesn't have a percentage.
Okay.
Which by the way I'm looking at it, since I used 15% for well, I guess 15% is the aggregate of everything completed.
So 10–15%, is that based on your review of the billing invoices and your observations?
This is on, I didn't have any invoices. This is strictly on my observation.
If we could turn to tab 13. You're able to identify this document, Mr. Smith.
This is my field observation report number 6 dated January 22nd, 2020.
Okay. Move to admit defendants 441.
Any objection?
No objection.
441 is admitted.
Okay, if we could pull that up, and I'll have you review the first page. You could just tell the jury generally what it is you're reporting on here. Now we're into the year 2020.
So this was the status of both areas at the date of this report. So not saying who did what, but you know, the backfill and grading had been completed. This was some work to insulate. They had a whole wall out to the outside of the walkers area. So it was freezing cold, so we had to go back in and put up a temporary wall and put some heat in the building because there was fire protection piping in there and there was water piping in there. So just to protect what was there, basically from freezing.
Right, you don't want the water pipes freezing.
Right, especially the sprinkler pipe.
So, Mr. Smith, let's go forward. You included some photographs in this report.
I did.
And while we're getting there, who's doing this work in 2020? Do you remember which contractor?
This was Gay Construction.
Okay. And what are we looking at here?
So that is the walkers area. When the contractor left, there were trenches and sewer pipe, water pipe in the ground. Most of the slab had been removed, and now it's everything has been removed. All the piping has been removed, and it's been backfilled and had some gravel on it as well.
Okay. Fair to say this work, in addition to drying in the building, this is also just cleaning up so it can be relet.
This is correct.
Okay. Let's go to the next photo. What are we looking at here?
So we're putting in a temporary footing for a metal stud and plywood wall to cover up the exterior of the building.
What is that piece of equipment we see in the background?
That is a backhoe,
okay.
Excavator.
Okay. So there was plenty of room to bring heavy equipment into this site?
Yes.
Have you ever seen a boring rig? A piece of equipment used to bore into the ground?
Yes.
Could you have fit a boring rig back in this area?
They make small ones.
Okay.
I mean, they make some for interior work, but they're just, you put them a lot of pieces.
Okay, there's been some testimony about hand augering to get a core sample. You're saying there's smaller equipment that can do that mechanically indoors?
Well, I'm thinking about equipment to put in piles,
Okay.
I guess.
Okay.
Structural elements, not just to take samples is what I'm talking about, yes.
Okay, but clearly you could get heavy equipment back in this area.
In here, yes.
Okay, let's go to the next picture. What are we looking at here, Mr.
So this is the patio area. When the contractor left, there were concrete foundations and steel columns and a few beams installed, and all of those have been removed at this point.
Mr. Smith, during your visits to this property, have you seen any evidence of subsidence, loss of ground, anything that would concern you around subsurface issues other than the void that was identified in space A?
No, we have not. I mean, this sewer line goes through this area, so we have not.
Thank you, that's all I have.
Ross, is that?
Mr. Smith, good afternoon.
Yes.
My name is Scott Halsey. We've not met before, but I represent our guest in this matter.
Okay.
So started off with Mr. McCleary, show you a picture of the scope of work when you came into this matter, correct? Do you recall a moment ago, Mr. McCleary showed you a scope of work of when you were brought into this matter?
The schedule of values you're talking about?
At the outset.
Oh, the schedule that we're going to perform.
Right, the scope of work you were asked to perform in this case.
For J.M. Williams.
Okay, well, maybe we should do this. Let me bring back to the screen to the scope of work. I think it's plan 35.
We introduced it as defendants 397. We're happy to do it.
That's fine. Yeah, that'd be great. Either way.
Which,
I just want to make sure we're talking about the same
which
thing.
tab are we on? Where are we? Tab 3.
Actually, so maybe I can work from.
Yes, okay.
And
My scope of work you're talking about.
yes, sir.
Okay.
So I just wanted to get oriented. So this is when you first came into the case. Is that correct, sir?
This is correct.
I say in the case, I'm really referring to this project.
Well, I mean, I was called back because the slab fell.
Yes, sir.
Yes.
And this was your, I think you said it was almost 50 years of commercial construction. This was your first involvement in a project that had a sinkhole, correct? Or a void, whichever terminology.
I would say yes.
But you were brought in this instance to help Conservancy ultimately determine the cause of this void or sinkhole. Is that correct?
Not necessarily the cause to get it fixed.
And you did not solicit advice from other people who had existing experience with voids or sinkholes when you came into this project, did you, sir?
We very quickly talked to the city of Atlanta, who had extensive experience with that.
Yes, sir. But as of July 21 or close to that point in time, you did not reach out to one of your peers, for example, and say, hey, I've never worked on a matter with a void or a sinkhole. Can you help tell me what the process is, how I move forward here?
No, I mean, we were concentrating on correcting the problem and gaining, contacting structural engineers in city of Atlanta and other people.
And you will agree, sir, will you not, that at the outset you were working with engineers that our guests had brought into the project?
Yes, that's correct.
And relying upon their advice, for example?
Yes.
And we could bring up plaintiffs. And do you recognize that document, sir?
Yes.
And how is it that you're able to recognize that document?
Well, it's got my email address on it and my signature on it, or not my signature, but it came from my email.
And you received that from Mr. Banta, is that correct?
I sent this to Mr. Manor.
Oh, yeah, I'm reading that backwards. You sent this to Mr. Banta.
Correct.
Like the,
For the record, what was this plan?
Plain is 55.
55.
We can put this on the screen. And so this is dated, what can you tell us what the date is on this?
This is dated August the 14th, 2018 at 8 in the morning, 8:04 in the morning.
And then if you look at the bottom, you're setting up a site visit with whom?
Mark Nelson and John Norton.
And so earlier you talked about working and trying to enter into an agreement with J.M. Williams or John Norton, who was the representative.
Correct,
Right?
yes. Mhm.
So at this point, there's still collaboration to try to get this resolved. Is that correct?
Yes.
And if you will sort of take a look at line item 3, please.
Okay.
And there's a concern here, is there not, about columns that are close to the void that support the roof? Do you recall that?
I do. There was one column.
And is this one of the concerns that you had as you move forward here, sir?
Yes.
And then you see repeated throughout here a reference to COA. You recall that, sir, what that means?
The city of Atlanta.
Yes, sir. And so at this point in time, you're in communication also with the city of Atlanta, is that correct?
No, well, this was Mark Banta was, not me.
Okay. And so, you're working for the Conservancy at that time, is that correct?
This is correct.
And so the Conservancy is in touch with the city of Atlanta, is that right?
That's correct.
And you're trying to work with them to get to the bottom of this issue, is that right?
I'm trying to get their help, yes.
And it is the case that you did want, ultimately, the city, I think you even alluded to this on your direct, to try to attempt to find the cause of the void, is that right?
Not particularly what I asked them to. I wanted them to fix it, so the cause would be for them to determine, yes, I guess.
And you would agree, sir, that to get to a repair or a fix, you first need to know what the problem is. Would you agree with that?
I would agree, yes. Well, I know how to fix it. You may not know what the problem was, but you know how to fix it.
It'll be helpful to know the problem, would it not?
It would be
sir?
helpful, yeah.
We'll hand you 2 different exhibits just to not have to walk up here twice. Plaintiff's Exhibit 94, Plaintiff's Exhibit 60. Let's first take a look, sir, at Plaintiff's Exhibit number 60. Do you recognize this document?
I do. It's my field report number 2, dated September the 6th, 2018.
And
The date of the visit that it reports on was August the 21st of 2018.
Your Honor, I move to tender evidence Plaintiff's Exhibit 60.
Any objection? 60 is amended.
And so on your direct, you alluded to going to the site periodically of the void. Is that correct, sir?
Correct.
And it sounds like you memorialized your visits in different ways, sometimes in notes and then sometimes in these field observation reports. Is that correct?
Yes.
And in fact, I know Mr. McCleary showed you a couple of the field observation reports. These appear to be, are these, I don't put words in your mouth, but are these the more formal representations of what happened when you visited the site?
Yes.
And I would like to draw your attention, sir, to the bottom of the first page of the report.
Okay.
And ask you specifically at line item number 2.
Okay.
And so this is, again, the COA, being the City of Atlanta, is that correct, sir?
That is correct.
And the focus at this point in time, sir, was trying to find the source of the void. Is that a fair reading of that?
That's correct.
Then could we move to, if I could take it, sir, to look at number 64, or excuse me, plaintiff's 94. And can you let me know, sir, if you're able to recognize this document?
This is an email from myself to oh, this is okay. This is a letter to some soil engineering folks looking at putting in a soil anchor at the base of one footing.
And this is an email you authored, is that correct, sir?
It is.
I would tender it evidence plaintiff's 94.
See it. You got something offhand to respond?
No, I can ask questions and then refresh his recollection if he doesn't recall. Okay, try that. Sir, September 18th of 2018, the documents not admitted, so I'm going to see what you're able to recall, sir, about this time. You recall that.
What did you tell me?
Sir, at this time, was the Conservancy attempting to get the city to do work to investigate the cause of the sinkhole?
They were from day one, I think, yes.
And certainly as of September 18th, is that right?
I imagine. I mean, I don't have a calendar in front of me of all the dates of when they actually showed up and started the work, but.
Is there something that would refresh, does the email I handed you a moment ago, would that refresh your recollection about what was happening on September 18th?
Well, if I went back to my notes, I can look at what's happening on September 18th.
Well, I guess I have a very specific question.
Okay.
I'm really not trying to be tricky. Throughout September, you're representing the Conservancy in this construction effort, in this void repair effort, as you call it.
Yes.
Okay. And you're trying to reach out to the city and get their assistance. Is that correct?
No, Mark Banta coordinated with the city. I never did coordinate with the city directly.
Okay, so fair enough. The Conservancy is, I'll be more
correct.
precise.
Yes.
Correct. Okay. Yes. And the goal is to get to the cause of this void. That's why you're trying to reach out to the city. Is that correct?
Yes.
Okay. And not only are you trying to get to the cause of the void, sir, but is the case is the Conservancy driving the train at this point on the effort to investigate the cause. Is that correct?
I don't know if that's correct or not. We're driving the concern. I mean, the city came out quite quickly and started putting people into the sewer and cameras and did their own inspection. I don't know if we're driving the city that much, but they were responding to a issue in their city. I wouldn't say we were driving them, but yes, whatever.
Okay.
We were coordinating with them.
Okay, you certainly were coordinating with them as of this time.
Yes.
Is that correct? Okay. And so in doing so, you initially thought in this process that the sewer was the cause of the void. Is that correct?
I located the sewer on the drawings where this was, and they crossed exactly at that location, so yes.
In fact, your concern expanded beyond the spot below the void. Your concern involved the entire sewer line as it were to traverse the building. Is that a fair statement?
It'd be a concern.
And you have been marked as plaintiff's 48. And it's two-sided, sir. So there's a front and back. Can you tell me if you're able to recognize that document?
Yes, this is an email from me to Mark Banta on potential scope to remediate the issue with the J.M. Williams.
All right. And if you look at the second page, do you see the second page of that, sir?
I do.
And what is that? What's reflected on the second page?
Work we were going to contract with J.M. Williams and the work that we had expected to happen from the city of Atlanta.
And it's the case, sir, was it not that you had a concern at this point that there might be voids along the sewer line beyond just the point of where the void was?
Well, my concern was that the contractor would be able to price exactly what I'm asking the contractor to price. And if the city of Atlanta did not do what I'm saying they should do, then we would add that to the contractor's scope of work.
Okay. In addition to that, would you agree that you were concerned there might be holes in the sewer line beyond what was immediately below the void?
I had no idea of that. That's the reason the city of Atlanta was called, and they went underneath through the pipe with cameras and everything else to inspect what may or may not have been down there. So they went to firsthand view of what they could see inside the sewer line.
So if I could have you take a look at the second page there under City of Atlanta Watershed Department.
Okay.
Can you look at number 8, sir?
Verify no other voids have been created along sewer line under building.
Was that a concern of yours at this time?
That was something that I would want the city to look at, yes.
Thank you, sir. And you don't ever recall during the course of this case that the city had identified the cause of the sinkhole, do you?
No.
And in fact, I think you testified on direct, you don't recall, well, maybe you apologize, let me ask. You don't recall the Conservancy ever investigating the cause of the void, do you, sir?
How would we investigate some of the city of Atlanta's structure? We were not going to go inspect the city of Atlanta's structures, no.
I understand that.
Okay.
But now, so I understand we have a sewer structure underneath the void. I understand that. You're saying the city was focused in on that. Is that correct, sir?
That's correct.
Right. But there's also just the void itself, right? In addition to the sewer beneath, there's the void itself.
Right over the sewer line, yes.
Yes, sir.
That's what we're here about.
Well, exactly. And the Conservancy never did its own investigation of the void, did they?
Did we remove the slab and get in the hole? No.
Okay. And you never hired a geotechnical engineer in this case, did you, sir?
We hired a structural engineer.
That's correct, but never a geotechnical engineer. Is that correct, sir? We
didn't get to because the city of Atlanta went through it, and they had a expert contractor who have done this more than once and properly excavated all the way down to the top of the sewer and poured grout in it and repaired it to the top of the slab, bottom of the slab.
I'm sorry. And the city contractor to which you're referring would be Ruby Collins. Does that
Yes.
sound right?
Correct.
And you don't know whether they ever found the cause, do you?
I don't know if anyone says they found the cause, period.
And in fact, with respect to Ruby Collins, you yourself never even observed the report prepared by Ruby Collins, did you, sir?
I did not.
You nevertheless reached a conclusion, did you not, that the cause of the void was some sort of sewer leakage? Was that your belief?
It's been there 100 years, so my belief was there was a small leak when it pressurized and kept taking a cup of dirt out every 10 years.
Your belief in that, though, was based, I believe you testified on something you heard from somebody else. Is that correct?
And that was my thoughts. I mean, I don't know about that.
Okay. But not predicated on anything other than what you just described?
No.
Let's pull up, Edwin Smith 1866. I'm going to show you plaintiff's 240.
Council, you have a branded version, it doesn't have
What is your? Yeah. What is it? Plaintiff's 240.
Yeah.
We,
just want to make sure they work.
Sir, is this a photo, the photograph of the plaintiff's 240? Do you recognize that photo?
I do.
Did you take that yourself, sir?
I believe I did.
And this reflects the hole around the time you were brought in. Is that right, sir?
Correct.
And I think you alluded a moment ago that you did have concerns about at least one of the columns. Did I understand that correctly, sir?
I didn't at the time this was taken care of. That was that's the location of where the column is, where the guy's got his finger. He opened up the drywall where the steel column is.
At some point in time, did you have concern about at least one of the columns? I believe you mentioned a moment ago.
I have not had serious concerns about the column, no.
Did you have concern about the HVAC on the roof?
No, but when we were going to, what our contract with J.M. Williams was, we're going to follow his engineer and put up towers and put up trusses before we did anything else, to not knowing how much that column was holding. We were going to follow that logic.
Right, and above that spot was HVAC system on the roof. Is that correct?
Way up there. No, this actually, I think, was the canopy over the HVAC.
Yes, sir. And you were asked a moment ago about two different exhibits, defendants 432 and 436. Do you recall that? You don't need to dwell on them, but if they're handy, otherwise we can. In the meantime, Your Honor, we'll tender to the plaintiff 240.
Objection 240.
I don't, what is 240?
Sorry, I was talking to the court, but I'd like to, I think you have in front of you defendants exhibit 432 and 436. Those on the table in front of you.
Oh,
Council handed you a moment ago.
432 is under tab 9. Okay.
To orient the jury what we're referring back to. So you recall, sir, being asked about visiting the site on February 28th of 2019.
It was February 12th and a report was February 28th.
Gotcha, sir. Right. Okay. Very good. Would you mind scrolling down to that? One more. This is just sort of a side note, but is this the way you went about sort of measuring the gap between the floor and the?
No, I used other equipment that I showed in the other picture.
So February.
This was just so you could see it clearly, you know.
Thank you, sir. So February 2019, you went out to the site and you said you were checking for settlement. Is that correct?
I was looking for anything that showed settlement, yes.
And then not to waste everybody's time, the defense showed you another photo from July of 2019, also where you went back to the site.
Correct.
Also checking to see if it had settled. Is that correct?
Correct.
And that is approximately 1 year from when the sinkhole was discovered. Does that sound right to you in terms of chronology?
I don't know. So I don't know. Let's go back and look at that.
Would you accept that the sinkhole was discovered in July of 2018?
Yes. Okay. Yes.
About a year later.
Yep.
So as of at least a year later, you're still on the project. Is that correct, sir?
Occasionally, yes.
Occasionally.
Yep.
And there's still concerns that are causing you to go look and check to make sure this is not settled, right?
Just a follow-up, yes.
And that's because these things can operate, well, I say these things to be more specific, sinkhole void can operate over the passage of time whereby the ground settles. Would you agree with that?
I don't know if that's the issue, but I mean, no, I don't know if I agree with that or not.
Well, you said you were out there checking to see if it had settled a year later, correct?
It's just to verify it's the same as it was before, yes.
Right, okay. Now, I think you testified on direct about dye test. Do you recall
I
being
do.
asked about that, sir?
Yes,
And that you had heard about a positive dye test?
I was told, yes.
Right, and that's what I want to make sure I understood. You had not seen this in a report, is that correct, sir?
That's correct.
So you're told, just by some other person
Correct.
told you they'd heard about a dye test.
Right.
To be clear, the Conservancy itself never did any of its own dye testing, did it?
Not to my knowledge.
In fact, you didn't do dye testing or water testing or really any other sorts of testing, you being the Conservancy, correct?
I guess.
But you did at some point see, I think you said the City of Atlanta memo, is that correct?
Refresh me on what you're talking about.
Yes, sir. Do you recall around October 10th, the City of Atlanta issued a memo about its findings of the sewer investigation?
Yes.
Do you recall if you ever looked at that report?
Well, which one is it? Let me see.
Your Honor,
I'll need a copy.
no, we don't.
Is it in the book?
I do have an objection on the cumulative nature. I was hoping to get Mr. King in today. It looks like that's not.
Mr. Halsey, other than just
asking whether he recalls there's some other reason to get into the city report again. Yeah, the question was, raised about dye testing. It seems to become sort of a central feature. I did want to confirm whether he had seen this and this mattered to his investigation.
So you just want, on that point, you want to confirm whether you've seen it? Go on from there.
Sir, this is plaintiff's 109. This is the City of Atlanta report I was referring to. Did you see this ever in real time, meaning back at, around the time this report was issued?
No, I don't think so.
Okay, then no further questions about the report, sir. I understand that you've not seen the report, sir. Do you have a recollection of having a conversation with Mr. Banta about the possibility of his calling the city to change some of the findings in that report?
No.
Let me get plaintiff's 113. Thanks, sir. I'm handing you what's been marked as plaintiff's 113. You recognize this document, sir?
I do. That's an email from me to Mark Banta.
And then you're responding to that email. See that?
I wrote the email.
Right, at the top.
Yeah.
So let me ask the question again. Having looked at this email, does this refresh your recollection whether you had a conversation with Mr. Banta about his possibly reaching out to the city?
No, I don't think so. But I was saying that I don't know. I think I was told about this report. And I just said they should say, the COA should say they found the leakage and repaired it with concrete mixtures. What I said the city should say, but they don't acknowledge anything, I guess, so.
That was your belief, sir, right?
Right.
And still is.
My belief is that they fixed it with the concrete mixture, which would be as strong, if not stronger than the dirt. And where this hole is not under a structural feature. It just supports the slab. It's not a critical location for the structure of the building.
But you've never seen the city report.
I don't recall seeing it.
And that's the report that talks about the backfill.
Okay.
A few more issues. We'll be done, sir. Thank you. You recall that this building had a lot of issues like problems with the roof trusses, mold growing, steel beam issues and such.
I acknowledge there was alleged issues, yes.
Yes, sir. And you has been marked as defendants 415.
Thank you.
Do you recognize this document, sir?
I do, yes.
How is it you're able to recognize it?
It was from my email to John Morton with a copy to Mr. Banta.
And does this relate to some of the issues I was just asking about, the mold issue, the grease lines, etc.?
Yes.
Would you agree that the issues that we're talking about are fairly common in a building of this type to find these kind of issues?
A building this old, yes.
And they're not really a big deal, are they, sir?
They are not.
So you mentioned a good bit, sir, about the sewer line in terms of that, your view being that the cause was related to the sewer line. You'll agree, sir, that, let me start with this. What's happening underground is very hard to know what's happening under the city unless you're either down there to see it or you have some good drawings or reports that explain what's happening under the city. Is that correct?
That seemed like an open-ended question to me.
No, that's all right. Yeah, I mean, just want your answer as you're able to.
Say that again clearly.
It's a very complex structure underneath the city of Atlanta.
Yes.
Agree with that?
Yes.
Okay. And consequently, it is important to have accurate drawings about what's happening underneath the city to have any sense of what's going on, meaning where the sewers are, how many there are, et cetera, et cetera. Do you agree with that?
It may be important, but the city does not have that much detail. Yes.
Well, and that's one of my questions for you is, in this particular instance, there were multiple drawings of what was going on underneath the city in terms of what sewers, where they're placed, where they're not.
I've only seen one.
Do you recall a time when Shake Shack moved into this area?
Yes.
Do you recall being involved in some communications about needing to get discrepancies between diagrams of sewer lines resolved?
Yes.
So as of not just,
That was buildings. That was not city of Atlanta. That was sewer lines inside the structure itself.
okay. But do you understand back at the time, back in 2018, that there were multiple drawings of the sewer under the city? Do you understand? Do you understand that?
Asked and answered.
Okay. Okay. To bring your attention to, let's get plaintiffs 178. It was been marked as plaintiffs 178.
Thank you.
You recognize this document, sir?
I do.
Is this another one of your field reports?
It is the same one we looked at before.
This is from January of 2020. That's right. This is the gate construction.
Correct.
And I believe we looked at the picture on page 2. Is that correct?
We don't need that question. We just tighten the questions so we can combine them.
Sure. Is this if somebody were to come into the site as of January 22 of 2020, is this how that site would have appeared?
I would hope so.
And if you go forward to the 4th page, this is where flooring is being added. Is that correct?
This was in the other area.
This is in the other area.
Yes.
And eventually, though, flooring was added throughout. Is that correct?
I didn't witness this area at all.
Okay. Well, let's stick with this area then that we're looking at, the one on page 1. At this point, you've been backfilled and graded. Is that correct?
Yes.
Thanks, sir. You were asked at the outset by Mr. McClary if there had been a contingency provision in the J. Williams contract. Do you remember that?
Yes.
You found that to be unusual red flag.
It was unusual. John told me that he had no contingency. It's not usual to show a contractor's contingency in a contract.
Were you aware at this time, sir, that the sinkhole was part of the foundation, which was something that the Conservancy was required to maintain and not the tenant?
I'm not sure that the Conservancy was required to maintain it, but I'm not sure if I understand your question quite
You
clearly.
understand the Conservancy had a responsibility for the void of the sinkhole?
I think we took that on as our responsibility. I don't know that we thought about it at all. I mean, nobody thought about it.
And in fact, you're aware that throughout this project, in which you were involved, that our client had signed several change orders covering different contingencies. Are you aware of that?
I am not.
You were asked about a stop work order by VR Guest. Do you recall being shown a page you had tallied with an estimate of how much work they had done at that point?
I do.
You estimated, it was a range of 80,000 or thereabouts.
I think you're right.
Would it surprise you to know that that number was closer to 400,000?
It would.
Loath to say final question, but I think we're almost done.
Good.
After the city came out and did the work that it did the Conservancy have engineers come and check on their work?
Engineers?
Yes, sir.
Well, we had, yes, we had engineers out there.
That was Mr. Hagberg?
Yes.
Right. Any other engineers?
No, not that I'm aware of.
Nothing further, Your Honor.
You redirect?
No.
All right. This one is being used. Thank you, sir. You can step down.
Thank you. I'll leave this here.
All right, members of the jury, I think that we have achieved everything we can for today. Let me scope out tomorrow for you. There will be a lot, I think, happening in this site. And so I think we have we've planted a couple of shorter witnesses lined up for tomorrow morning. And assuming we can start right at 9, please make your best efforts to do that. That's going to ensure our success for tomorrow. And based on kind of a back of the napkin estimation, I think closing arguments would begin at some point in the afternoon after maybe more of a longer break, because there are some things still we have to do outside your presence. So that would be maybe around 1 or 1:30 optimistically. From there, closings are about 2 hours in length. And then I have to charge you on the law. That takes about 15 to 20 minutes. And so as of now, I would say it's a reasonable estimate to say that it is in your hands by 3:30 or 4 o'clock. From there, we're at your disposal. And we can stay after 5 if you want to, but that's not indefinite. You know, at some point, the deputies do need to go home. So we'll talk through that more when we get to that point, but I just wanted to let you know the roadmap. I see a juror with a question for us. So ma'am, if you could just identify your juror number, remind me.
Juror 5.
All right.
Will Tuesday's elevator situation be the same as today?
Well, that's the first time hearing of an elevator situation. Do you know what happened? Or can you tell me what happened?
Just that it was 8:30, 8:40, and it was really backlogged, so I
The
was
one
in
out
the
in the
building.
main.
Yeah, the
when you
main,
came in off Central.
yeah, so we were in the building, but there were 3 or 4
Mondays are
of us.
notoriously bad.
Okay.
Because that's, if you recall, way back when you
Yes.
showed up on Monday.
So Tuesday should be better.
Tuesday should be much better. All right, anything else? All right, seeing none, we'll see you back. Please do not do any research about this case. Everything you learn is in this courtroom, and don't discuss the case with anyone else. We'll see you at 9 o'clock.
All right, for sure.
All right, if I can have counsel kind of collect the exhibits from the witness stand, keep track of those, what's been admitted. Just go ahead and flag now in case I forget for later. One of the items I would give you is homework and maybe something to work on throughout the morning with second chair or third chair, fourth chair, is compiling that stack of what's going back to the jury. And so much has been kind of edited and conditionally admitted on the fly. There may be some redactions there to talk about. I know the parties have talked about saying, we're not getting into continuing witness rule. Anything admitted should go back. I wonder if that's still the case. And again, for those exhibits where maybe we only admitted half but not all of it, y'all are gonna have that redacted and ready to go to give to them by the time they get it. So I just put that on your radar now. Let's see, what else? I'll turn it over to the parties and we can keep chatting through some other issues that come to mind to make sure tomorrow flows smoothly. I'll just start with the plaintiff here. Anything needs addressing before we would break?
Sure, needs addressing it, just more alerting the court is we anticipate having a single rebuttal witness. We expect it to be a very short witness based on issues that came up today about Shake Shack.
All right, so that was Mr. Carter. And can you proffer along the lines of what it is you think his testimony is going to cover? I mean, I understand that we talked about some of the contracts and maybe some of the permitting things that came up. Is that the extent of it, or what is he authenticating contracts? I mean, what is he doing?
It's going to be what reports, what engineering reports were showed, in brokering this lease agreement.
Brokering his lease agreement?
In the lease agreement that he was brokering for his client.
I would expect we could reach a stipulation on that. I'm not sure.
Be more blunt, he was shown Hagberg 2, but not Hagberg 1.
Okay, so there's a proposal just to have that in writing as a stipulation.
I'm sorry, just a moment, Your Honor.
Sure.
There is a second part of that, which stipulation on this, but that the Hagberg report that he did receive, Hagberg 2, was not sufficient for them to move forward with the lease without more.
The original November Hagberg reports that they saw, there was other things that happened after that, but then they entered into the lease.
So the Shake Shack lease obviously is now a couple of years later when that's been conceded. They need something to rely upon, just as our client did, to move forward in the Sinkhole. They were provided the Hagberg 2. That's what we're characterizing, most strongly disagree with, is the sanitized version. What they were not provided with, and what our witness would testify to, was they never had seen Hagberg 1. In addition to that, and that's important because that was a distinction that mattered in our case. A lot's been made of Shake Shack and they're moving in, and hey, everything's okay. Shake Shack moves in, these guys, something's wrong with these guys, won't, doesn't work with these guys. And so we want to show the same thing happened to them. On top of that, we expect the witness will testify that the Hagberg report that they did receive still was not sufficient to move forward. And that's been a point of contention in our case as well, that on its face, Hagberg 2 is problematic. And so it reinforces a couple of points that we've been making, and it's relevant now because Shake Shack has been made a significant part of their case through their witnesses.
All right, Mr. McLean.
Well, I think anything that, what's his name, Chris?
Carter.
Chris Carter. I think anything Chris Carter says about what Shake Shack needed or what was sufficient to Shake Shack is hearsay.
First of all, who is he? I don't even know who he is.
I think he's a real estate broker who was involved in the solicitation and the lease for Shake Shack.
That's right, and he was operating in this capacity as their representative, Shake Shack.
Scott, are you talking about the GPR testing? We talked about.
The Hagberg, yes.
You said it, you're proffering that this guy's gonna come in and say that wasn't.
So two things. One, that they only got Hagberg 2 and not Hagberg 1.
We agree. We'll still do
Yeah.
it.
Secondly, that Hagberg 2 was not sufficient for them to proceed forward with the lease.
So what else happened before they signed the lease? Issue. The provision that says, we've told you about this, we. Correct. Right. Section 304. Your Honor, this seems like a total waste of time. This issue, I believe, the door was opened by the plaintiff. They put these leases in. The jury has both of these lease versions and jury can look at them. I don't think a witness coming in here to say what Shake Shack thought. I mean, they entered into the lease, they're operating.
I mean, I suppose the issue here is what other things could have gone on that weren't reflected in the lease.
Well, that's not what I hear from.
Well, that I know, and I agree with you there. But I also would have the initial concerns that you raised of a real estate broker for the deal coming in and basically just acting as a conduit for what his client's desires and positions were. Yeah, I'm sure he has knowledge, but unlike everything else, which had either non-hearsay or exceptions, I'm not seeing that here with him. But if you brought in the owner of that Shake Shack tomorrow, I think it might be a different story, but I don't see that on this witness list. So you can talk through that concern with me, but I do also think that, I mean, I agree that to some extent Shake Shack is an issue in this case. I think it was referred to on direct through Mr. Banta. It's been referred to, I think, throughout. I couldn't recall offhand who may have said it first, right, and how it was used as an argument. So some of these issues do seem at play, but I'm very wary of now going down a rabbit hole of a second trial of why Shake Shack's lease went forward and this one did not. I'm very concerned about that possibility.
Yes, sir. So addressing both of the court's points, I think we can have this witness up and off the stand 15 or 20 minutes. I don't expect this to be a sideshow or a side trial. As to the...
Well, I'll just point out for both parties, the only ones that have finished on time is when I had the clocks on. So the estimates have been pretty much off every single time, except for the last one. So direct was 29 minutes versus 45. But anyway, I'll just share that. But okay, I take your representation there. What else?
That's our main issue, is that rebuttal. I want to bring that.
Okay, you addressed the time aspect. You think it would be a limited witness, but what about this issue of how he's just talking about what the owners of Shake Shack think and did and felt, and getting an evidentiary?
So no, I think so. Sorry, let me say no. Let me start over. He was an agent for Shake Shack. He had an active role in this matter in advising them on what steps to take or what steps not to take. He will say in that regard, he was the person who received the Hagberg report in question. And based on what he received, he gave advice to Shake Shack about what steps to take next, specifically the lease revision. And again, I think given what's been laid out in Vince's opening, and then now what's been brought in evidence, this is directly relevant to the issues in this case.
The relevance isn't really, on its face, is not giving me concern. Some aspects of this I see are relevant, but I am getting caught up on hearsay on this one because he's not a party to the lawsuit. Party opponent wouldn't be at play. Their actions, I've not heard any testimony weighed into be our guest's decisions. This is something that happened after the fact. So I'm not seeing it for those non-hearsay purposes we've been using pretty prolifically.
I would ask the court to allow us to revisit that further in the morning because I understand the court's issue where it's the point we're on. I'd like the opportunity to look into that a little further and then we either make the case or we don't.
All right. Anything else you think that needs to be addressed as it relates to Mr. Carter and the rebuttal witness then? All right, not hearing any. I also think that in the interest of staying on track for tomorrow, with the exception of Mr. McLary, maybe because you are able to work out the amounts and doesn't end up testifying. But if you don't, I presume his direct may be fairly short as opposed to the cross may be longer. My inclination is to say here that however long the direct is, the cross can be no longer. So that creates a ceiling of time. So you can think about that and any reason why that should not be imposed here. Or if you have any other creative solutions. But all right, so I think I again just opened up the floor to anything and everything. You talked about Mr. Carter. Anything else on the part of the plan?
Just a moment, sorry, we need to consult. There is, I guess, one more item from the plaintiff side, Your Honor. We would like to reserve the possibility of calling Mr. Lett, because in this case, he's also a counterclaim defendant. We looked into the case law before coming in today, and it's not a requirement that should be permitted to testify. That is within the court's discretion. We're not asking the court to take it up at this moment. We would like to have a further huddle. I'm going to ask to do that unless we thought there was something that was not testified to that has come up. Makes sense, but we're just like to let the court, we'd like to reserve the right to visit that.
I mean, it's always good to flag something, so we'll always appreciate that. But you know, I'm going to have to hear a pretty good reason what it is that she needs to talk about on rebuttal. Well, I guess you're saying this isn't for rebuttal, it's as
Her as a counterclaim defendant.
Okay. Yeah, I'm just gonna have to hear a very strong case on why that's justified here.
Yes, sir.
If you have one now, maybe that can.
We would like to revisit that to be respectful of the court's time. Sit down.
Okay. All right. Well noted. What else?
That's it from the plaintiff side. Yes, sir.
All right, let's swing it over to the defense.
Nothing, Your Honor. I guess I'm curious, are we gonna do the charge conference now, or are we gonna do it tomorrow?
I mean, at this point, I think just the way it shakes out is that we'll just give them a longer lunch break and try to set aside, you know, give them 2 hours for lunch. And I mean, we could do it. We could kind of preview a few issues here just to maybe streamline some things.
It's your discretion. I'm just curious.
But I would, I mean, there were a couple non-pattern charges, so I feel like we could do it in an hour, but I don't know.
I think we could, Your Honor. The only thing I would prefer to do it tomorrow, be our guests and over some updated changes to their
Right, there's still
suggestions
some
around 4
supplementals.
o'clock today. We're working on the spoliation instructions. I think there's a few things we can maybe button up tonight and give me a chance to review in an effort to make it about an hour charge conference.
I understand. Well, that's gonna be the plan then. Let me just flip through and flag a few things so that y'all can talk about it and consider it unless you already have a position on it. Again, they will have a written copy of the charge, so I just flag that for you. One thing I generally try to do is, because they are gonna get a written copy, usually they start tuning out. So I try not to just read on incessantly. And one of the ones for stipulations is I would propose, rather than have me read all the stipulations, y'all just copy and paste those into a written exhibit, which we'll then tender and we'll be back with them. And I'll just say, you can look at the exhibit that's submitted and you can read the stipulations. So.
Your Honor, do you allow a written copy of the final instructions to go back with the jury?
Yes.
Okay, so then if the stipulations is in one.
They are, well, the thing is that what I'm
trying to
sending
skip
back
over.
is what I read word for word.
Okay.
All right, and so what I would put in there is, you know, about the following, or that you could say something to the effect of the stipulations are summarized in Exhibit X, which you will have a copy of in your stipulations. So then I don't have to read 2 pages of stipulations. So that's one thing to note for you. I want to go, and I also want to revisit, maybe y'all have already come to a decision on this, but on the verdict form, would y'all converse on potential legal theories here about whether the jury could come back and say, both of you lose, both of you win, or, basically is it really an alternative? If one, then not two. Any feelings on that? Mr. Holmes, did you look at that at all, or feel free to pass?
I'll ask my team to correct me if I have this wrong. This is not something I think the short answer is yes, it's possible to have both parties breach, both case law and case. We have asked one of the jury instruction on a related point, one of the jury instructions we're asking for is that there cannot be a breach if there's not performance by a party. And so, so the answer to the question is yes, but it's caveated, I think, if there's not performance by a party.
Just to clarify, I think what he's referring to is if there's material breach that excuses the other party. So we try to add.
To reflect that.
Right.
All right, I suspected that would be a wrinkle to flush out here, and so it takes interesting to add. Feel free, Mr. McCleary, but it sounds like y'all are working on it.
We're working on it. I don't disagree with what Don just said in terms of materiality, and I think it comes down, Your Honor, to how the verdict form is written. I think we had proposed a finding as to whether the Conservancy breached by failing to provide a good and tenantable foundation.
Yeah.
And I think the proposal from the other side was just, did the Conservancy breach? And there, in that world, I think I don't know if we want to get into the whole law of what's material and first party breach. Our proposal is going to be, and it looks like the court was inclined to adopt plaintiff's proposal in terms of, just more broadly.
Yeah, just kind of a catch-all. I mean, and that's also, I'll just note kind of the preference on charges too. I mean, I think that it's helpful in some respects, when you've gotten your non-patent request, like here's exactly our claim of how they breached. Look at section, 3.2 of the leasing agreement. That generally, I've not gone to that level of granular detail. And just a breach is when you break an agreement, leave it at that. And if y'all can't enlighten them in closings of exactly what that point is, then we have bigger issues. But
I guess Your Honor, what I'm saying though is that I agree with what Mr. Halsey said in terms of if we just leave it wide open. I think it is possible that but one party breached, but the other party also breached. I think it's theoretically possible. I don't think under the facts of this case, correct me if I'm wrong, either the Conservancy breached by failing to provide the proper base building condition, or be our guest breached by failing to finish and start paying rent.
And if that's the case, and that's by agreement, then I'll structure it that way, and we can do that, and we can make that explicit. So, and that's fine. I just want to make sure that that's a knowing decision, right?
Sure.
And so we can take that up as it comes.
I think we can do it.
Yeah. All right, all the other things, I mean, there's just very little things that we'll just cover during the charge conference, I suppose. And so I think we'll just send our very most recent one that incorporated. We've got one supplemental that we put in, and we'll send that back to y'all so you have a working copy, and then we'll just go off whatever final one you get back to me tomorrow morning, that'll be the one we do for our charge conference. All right, not hearing anything else then, we'll be in recess until 9 o'clock tomorrow morning. Thank you.
Thank you.